report them after the
petitioners, my lords. Yes, appearing with me are my brothers of the inner bar, starting with our Kalo SAN, Tinubu SAN, Dr. Mrs. Valeria Janet Azinge SAN, Beko Okoko SAN, Alex Ejesiem SAN, Peter Afoba SAN, and then members of the outer bar with us, 3 of them, starting with number 8, Chike A. Obi, Precious Uchendo, and finally, Igwekamba Ubiora. Together, we appear for the petitioners, my lords.
didn't appear with the iron eater today. The iron eater crusher.
He couldn't be accommodated today.
Yes, first respondent.
If it pleases my lords, I am Sir Stephen Adedi. I appear with my learned friends of the inner bar, T.M. Inwa, SAN, Al-Hassan A. Umar, SAN, Suleiman Olawale Ibrahim, SAN, and our friends of the outer bar appearing with us are Nasara H. Auta, Esquire, Aminu Sadauki, Esquire, N.A. Atta, Esquire, Susan A. Imrozi, Esquire, Jamiu Aguru, Esquire, and Martins F. Epa. We all appear for the first respondent. Thank you very much, my lords.
Second and third respondent.
With profound humility to my noble lords, my name is A.A. Malik. My humble appearance is for the second and third respondents. And my learned brothers of the inner bar, appearing with me are Babatunde Ogala, SAN, Dr. Remy Olachubura, SAN, and Mutalubi Ojo Adebayo, SAN. And we also have our colleagues on the outer bar, namely my lord, Emmanuel Uwadoka, Esquire, Yinka Ajeni Fuja, Esquire, Akintola Makinde, Esquire, Julius Ishola, Esquire, and last but not the least, Taiwo Lakano, Esquire. Recommended.
Yes.
Good morning, my lords. I am Chief Dr. Charles Uwensi Edosawa. I make humble appearance for the fourth respondent. With me, sirs, Chief Adeni Akintola, SAN, Chief Afolabi Fashano, SAN, Sam Ologun Risha, SAN, Solomon Moore, SAN, Abdul Muhammad Rafundadi, SAN. Lords, our learned friends of the altar bar are also here with us. And they're Omosaya Kupola, Esquire, Olaniwaju Onigegewura Akinshola, Esquire, Kolaji Oyun, Esquire, is Waila Muhammad Ibrahim,
Thank you very much. We're all here for the first respondent.
Petition number CA/PEPC/04/2023 between Allied People's Movement petitioner and Independent National Electoral Commission, All Progressives Congress, Tinubu Bola Ahmed, Kashim Shettima, Kabir Masari.
Please, my lords, Mrs. May Abamuche Umbu, INEC National Commissioner, Chair Legal Services, for the first respondent.
Petitioner is absent.
Petitioner is absent, my lord. First respondent is represented, my lord.
Hello, my name is Dr. Abdullah Umar Ganuye, National Chairman, APC, for the first respondent.
My lords, my name is Kashim Shettima. I am the third respondent. My lords, I am the fourth respondent. My name is Kashim Shettima.
My lords, the second respondent is represented, the third respondent is absent, the fourth respondent is present in court, and the fifth respondent is absent.
This is the network service of the Nigerian Television Authority. You're watching the special coverage of the sitting of the Presidential Election Petition Court here in Abuja, the nation's capital. Today, Wednesday, the 6th of September 2023, the Election Petition Court will deliver its judgment in the consolidated petitions arising from the conduct of the presidential election on the 25th of February 2023. Earlier, you saw visuals from the sitting in the court where we have two of our correspondents, Dele Atumbi, who is the head of our legal desk, as well as Ayebe. We'll be joining them, of course, in the course of this special coverage of the sitting of the Presidential Election Petition Court. Also here with us in the studios from where we are having our special coverage, we have two guests. First, let me say I am Kingsley Osadolo, and I warmly welcome you to the special coverage because it is Judgment Day today in the election petitions filed with regard to the presidential polls that took place earlier this year. So in the course of the coverage, we'll be having interaction with two of our guests and others who will join us. But first, let me warmly welcome Professor Edoba Omorige, learned senior advocate of Nigeria. Professor Edoba Omorige is a professor of comparative constitutional law and legislative governance at the University of Benin, currently on secondment at the Institute of Legislative Studies here in Abuja. Professor Omorige, we're glad to have you.
Thank you so much for having me.
We also have with us in the studios for this special coverage and conversation Ezenwa Nwagu is a very well-known face, a veteran election observer and activist. Mr. Ezenwa Nwagu, we're glad that you've joined us.
Thank you very much.
All right. Amongst the visuals you saw out of the sitting of the court were the preliminaries before the justices launch into the business of the day proper. So you're having introductions of the petitioners and the respondents. And I'm sure if you listened in, you heard the various persons introducing themselves. The petition, of course, is filed. That is to say, like the equivalent of a complainant, and then those who are the equivalent of the defendants, of course, in this matter, they are referred to as respondents. And thereafter, the proceedings will commence. But before we return to the court, and our correspondents, let's quickly engage our two guests here in the studios, Professor Edoba Omorige and Ezenwa Nwagu. Beginning with Professor Omorige. How significant is today?
Well, of course, we're all expectant. I'm sure virtually every Nigerian is glued to the television now. And hoping one way or the other to hear what the outcome is, But what is good is that we have all been very law-abiding, and in election held, like you said, on the 25th of February, and the challenge has been on over the past 2-3 months or 4. A lot of comments here and there, but everyone has conducted himself, herself in a very peaceful manner. I think that is quite commendable. It further underscores the fact that our democracy is consolidating. So far, it's so good. So we'll wait for the outcome.
How significant is today?
Well, thank you. I think we're coming to a closure, or a near closure, to the electoral cycle for this 2023 election. And judicial oversight is part of that, and quite a lot of people don't always, underscore that point, that the way our laws have been framed is that after the whole process of elections, that the judiciary would take a look as to whether there were what Prof. They would call substantial compliance with the electoral laws, the constitution, and the guidelines for that election. And we're coming to that point, and it's exciting because the truth of the matter is that our country is in a place where it can beat its chest and say we have been able to run transitions, and those transitions with term limits that are very clear, with judicial responsibility and all that. And that for me is what today signifies, that we can tell the world that our democracy is coming full circle.
All right. Thank you very much. Again, we're still seeing visuals coming from the courtroom. I believe these are still part of the introductions that are ongoing before the launching. Our correspondents will advise us accordingly. But just to remind our viewers that 18 political parties participated in the presidential election on the 25th of February. 18 political parties participated. And after the polls results were announced, a winner declared and returned elected as President Commander-in-Chief of the Federal Republic. But 5 political parties and their candidates were dissatisfied with the outcome of the elections, as announced by the Independent National Electoral Commission. They therefore filed their petitions, but eventually 2 of the petitioners withdrew their petitions. So we're left with 3 petitions before the Presidential Election Petition Court. Now, those petitions were those by the Allied People's Movement, People's Democratic Party, and Atiku Abubakar, who was a candidate of the party, Labour Party, and Peter Obi, who was also the candidate of the party. So 3 petitions were now before the Presidential Election Petition Court. Those petitions, according to the provisions in the schedule to the Electoral Act, have now been consolidated into one so that all the issues are taken together and a decision arrived at. Professor Edoba Omoroge, I want to return to you. Okay. Yes, you say this process of this nature, and everyone also affirms that it helps to consolidate our democracy. But in some quarters, there are concerns that virtually all presidential elections in Nigeria, with the exception of the 2015 presidential elections, have been the subject of litigation after a winner was declared, announced, and then returned elected. Is this helpful or hurtful to our democracy?
Well, for me, it's not a surprise at all. We are a growing democracy, and we are still trying to, get our acts together in many respects. In terms of, actually conducting an election that, ticks all the boxes in terms of fairness, credibility, and so on. We still have challenges here and there, of course. And then there's also the challenge of lacking the competitive spirit, which is to accept defeat when you have been defeated. So, so it's a two-way challenge. And many other countries, that have had the democratic system in place over the years, far many years than us, they continue to face similar challenges. Even the US, for instance, has had democracy in place since 1776, so to say. You notice that, you still have the concerns over, who won or who didn't win. You thought that it was never going to happen. But look at, just 3 or 4 years ago, with Trump, continuing to challenge, even now, the outcome of the 2020 presidential election. Before then, you had Gore and Bush. Also, they had to go to court. And even as far back as 1960, the challenge between Nixon and Kennedy. Nixon was very dissatisfied. He almost went to court, but for some reason he had to step aside. So it's not something that is so terrible as people want to conjure it. Of course, the ideal thing would be to avoid judicialization, of elections and so on, so that you leave it at the doorstep of the people to decide, and that's all. But the human spirit is something that you cannot fully predict. So, but it's part of the democratic process. That at least at the end of the day, matters will be resolved on the basis of, clearly defined and determined processes and procedure. So nobody should feel, in any way concerned more than we should be. Thank God at least we have processes for resolving conflict. That's what's important. We're following and marshalling through that process. And today, as you can see, it's just one of the hurdles. Ultimately, perhaps if whoever loses now dissatisfied, they have to also end up, the higher level, which is at the Supreme Court. So it's part of the democratic process. And that is why democracy remains a better system, because of its capacity to accommodate conflict in a very peaceful way.
All right, thank you very much, Senior Advocate. Again, I'll pop the same question to you, namely, is recourse to litigation and ultimately judicial review helping or hurting our democracy?
My quick sense would be what would be the option. Election is a competitive enterprise, and is like football. You need to, even when you are dissatisfied, there are processes you can go for arbitration and all of those things. I think that what we need to do is to, I've made the argument in some other place that the certainty of a process does not guarantee a certain outcome. And so what we need to do is to consolidate so that our electoral processes are certain, but the outcomes we don't have a control over. And then the way people respond to that outcome is also depends on their own perception and understanding of how, first and foremost, the electoral management body acts, and even their understanding of the mandate of the electoral management body, other stakeholders in the electoral process. And all of those things play in determining whether, but I agree with Prof, we're a litigious category. We virtually go to court on every matter. I used to have a friend who said if it's 3 months he has not gone to court, it doesn't feel good. So we are that way, but it's the better option, because the kind of thing that we saw in 2020 in the US is something that even the American people are ashamed of up till now. It's not something we want to carry on, where people want to take the laws into their hands. We have a system that is robust. It may not be what we want it to be, but in testing it over a period of time, we get to that point where we can have something to show the world. And at other lesser elections, we have seen episodic interventions of the judiciary, either way, that showed that when you do the wrong thing, they can wield the big stick, and if you do the right thing, they can also congratulate you. Right? And I think that's where we need to go.
Professor Omorige, used a word which is, of course, very common in election jurisprudence. They said the judicialization of politics, for instance. There are concerns in some quarters that more and more, with the exception, for instance, of the presidential election over which we're having this dispute and then the judgment that will be delivered today, council elections, State House of Assembly elections, National Assembly elections, governorship elections, and then, of course, the presidential election, that power appears ultimately, you talked about outcomes, but that power appears ultimately to reside in the courts and less in the electorate. Should this be concerning?
But I think we need to engage the statistics and see, because when you say judicialization, you start from the process, because election is not an event, it's a process. The candidate selection process throws up a lot of issues that are in court, and people lump all of those together. They are the ones that have to do with the conduct of election. We need to separate them and then look at the data. The data does not speak. The data speaks to the fact that there is even a reduction in terms of the number of people going to court for the conduct of the election. There is more on the candidate selection process, and that distinction is not being made. So because the work is big and the frame is also wide in a way that we are not able to, stake out these issues. You have a presidential election in which 18 political parties participated, and from your opener, 3 are remaining in court. I mean, that's not a very terrible thing in terms of number now. But for me, I go back to it again. If we don't judicialize, we are left with option AK-47 or demonstrations, and we can't go that way. We need to stay in the process in which the drafters of our laws have said, when you have a challenge, if you feel dissatisfied, if people who win election don't go to court. So it is those who are dissatisfied that go, and the place to go to is the court to say, I am angry, I don't like the way these things have been done. And then the fact that you are the one that took it there does not necessarily mean that you are right. So the court will look at the laws, because election is a law-guided process. It is not anything. It is law. And then the law will be placed side by side the conduct of all the different stakeholders who have been part of this election, and see whether they complied with the law. if they did not comply with the law, the judiciary will say, look, you did not do what you are supposed to do. And if they did, they will say you did. The challenge is that the trust deficit for us is something that we need to begin to interrogate in terms of whether we even believe that public institutions have the capacity to do what the Constitution says. And that has something to do with attitudes. You know, if you, no matter what you do, it's like the cigarette pack where you have written smokers are liable to die young. It doesn't stop people from smoking. So no matter what you do in terms of, you know, education, in terms of saying, look, you can show examples of where the judiciary has been upright and where they have there has been some kind of derivation. But all the same, that's the only place for me that we can.
Okay, thank you very much, Ezenwa. Let's take a look at this. Is it necessarily the case that Ezenwa has made a fine distinction between litigation arising from pre-election matters and then litigation arising from the conduct of elections? Clear a distinction almost without a difference, because pre-election disputes relate, many would argue, to eligibility for you to participate in what is then conducted, and that this should therefore speak to all stakeholders or all participants in the electoral process value chain. What do you think?
I think the distinction is a very significant one, and it should not be taken for granted at all. Yeah, of course, there is a heightened sense of litigation, not just even the fact of it. The people seem to be now more inclined to jump into court pre-election over internal disputes in their political parties, and so that gives that sense of judicialization. You know, I've had to argue severally that perhaps we made a mistake of trying to, you know, put even more, provide more opportunity for, you know, members of the political party to approach the courts over issues of internal democracy, selection process, and so forth. Maybe that was a mistake because at the end of the day, political parties, no matter how you try to pretend about it, they are private organizations, only recognized to seek power. And so why should the courts be so concerned about who emerges, you know, as candidates for political party? It's a big debate, but by and large.
Prof, and as we are getting signals that we have to return to the courtroom of the Presidential Election Petition Court, where judgment has been delivered in the consolidated petitions against the outcome of the February 25th elections.
Compliance with the provisions of the Constitution of the Federal Republic of Nigeria 1999 and the Electoral Act 2022. A declaration that having regard to the joint ticket principle enshrined in Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999, the withdrawal of the first respondent as the vice presidential candidate of the second respondent by operation of law amounted to automatic withdrawal and invalidation of the candidature of the third respondent as the presidential candidate of the second respondent for the presidential election conducted by the first respondent on the 26th day of February 2023. A declaration that arises from the invalidity of the third respondent nomination, the first respondent ought not to have included the name or the abbreviation of the name or the logo of the second respondent in the ballot papers and other election materials used by the first respondent for the conduct of presidential election held on 26th day of February 2023. The fourth respondent was not qualified to contest as the vice presidential candidate of the second respondent as at 26th February 2023 when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. An order nullifying and voiding all the votes scored by the third respondent in the presidential election conducted by the first respondent on 26 February 2023 in view of his non-qualification as a candidate of the second respondent. Upon the ground of prayer for above, an order nullifying and or setting aside the term of declaration of third respondent as winner of the election conducted by the first respondent for the office of the President of the Federal Republic of Nigeria on the 26th day of February 2023, same having been made in violation of the provisions of Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999 and Section 35 of the Electoral Act 2022. Finally, upon the ground of prayers 5 and 6 above, and in the absence of the third respondent's participation in the presidential election held on 26 February 2023, pursuant to Section 136 of 2 of the Electoral Act, an order declaring the candidate with the next highest number of votes as the winner of the election. The grounds of the petition as set out in paragraph 15 of the petition is as follows. Your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The respondents were duly served the petition and also responded by filing their replies. The first respondent reply to the petition was filed on 9th of April 2023. The second respondent reply to the petition was also filed on 9th of April 2023, while that of the third and fourth respondents was filed on 13th of April 2023. The fifth respondent also filed replies to the petition on the 16th of April 2023. The petitioner then filed replies to the respective replies of the respondents to the petition. The respondent filed a number of motions, all of which challenge the contents of the petition. These motions were duly heard during the hearing session and ruling reserved. The first motion was filed by the first respondent. Applicant here in this motion was filed on the 6th of May, wherein it sought the following reliefs. 1. An order striking out paragraphs 2, 3, 4, 5, 6, 7, 13, 14, and 16 of the petition reply filed on 20th day of April 2023 in response to the first respondent's reply. 2. An order striking out paragraphs 8, 9, 10, 11, and 12 of the petition reply filed on the 20th of April 2023 in response to the first respondent's reply. And for such further orders as the Honorable Tribunal shall be fit to make in the circumstance. We were asked to note that the grounds for the petition or for the application are as follows, and if not read them out. So the motion is supported by an affidavit of 4 paragraphs and a written address. The petitioner respondent then responded by filing counter affidavit of 7 paragraphs on 13th of May 2023. Same was accompanied by written address in the opposition to the application. The arguments of counsel in respect of that application have been considered here in the ruling. A similar application was also filed by the second respondent on the 8th of May 2023, wherein the second respondent pressed this court to grant the following reliefs. 1. An order of the Honorable Tribunal granting leave to the second respondent applicant to file and argue this application before or outside the hearing session in this petition. It will be noted that this court is sitting as the Court of Appeal, not as a tribunal. So, an order of this Honorable Court striking out paragraphs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 17 sub 1, 2, 4, and 5, paragraph 18, 19, 20, 21, 22, 23, and 24 of Part B of the petitioner's reply and for the entire petition reply to the second respondent's reply to the petition for being an unnecessary repetition and or introduction of new facts unrelated to the second respondent's reply to the petition. 3. An order of the Honorable Court striking out in whole or part thereof of the witness statement on oath filed together with the petition reply to the petition for being irregular and in flagrant non-compliance with the relevant provisions of the first schedule to the Electoral Act 2023. So the grounds for that application have also been summarized in this judgment is same thing with the submission for counsel. The third and fourth respondents also filed a motion on the 10th of May 2023, seeking the following reliefs. 1. An order striking out the entire reply filed by the petitioner on 20th April 2023, together with the accompanying witness statements on oath, list of witnesses to be relied on, and the list of additional documents. 2. Further, or in the alternative to prayer 1 above, an order striking out paragraphs 1, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, up to 21, all the petition reply under the heading petition reply to the third respondent reply to the motion filed on 20th April 2023 to the applicant reply to the petition. And for such further orders as this honorable court may deem fit to make in the circumstances. The grounds have also been referred to this ruling. We have also considered the submissions of counsel. Now, it is apparent that the first respondent's motion filed on the 6th of May 2023, the second respondent motion filed on the 8th of April 2023, and the third and fourth respondent motion filed on 13th May 2023 are all aimed at having certain paragraphs of the petition replies to the respective replies of the respondent's replies to the petition startup. The common ground in all the applications is that the averments in the petitioner's reply have introduced new facts, new issues, facts, and or grounds to the petition. Furthermore, that some of the averments are rehashed or repetition of the averments in the petition file. That those averments in the petition reply to paragraph 16, subparagraph 1A and B of the first schedule to the Electoral Act 2022. The said paragraph to the Electoral Act stipulates that, I quote, if a person in his reply to the election petition raises new issues or facts in defense of his case, if the petition has not dealt with, the petition shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, a petitioner reply in answer to the new issues or facts, so that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him, and B, the petitioner reply does not run counter to the provisions of paragraph 14.1. In my view, the provisions of paragraph 16.1 of the first schedule to the Electoral Act 2022 are clear, unequivocal, and unambiguous. It does not, therefore, require any technical rule of interpretation to understand or to be understood. From a holistic reading of that provision, it will be seen that it is meant to explain the purpose of a petitioner's reply to the respondent's reply. His purpose is to raise answers to the defense or any fact which must be specifically pleaded and which has the effect of destroying the respondent's defense or make it not maintainable. The bottom line is that a petitioner is permitted by the first schedule to the Electoral Act 2022 to file the reply while the respondent to the petition has in his reply raised new issues of fact in the defense, which fact the petitioner has not dealt with in the petition. However, in doing so, the petitioner reply shall not introduce new facts, grounds, or prayers tending to amend or add to the contents of the petition. I've cited the case of APC and PDP citations of life. It is therefore clear that paragraph 16.1 of the first schedule to the Electoral Act does not permit a petitioner in his reply to introduce or bring in any new issue or fact which ought to have been raised in the petition itself. In other words, a petitioner cannot, in the guise of a reply to a respondent's reply, introduce a new issue or fact which was never raised in his petition nor raised by the respondent. To do that will amount to amending or adding to the petition and also taking the respondent by surprise, because at that stage the respondent will not be in a position to react to that new issue or fact. It will therefore breach the respondent's fundamental right to fair hearing. Therefore, the petitioner is not permitted to repair or rehash his averments in the petition in such a way that it will amount to an amendment or restructuring or a reconstruction of the petition. See the case of Dingedi and Wamako citations of supply. With the state of the law as stated above, At the back of my mind, I have endeavored to scrutinize the pleadings in the respondent's respective replies to the petition. Vis-a-vis the specific paragraph of the petition replies complaint of. I start with the first respondent's complaint. The first respondent's complaint is against paragraph 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 16 of the petition reply. I have carefully studied those paragraphs of the petition reply. It is my view that paragraphs 1, 6, 7, 8, 12, and 14 of the reply to the first respondent reply are competent as they are proper replies to the first respondent's reply. However, paragraphs 2, 3, 4, 5, 9, 10, 11, 13, and 15 of the said petitioner reply are not competent as they are either rehashed or facts pleaded in the petition or they introduce and or add new facts to the petition. Being incompetent, they are hereby struck out. The complaint of the second respondent is against paragraph 1, 2, 3, 4, 5, 6, 7, 9, 10, 11, 12, 13, 14, 15, 16, 17, sub 1, 2, 3, and 4. 4 and 5, sorry, 18, 19, 20, 21, 23, 24, and 25, part B of the petition reply to the second respondent's reply to the petition. I have carefully considered those paragraphs in the light of paragraph 16, 1A and B of the first schedule of the Electoral Act 2022. It is certain law that where a respondent raises in his reply to the petition phrase or new issues, it will be necessary for the petitioner to file a reply to the respondent's reply to the petition. At that stage, the petitioner may also file further written statements on oath of witnesses. He may wish to call in rebuttal of the new issues raised by the respondent. This is because any failure by the petitioner to reply or answer those new issues raised by the respondent will be deemed that the petitioner has considered to such raise of new issues. The cases of Kitris and India Wamako were also cited. That being so, the written statements on oath of witnesses filed along with the petition reply to the respondent's reply and proof of paragraphs that are accordingly struck out. In my view, paragraphs 1, 2, the paragraph listed in the petition reply to second respondent's reply to the petition are either rehashed or paragraphs in the petition or introduced or added new facts to the petition. They are incompetent and accordingly struck out. I am also of the view that paragraphs 1, 3, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 to 20 of the petition reply to third and fourth reply to petition the height of the environment in the petition. They are in my view incompetent and accordingly struck out. This other motion filed by the first respondent on the 7th of May 2023 taking the following relief. 1. An order of this honorable court striking out the petition for being incompetent and an abuse of court process. The grounds of filing the motion have been produced. The motion is supported by 6 paragraphs of affidavit deposed to by 1 Chief Nwakite, the litigation secretary in the law firm of Atiku and Mahmoud, solicitors to the first respondent applicant. It is also accompanied by a written address filed in support of the motion. In response, the petitioner filed a counter affidavit on the 14th of May 2023 consisting of seven paragraphs posted by 1 Carlo Kenneth Okorie, together secretary of the law firm of Mrs. O.M. Atoyo BSN and partners. The written address was also filed along with the counter affidavit. I have considered the arguments of counsel on this motion. The third and fourth respondents also filed a similar motion on 12th of May 2023. Therein, the third and fourth respondents prayed for an order of this honorable court striking out and or dismissing this petition for being incompetent, fundamentally defective, and justing no jurisdiction on this honorable court to adjudicate thereon. The grounds for the petition have been listed. motion, several grounds were raised. That the sole ground of this petition is stemmed from the qualification of the respondent. The issue of qualification or disqualification of the candidate to contest an election for the office of President of Nigeria is a constitutional one. That is why it is stipulated in section 134 subsection 1 of the Electoral Act 2022 that an election may be questioned on any of the following grounds. A person whose election is questioned was, at the time of the election, not qualified to contest the election. The qualifications and or disqualifications of the candidate to contest an election for the office of president are stipulated in section 131 and 137 of the Constitution of the Federal Republic of Nigeria as amended. While the qualifications are inserted in section 131, the disqualifications are ingrained in section 137 subsection 1A(j) of the Constitution. It is apparent, therefore, that the issue of qualification of the candidate to contest an election could be a ground in an election petition, though it may also be ground to pre-election matter, where such issue of qualification or disqualification of candidate arises from the primary election of the party by virtue of section 285 of section 14 of the Constitution. Where the issue of qualification or disqualification arises from before the election, it is an election, a pre-election matter, and an action on that issue must be restricted pursuant to section 285 of section 11 and 14 of the Constitution. You should note that upon a quick and careful perusal of the pleadings and in the petition, the issue of disqualification of the first respondent rests solely on the issue of the alleged invalid nomination for his running mate with the third respondent. The issue of invalid nomination is captured by paragraphs 18, 19, 20, and 21 of the petition. For proper understanding of the facts pleaded, those paragraphs are to be produced. The second issue, arm of that issue is captured in paragraph 22, 23, 24, and 25, as premises of the petition. Considering the facts pleaded above, it is clear that the claim of disqualification or non-qualification non-qualification without respondent is centered solely on the invalid or double nomination of the fourth respondent. However, it is the certain law that the issue of nomination of a candidate at an election is a pre-election matter. Therefore, the issue of qualification or disqualification can only be ventilated on the grounds enumerated in section 131 or 137 of the Constitution. That is why section 84 subsection 3 of the Electoral Act 2022 stipulates that a political party shall not impose nomination qualification or disqualification criteria, measures, or conditions on any aspirant or candidate for any election in its constitution, guidelines, or rules for nomination of candidates for election, except as prescribed under section 65, 66, 106, 107, 131, 137, 177, and 185 of the Constitution. 187. It therefore means that The conditions of qualification or disqualification are prescribed by, under Section 131 and 137 in case of person contesting for office of president. That means that why it is alleged in an election petition that a person is or was not qualified to contest election to the office of President of Nigeria, as stipulated in Section 134, subsection 1A of the Electoral Act 2020. It is Sections 131 and 137 of the Constitution of Nigeria that are applicable. See the cases of PDP and ANIC, Kaki and PDP, Ucha and Unwe, and Captain Idris, Chalawada and others, Yahya Bello and others, all citations of right. That's why election has been conducted and result declared. Such election cannot be questioned on grounds of qualification under Section 131 and 137 of the Constitution in the case of a presidential election. This postulation is supported by Section 134, subsection 3 of the Electoral Act, where it is stipulated that with respect to subsection 1A, a person is deemed to be qualified for an elective office, and his election shall not be questioned on grounds of qualification if, with respect to the particular election in question, he meets the applicable requirements of Section 65, 106, 137, or 177 of the Constitution, and he is not, as may be applicable in brief of Section 66, 107, 137, or 182 of the Constitution. As stated earlier, the applicable provisions are Section 131 and 137 of the Constitution. It is clear from the plenitude of the pleadings in this petition that the facts grounding the petition's claim of disqualification or non-qualification of the third and fourth respondent is seen from double and invalid nomination of the first respondent. I had pointed out earlier in the course of this ruling that the issue of qualification or disqualification of a candidate at an election is strictly the requirement of the Constitution. That it was held in the case of Al-Hassan and another versus Ishaku and others, citations supplied a court by virtue of the provisions of Section 138 of 1A of the Electoral Act. The tribunal's power to decide whether a person is qualified to contest an election is restricted to establishing the requirements of Section 177 and 182 of the Constitution against the adverse party. An election tribunal has no jurisdiction to inquire into the primaries of a political party, close of court. It is apparent, therefore, that issues of nomination or sponsorship of candidates by political parties come under pre-election matters and should be disputed and determined before the conduct of the election. Shinkasi and others versus Yari, others, Ella and others versus Abu. That being so, a ground of election petition questioning the election of a person duly qualified to contest such election as required by the Constitution cannot be sustained, while it is predicated on nomination or sponsorship of such candidate. Therefore, a petitioner who relies on the non-qualification of his opponent to nullify the election must bring the facts of such non-qualification within the ambit of Section 131 and 137 of the 1999 Constitution. I have noted that the petitioner respondent sought to tie his complaint of non-qualification to Section 142(1) of the 1999 Constitution. That provision stipulates as follows. In any election to which the foregoing provision of this part of this chapter relates, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate for election to the office of president who nominated him as such associate is duly elected as president in accordance with the provisions of aforesaid. I am of the view that the above cited provision of the Constitution does not create additional qualification or disqualification for a candidate contesting for the office of president of Nigeria. Furthermore, Section 142 of the 1999 Constitution, read along with Section 141 of the said Constitution, create the office of President and Vice President. Section 142(1) is a specific provision donating power to the President to nominate a person as his associate to occupy the office of the President. That's why subsection 2 or section 142 mandates that the requirements of qualification and disqualification attaching to the occupier of seat of president also applies to the holder of the office of vice president. It is therefore my view that section 142, subsection 1 of the Constitution does not introduce the issue of nomination or sponsorship of vice president so as to enlarge the scope of qualification or disqualification applicable to the seat of president. Therefore, there cannot therefore be a disqualifying factor of a candidate for the office of president outside those specified in section 131 and 137 of the Constitution. It can safely be said that those provisions have sufficiently and conclusively covered the field until there is an amendment to the Constitution. In the cases of IG, ADIA, and AD Federation, also PDP and ANIC. As a follow-up to my findings above, I hold the firm view that the issue of nomination of sponsor of correspondence being a election matter ought to have been ventilated by the petitioner before the Federal High Court, as this court has no jurisdiction to deal with the matter. Even if this court has such jurisdiction, because of action being an election matter, is that by virtue of section 285 of 9 of the Constitution of the Federal Republic of Nigeria 1999 was amended. Having found as above, it is my view that the two motions filed by the first respondent and third and fourth respondent on 7 May 2023 and 12 May 2023 respectively have no merit. Accordingly, I find that the petition is possibly have merit. Accordingly, I find that the petition is liable to be struck out for being incompetent. A motion on notice filed on the 8th of May 2023, the second respondent, the applicant, sought the following relief. An order of this Honorable Tribunal granting leave to the second respondent applicant to bring and argue this application before, from outside or during the pre-hearing session. 2. An order of this Honorable Tribunal striking up grounds 1 and 2 contained in paragraph 16 of the petition for being incompetent. 3. An order of the Honorable Tribunal striking out paragraph 17, 18, 19, 20 to 29 of the petition, which are predicated on the incompetent grounds 1 and 2 in paragraph 16 of the petition for being an abuse of court process. And order 4. An order of this tribunal striking out release 1 to 7 of the petition for being incongruous, illogical, and ungrantable. And 5, an order of the Honorable Tribunal dismissing or otherwise striking out the petition for one of the petition and on the ground that the petition does not disclose any reasonable cause of action. The grounds stated here in arguments of counsel which I have summarized in the ruling, it will be seen that this application is premised on several grounds. The first is that the grounds of the petition are incompetent. This is premised on the erroneous argument of the second respondent of applicant that the grounds for the petition are as stated in paragraphs 16 of the petition. The careful revision of the petition will disclose that there is only one ground for the petition and is stated in paragraph 15 of the petition as follows: that your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The amendments in paragraph 16 as unequivocal caption deal with the facts of the petition. This ground for the objection to the competence of this petition therefore lacks substance and accordingly discountenance. The second ground for the objection is that the petition is an abuse of court process. It is premised on the fact that the petitioner's respondent had earlier instituted an action before the Federal High Court in suit number FHC/ABJ/CS for 1215/2022 between Allah People's Movement and INEC and 12 others on the same subject matter, as in this petition, against the first, second, third, and fourth respondents in this petition and others. It was however deposed in paragraph 3M of the counter affidavit filed by the petitioner in opposition to this application that the matter was not determined on the merits by the trial court, who referred the matter to the Court of Appeal for interpretation. That in any case, the matter had since lapsed in 180 days for determination by law being a pre-election matter. It is tried law that abuse of court or judicial process simply means the use of the court process malafide or in bad faith with the annoyance of the opponent. One variety of it is the institution of multifarious actions between the same parties with regard to the same subject matter and same issue in the same or another court. A quick look at summons in suit number FFC ABDCS 1275-2022 will show that same was repeated in the Federal High Court, Abuja, on 27th day of July 2022. Being a pre-election matter, what to have been determined within 180 days, as required by Section 285, Section 10 of the 1999 Constitution. It therefore means that it lapsed by January 2023, about a month the election in question was conducted. This petition having been instituted on the 20th of March 2023, when suit number FFC was no more alive, does not qualify as an abuse of court process. This ground for this objection is also from Kenan. On whether this petition is called by the doctrine of Estoppel, it was argued that the issues raised in this petition have been firmly resolved by the Court of Appeal in Appeal number CS of ABJs of CS of 08 of 2022. Issue Estoppel arises when the issue has been decided upon finality by a court of competent jurisdiction. In other words, once an issue has been raised and distinctly determined between the parties, another party can be allowed to fight that issue all over again. The same issue cannot be raised by other parties again in the same or subsequent proceedings except in special circumstances. For issue Estoppel to apply, the following conditions must be satisfied. A, the question must have decided, the same question must have been decided in court proceedings. B, the decision which creates the Estoppel must be final, and the parties to the judicial decision or their previous to the proceedings in which the Estoppel is raised must be the same. To determine whether the above three elements exist, the court will closely examine the reasons for the judgment and other relevant facts that were actually issued in the proceeding. See the cases of Oyekola and others of Amudu, OSPM Limited versus Nitel Company Nigeria Limited, and Dasuki Retired versus Federal Power Nigeria Station Supply. I have started the case thought to be relied on as Estoppel in this case. It is apparent that the parties in that case are not the same as in the instant petition. The issues, though the same, were not resolved to finality in the previous case. The action was struck out on ground of lack of local standard by the lower court, which this court affirmed on appeal. Thus, the objection on that ground is also discontinued. On whether the question is tackled back, I had held in the earlier motion filed by the first respondent on 7th May 2023 and third further respondent's motion filed on 12th May 2023, which were taken together. This petition, which is premised on the nomination responsibility of the fourth respondent, is a pre-election matter. That being a pre-election matter, the court will have been imputed and ventilated by the petitioner before the Federal High Court within 14 days from the date of occurrence of the event or action complained of. That not having been done, the course of action in this petition stands barred by virtue of Section 2859 of the 1992 Constitution of the Federal Power of Nigeria as amended. On the issue of local standing, I have also held in the previous motions filed on 7/5/23 and 12/5/23 that issues of nomination or sponsorship of candidates by political parties for an election come under pre-election matters. It is certain that the issue of nomination of candidates by substitution is purely a pre-election matter. The only person with the local standing to challenge the nomination is an aspirant who participated in the process of such nomination. In other words, apart from an aspirant who took part in the primary election, no other person is authorized to challenge such nomination by a political party to an election. Such process of challenging the nomination is sanctioned by Section 84, Subsection 14 of the Electoral Act 22 and 285, Section 14 of the Constitution. Kafi and another versus Abdul Aziz Ayari and Al Hassan another and Ishaku. It therefore follows that the course of action in this petition, which is rooted in the nomination or sponsor of the fourth respondent, is a pre-election matter. Being a pre-election matter, the petitioner herein has no local standing to challenge or question such nomination or sponsorship of the fourth respondent by the second respondent. Thus, in the People's Democratic Party (PDP) and Independent National Electoral Commission and others, unreported decision of the Supreme Court, delivered on 26th day of May 2023 in SC/CV/501 of 2022. I have the matter has been reported, but I have not been able to avail myself of the report. Held at the Supreme Court held at page 71 at follows, page 31 lines 116 there as follows. Court, the provision does not make the filing of pre-election matters by political parties and all comers affair. It is not the purpose of the provision that the floodgate of pre-election litigation be open to political parties who will hide under it to challenge the actions or inactions of rival political parties under the guise of challenging the decision or activities of INEC. The application of Section 285, Section 14C of the Constitution does not extend to a political party poking into the affairs of another. The position of the law has always been that no political party can challenge nomination of the candidate of another political party, no matter how paid or disgruntled the political party is with the way and manner another political party is conducting or has conducted its affairs concerning its nomination of its candidate for any position. It must keep mum and remain an onlooker, for it lacks the local standing against such nomination in court. Close of court. It is clear, therefore, that a political party such as the petition is herein only has the local standing to file a pre-election matter when the situation affects it or its candidate by virtue of Section 285, Section 14C of the 1999 Constitution. That being so, as in the instant petition, where the grounds of the petition is rooted on the nomination or sponsorship of the candidate of another political party, this petitioner will have no local standing to institute the action, be it in the Federal High Court or an election tribunal. For that reason, it is my view that the course of action in this petition being on the nomination and sponsorship of the third and fourth respondent by the second respondent applicant, petition is incompetent for lack of local standing on the petition to institute the action. It is also liable to be struck out for being incompetent. The second respondent applicant also contended that the petition is not properly constituted as the candidate concerned by the petitioner has not been joined as co-petitioner in the petition. The short answer to that is that Section 133, Section 1D of the Electoral Act 2022 entitles the petition as a political party to institute an election petition. The applicant has not referred us to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined as a co-petitioner. It is true that it is proper for the candidate of the party to be so joined, but there is no law that compels the political party to join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal, but any non-joinder would not invalidate the petition. This is particularly so when Section 133, Section 1 of the Electoral Act stipulates as follows. An election petition may be presented by one or more of the following persons: A, the candidate in an election, or B, a political party which participated in the election. By the use of the disjunctive word "or," it means that an election petition may be filed by the candidate alone, or the political party alone, or both of them. The objection on this ground is also discontinued. contemptuous motion filed on the 15th of May 2023, the citizen respondent, thus Kabir Masari, read this court to grant him the following reliefs. 1. An order of digital court dismissing this petition in its entirety for one jurisdiction. 2. An order striking out the name of the citizen respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And first, other orders are this honorable court may deem fit to make in the circumstances. The grounds of the application have been stated. I've also considered the submissions of counsel. Now, section 133. Section 133 of the electoral of defense persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the person whose election or return is complained of and the electoral body that conducted the election. See section 133, subsection 2 and 3 of the Electoral Action 22. Those are what are termed statutory respondents. It should be remembered that election petitions are sui generis. As sui generis and is procedure is strictly regulated by statute. That's why a person does not fall within the category of statutory respondents. They are not necessary parties in election petition. See the cases of Abere and Nimra, Buhari and Yusuf, APC and PDP. That's in Waziri versus Gaidam. The Supreme Court held a court. From the above, I have no difficulty in going along with the submissions of the respective counsel for the respondent. That section 137, sub 2 and 3 of the Electoral 2020 has no room for the joinder of the state respondent who neither won the election nor performed any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election. And even no relief was claimed against the said respondent, and indeed, he had nothing to gain or lose in the application of a close of court. Indeed, a holistic reading of the facts of this petition does not disclose any complaint against the civil respondent. The only fact that relates to the civil respondent relevant to the petition is the act of withdrawal of candidacy as the running mate of the third respondent. That is an act that occurred within the tribulation period, therefore cannot amount to any act done by the civil respondent by the respondent at the election. It cannot therefore ground any complaint by the petitioner against the civil respondent in an election petition. It may be relevant in a election matter but not in an election petition. It is therefore my finding that there is no any claim on the civil respondent. Otherwise, the relief sought in the petition will not in any way affect the civil respondent as he did not participate in the petition either as a candidate or agent of the second respondent, and no declaration was made in his favor by the first respondent. In that respect, I hold that the objection of the civil respondent on this ground has merit. Accordingly, I order that the name of the civil respondent be struck out of this petition. These are the rulings in respect of the petition number 4. I will now go to the main petition itself. So, after the pre-hearing session, hearing on the petition opened and closed on the 21st of June 2023, the petitioner called one witness and closed his case. None of the respondents called any witness but tendered some documents from the bar, and the petition was adjourned for adoption of written addresses. Parties then filed on self-written addresses as directed by this court, and same were adopted on the 14th of July 2023. The matter was then adjourned for judgment. The first respondent's written address was filed on the 30th of June 2023. Therein 4 issues were raised for determination as follows. 1. Whether considering the facts of the petition and evidence laid thereon, the petitioner has the local standing to question the nomination of the first respondent as a ground of challenging qualification and stand of the third respondent as the winner of the presidential election of 26 February 2023. 2. whether having regard to the facts pleaded and evidence laid thereon, vis-a-vis the provision of Section 134 subsection 3 of the Electoral Act 2022, can the issue of validity of the nomination of the sole respondent as the vice president candidate of second respondent be validly raised as a ground before this honorable court to question or challenge the qualification and return of the third respondent as the winner of the presidential election of 26 February 2023. Number 3, if the answer to not true is in the affirmative, whether having regard to the facts pleaded, the nomination of the fourth respondent as the vice president candidate of the second respondent is void, as to render the third respondent not qualified to contest the presidential election of 26 February 2023. 4, whether considering the relief sought as per the petition accrues no utilitarian benefit to the petitioner, this petition not an abuse of court process. Well, to save time, all the other respondents filed briefs and raised issues. These issues have been introduced in this judgment, including the issues raised by the petitioner. From the affirmance in the petition, the oral and documentary evidence, and the submissions of counsel, that this petition is grounded on the disqualification of the third respondent to have contested the presidential election of 26 February 2023. This is evident in paragraph 15 of the petition, wherein the petitioner pleaded that, read it earlier. This is further explained as emanating from the non-qualification of the first respondent to have contested the election as the vice president candidate of the second respondent. It is specifically pleaded in paragraph 17 of the petition as follows. Your petitioner states that the fourth respondent was not qualified to jointly contest with the third respondent for the presidential election held on 26 February 2023, having been purportedly nominated by the second respondent as its candidate for more than one office. The specific reasons for questioning the qualification of third respondent have been pleaded in paragraphs 1 and 2 of the petition as follows. Those paragraphs have been reproduced. If you get the judgment, you will see it here. So the combined reading of paragraphs 16, 16 and 17 of the petition, coupled with the particular thereof, show clearly that the petition is premised on non-qualification of the third or fourth respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in section 135 of section 1 of the Electoral Act that has been introduced earlier. It is the ground stipulated in section 134(1)(a). That they are not qualified to have contested the said presidential election. I've considered paragraphs 18, 19, 20, 21, 22, 23, 24, 26, 28 as relevant for determination of the petition, which paragraphs have been reproduced in this judgment. In response, the first respondent, that's INEC, filed a reply to the petition where it was averred in paragraphs 14, 15, and 16 of the first respondent reply to the petition as follows, which has also been reproduced. The second respondent also filed a second respondent reply to the petition and also made their own affirmance in paragraph 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, and 25, 29, which have been produced herein. From the totality of the pleadings in the petition and the replies of the respondents, What appears from the complaint of the petitioner is that the fourth respondent, while still a candidate of the second respondent for Borno's Central Senatorial District, was nominated and did accept to be the vice president candidate of the second respondent. That this act violated the provision of Section 35 of the Electoral Act 2020 as it amounted to the double nomination. That in the circumstances, this nomination as an associate of the second respondent for the present election is void. That the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time of the election. The petitioner relied on Section 131 and 142(1) of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of Federal Republic of Nigeria as amended stipulate as follows. A person shall be qualified for election to the office of president if A. he is a citizen of Nigeria by birth, B. he has attained the age of 40 years, C. he is a member of a political party and is sponsored by that political party, and D. he has been educated up to at least school certificate level or its equivalent. 142(1). In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate is for election to the office of president who nominated him as such associate is duly elected as president in accordance with the provisions aforesaid. The general principles of interpretation of the Constitution, which is the supreme law of the land, is that mere technical rules of interpretation of statutes are to some extent be avoided in a way as not to defeat the principles of government. That's why the words used are clear and unambiguous. A literal interpretation should be applied. In the interpretation, therefore, the provisions of the Constitution are to be accorded holistic interpretation so as to avoid ambiguity and arrive at the true intention of the legislature. The court must limit itself to the words used in the Constitution without resort to any external aid or materials. See the cases of Sani and President Federal Republic of Nigeria, Ahmadi and Aine, and Agi and PDP and others. Thus, in Wike Yezonwo Nwesom, Honorable Dr. Dakuku, Adol, Peter Side, and others, the Supreme Court observed that, I quote, the principle of conception of the Constitution to the effect that a Constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for the present, but for generations yet unborn. It was held that in construing the Constitution, undue regard must not be paid to merely technical rules, because in doing so, the objects of the provision as well as intention of the framers of the Constitution will be frustrated. Courts have always been encouraged to adopt a broad and liberal spirit in interpreting the provisions of the Constitution while constantly bearing in mind the object which such provisions were made to serve, close of course. That being so, where the Constitution has stipulated the qualifications to be attained by a person contesting or seeking to contest for any elective office created by the Constitution, the courts cannot create or import into the Constitution any other qualifying or disqualifying factor. This has been the position of the Supreme Court and dutifully followed by this court. It has therefore been held that qualification or disqualification of candidates to contest election is exclusively determined within the context or scope of the Constitution, and that nothing can be added to it. In other words, the Constitution, being the ground norm, is superior to any other law, including the Electoral Act. Therefore, where the Constitution has qualified a person or candidate to contest an election, no other law except the Constitution itself can disqualify him. The petitioner, in this case, has premised his complaint of non-qualification or disqualification of the third and fourth respondents as the president and vice presidential candidates of the second respondent on the issue of invalid nomination of the fourth respondent. That the fourth respondent, while still the senatorial candidate of the second respondent for Borno Central District allows himself to be nominated as the vice presidential candidate of the second respondent for the same election. In our rulings earlier delivered on the motions and prelude objections, we had ruled that the petition grounded solely on the issue of invalid nomination or improper nomination is not a cognizable ground of disqualification under the Constitution. In other words, the claim in the petition that the third respondent was not qualified to contest the presidential election because he nominated an associate whose nomination was invalid does not flow from any ground of disqualification of a candidate to the office of president as stipulated in section 131 and 137 of the 1999 Constitution. See the cases of Balewa and Mwazu and Faleke and Ainek, Tazu versus Iora. Then in Shinkasi versus Yali, the Supreme Court held that the Supreme Court has listed in section 182, section 182 very exhaustively all the issues that can qualify a person from contesting the office of governor of a state. From the record of this court, the facts have not disclosed any evidence to show that the first respondent was not qualified to contest elections into the office of governor of Zamfara state. It is my view that once a candidate sponsored by his political party has satisfied the provisions set out in section 177 of the Constitution and is not qualified under section 182 subsection 1 thereof, he is qualified to stand election to the office of governor of a state. No other law can disqualify him. This authority can apply mutandis to section 131 and 137 of the Electoral Act. It has not been contended by the petitioner that either the third or fourth respondent is trammeled by the provisions of section 131 or 137 of the 1999 Constitution. The complaint of the petitioner rooted on nomination and sponsorship of third and fourth respondent will find accommodation in a pre-election dispute which the petitioner cannot even pursue, not being a member of the second respondent. See section 84, subsection 14 of the Electoral Act 2022 and 285, 14 of the Constitution. While I'm tempted to put an end to this petition at this stage, but realizing that this court is not the final court on the matter, I'm concerned to look at the merit of the petition. As pointed out earlier in the course of this judgment, a complaint of the petitioner in this petition is that the third respondent was at the time of the presidential election held on 25th February 2022 not qualified to contest the election. This is because, according to the petitioner, the fourth respondent was not qualified to run on a joint ticket with him, that was third respondent, as the fourth respondent nomination was invalid for double nomination, which violates section 55 of the Electoral Act 2022. As stated earlier, the petition contended that the fourth respondent was a candidate of the second respondent for the Borno Central District when the third respondent nominated him as his vice presidential candidate on the 14th July 2022. In other words, that at the time the fourth respondent was nominated, he had accepted nomination as the vice presidential candidate of the second respondent. He was still a validly nominated central candidate of the second respondent for Borno Central District. The petitioner then contended that the second respondent had earlier submitted the name of the third respondent together with that of the fifth respondent to ANIC as his presidential and vice presidential candidate for the 25th February 2023 election. However, that before the date of the election, the fifth respondent withdrew his candidature as the running mate of the third respondent on the 24th June 2023, and the name of the fourth respondent was then submitted to ANIL, that first respondent, on the 15th July 2022. That the second respondent did not conduct any fresh primary election for the purpose of picking another running mate for the third respondent after the withdrawal of the fifth respondent. The respondent considered that the fourth respondent was ab initio the central candidate of second respondent for Borno Central District. However, that on the 6th July 2022, the fourth respondent via a letter dated the same date notified his political party that second respondent, of his withdrawal from the central candidature. That upon receipt of the fourth respondent letter, the second respondent immediately notified INEC, and which notification letter was received on the 13th July 2022. That the said letter also notified the first respondent of its intention to conduct a fresh primary election for the replacement of the first respondent following his withdrawal as a central candidate. That it was until 14th July 2022 that the first respondent was nominated as the third respondent associate for the presidential election of 25th February 2023. The fifth respondent notice of withdrawal as a candidate is in evidence as Exhibit PA2, while the notice of withdrawal and letter of voluntary withdrawal of the fourth respondent are in evidence as Exhibits PA3 and PA4 respectively. It will appear that the petitioner is the view that the fourth respondent was still the central candidate of the second respondent as at the 14th of July 2022, when the fourth respondent was nominated as the vice presidential candidate of the second respondent. However, the respondent contended the issue of alleged double nomination of fourth respondent has been determined finally by the Supreme Court in People's Democratic Party, PDP versus ANIC, that in the circumstances, the said judgment, the Supreme Court constitutes estoppel parem judicata and binding on the parties in this petition. Now, for a judgment to constitute issue estoppel, the conditions are earlier stated in the rulings. So the three elements must be present and coexist for a plea of estoppel parem judicata to apply. See the cases of Ito and Epe and others, Oshoboja versus Amida and others, and Alexandra and others versus Lone Star Drilling Company Limited, all citation supplied. It is obvious that the judgment sought to be relied on for the plea of estoppel is that of the Supreme Court, the highest and final court in this country. There is no doubt that the decision was final, and the issue that was determined by the Supreme Court is the same as in the present petition, with whether the fourth respondent breached Section 35 of the Electoral Act, but by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local standing of the PDP to question the nomination of the fourth respondent, the candidate of the APC, a different political party. That may well be so, but it is clear from the judgment, thus Exhibit X1, that the Supreme Court pronounced on the substantive issue of double nomination. Though Joro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case, the other laws of the Supreme Court proceeded to do so. It is settled law that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributory judgment contains what is not in the lead judgment will not whittle down its binding effect. Thus, in Olu Sherpa and others versus Abdurrahim, my Lord Fabi JSC said, I quote, the concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements, edifies, and adds to the lead judgment when the justice adds to it certain fact aspects which the writer of the lead judgment did not remember to deal with. Insofar as a concurrent judgment performs same or all the above functions, it has equal force with or as the lead judgment insofar as the principles of stare decisis are concerned. Of course. Now it is apparent that the parties in Exhibit X1, PDP and ANIC and other supra are not the same as in the present petition. The earlier decision, though, involved the first, second, and fourth respondents. The present petitioner was not a party in that case. That is why it was argued by the petitioner herein that Exhibit X1 cannot operate as to stop it from litigating the issue of double nomination of the fourth respondent. The respondents have responded that the judgment in PDP and Annex Exhibit X1 is a judgment in rem as opposed to judgment in personam. In law, a judgment in personam is a judgment against persons who are parties or privy to the particular suit or proceeding alone. It is referred to as judgment inter partes. It is a judgment binding on the parties to the action alone. A judgment in rem, on the other hand, is a judgment that determines the status of a person or thing as distinct from the particular interest of a party to the litigation. It is referred to as judgment contramundum, binding on the whole world. It is therefore binding not only on the parties to the dispute, but even non-parties. Therefore, once the status of person or thing has been pronounced upon by a court of competent jurisdiction, no person is permitted to assert the contrary of what the court has decided. See Black's Law Dictionary, 11th edition at page 1008. Demishola vs. Bolarinwa, Yanati Petrochemical Limited and EFCC. Then Ladi Jobi and others versus Oguntayo and others, citation supply. It is no doubt that the judgment matter in PDP and INEC others X1 was in respect of the alleged double nomination of the first respondent as the vice president candidate of the second respondent in the 25th February 2023 presidential election. That is the same issue raised in this petition as grounding the disqualification of the third and fourth respondent in this petition. Pronouncing on the issue in this case, in the contradictory judgment, my Lord Okoro JSC, who presided on the panel of the Supreme Court, held as follows, I quote, "There is no doubt that the fourth respondent was at a stage nominated as a candidate representing Borno Central District, but upon being muted, he would pair with the third respondent as vice presidential candidate of second respondent, All Progressive Congress, APC, in the 26th February 2023 general election. He withdrew his candidature for the Senate before taking up the position of vice president candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July 2022 respectively, laws of court. After considering those documents, His Lordship concluded at page 7 of the contrary judgment that, quote, "It is crystal clear that the two exhibits alluded to above, the fourth respondent did the needful by resigning his position of Senate candidate for Borno Central District since 6 July 2022, before being nominated by the third respondent to run alongside him as vice presidential candidate of All Progressive Congress," close of court. My Lord Okoro went on to, after citing section 31 of the Electoral Act 2022, held at page 8 of his contradictory judgment that I quote, "The above provision of the Electoral Act 2022 was duly complied with by the respondent. It is my well-considered opinion that as at the 6th of July 2022, having withdrawn his nomination and personally served term on the second respondent of the withdrawal of nomination on 6 July 2022, the fourth respondent was no longer a candidate for the Borno Central District election, and his subsequent nomination as vice president candidate of the second respondent for the presidential election was not multiple nomination, as there was no longer a nomination for the fourth respondent since his withdrawal on the 6th of July 2022. I have also cited the elaborate contribution of His Lordship Ajim JSC. So I have endeavored to quote extensively the dicta of the laws of the Supreme Court in PDP and INEC Supra in order to show that the issue of double or even multiple nomination of the fourth respondent as the central candidate and vice presidential candidate of second respondent in the 25th February 2022 general election has been settled to finality. It is a judgment in rem, therefore binding on the parties to this petition and in fact the entire world, including this court. Being the judgment of the final court of the land, of this land, this Supreme Court, no person is permitted to again raise and litigate on it in any other action or proceeding. It is therefore settled and remains that this petition, which questions the qualifications and seeks to disqualify the third and fourth respondents from contesting and occupying the seat of President and Vice President of Nigeria on ground of double or multiple nomination of the first respondent and Vice President candidate of the second respondent on ground of double or multiple nomination of fourth respondent has no substance. I only wish to add that Section 35 of the Electoral Act is targeted at the candidate and not the political party. That is why it uses the terms a candidate and normally allows himself to be nominated by more than one political party or more than one constituency. Thus, to prove that the candidate knowingly allows himself to be so nominated, both the intent and actual acts of nomination, that is, the mens rea and actus reus, of the Act prohibited must be proved, the stipulation in the section being a penal provision. In the instant case, neither the intent nor the fact of the first respondent to allow himself to be so nominated was established. That's why His Lordship Ukumi JSC, in his contributory judgment in Exhibit H1, held as follows, I quote, by Section 31 of the Electoral Act, the fourth respondent, Shetima, was obliged to submit a notice of withdrawal in writing to his party, which he did, and then his party is to deliver that notice to the Commission not later than 90 days to the election. In view of the above stated position of the law on this issue and the facts of this case, there exists no animus or display of intention by the fourth respondent to stand as the nominated candidate of the second respondent for the vice presidential position and also the senator representing Borno Central District in the general election of 26 February 2023. There cannot be any other interpretation in the circumstances unless there is clear intention to knowingly stand as a candidate for two elective posts in the same election cycle. Jim JSC also contributed as follows, quote, the manifest intention to relinquish the earlier nomination to pave way for the nomination of another person to replace him as the party's central candidate cannot be overlooked or disregarded. To simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nominations without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies is against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the events is not what determines the existence of multiple nominations. It is the intention, design, or purpose to hold two or more nominations as candidate for election that shows that the person so nominated knowingly did so. The second respondent did not intend that the first respondent should be its candidate for Borno Central election and its vice presidential candidate for the present election, and the first respondent did not understand or know that he was so nominated. The word knowingly in Section 35 of the Electoral Act must be interpreted broadly to include all its literal meanings. Barton's Legal Thesaurus, 4th edition by William C. Barton at page 356. It is defined to include advisedly, deliberately, designedly, intentionally, learnedly, pointedly, purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties on this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency as alleged by the petitioner against the first respondent has not been established. In other words, both the mens rea and actus reus of the Act prohibited by Section 35 of the Electoral Act 2020 were not established. One other aspect alleged by the petitioner on his claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate. That after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the Commission for the election concerned. The interpretation of this provision does not, in my view, pose any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to Section 29 of the Electoral Act Supra, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. By the proviso thereto, the political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the fifth respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by Section 33 of the Electoral Act. It should be remembered that by Section 142, subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore, in my view, the requirement to conduct a fresh primary election does not apply to the nomination of a vice presidential candidate. Thus, my Lord of DJSC highlighted this point in Exhibit 1 as follows. The fourth respondent was not required to buy any nomination form. He was the second respondent, APC's candidate, at the election into the office of Senator representing Borno Central District. But before the election took hold, he was nominated as the third respondent's associate, who is to occupy the office of vice president. The fourth respondent did not buy a nomination form for the said office, and most importantly, did not contest any primary election in order to emerge as APC's vice president candidate. Close of court. The petitioner in paragraph 28(2) of his petition had averred and also contended in his final address that there was a gap of about 3 weeks between the period the fifth respondent expressed his intention to withdraw and his actual withdrawal or purported nomination, thereby invalidating the nomination of third respondent, because the candidate of third respondent had lapsed and was no longer in a position to constitutionally terminate a running mate. This contention or petition is, however, misconceived. There is nothing in the Constitution which robs a presidential candidate of his right to nominate his associate, who shall be his running mate for the office of president. There is also nothing that invalidates the nomination of a new associate by a presidential candidate as his running mate after the withdrawal of a previous associate, so long as the nomination of the new associate was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that the position of a person as vice presidential candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 would not apply. On that note, I hereby hold that the petitioner failed to prove the lone ground of his petition to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason of double nomination. Having resolved the sole issue of this petition against the petitioner, this petition is held to be devoid of any merit. I'll continue with petition number 3 and 5. I can see Dr. Levy moving up and down. So, as an elderly person, I know what is going on. Yes.
We just wondering, my Lord, if your brethren agree with your judgments or not.
Pardon?
I said, we're just wondering.
So it's a consolidated judgment. They will give their contributions after we have read all the judgments.
Oh, my Lord, please. We just needed to know, sir.
Yes, they will give their.
Thank you very much, my Lord. Thank you, sir.
Call the court.
Network service of the Nigerian Television Authority. And you're watching the special coverage of the sitting of the Presidential Election Petition Court, which today, Wednesday, the 6th of September 2023, is delivering its judgment in the consolidated petitions arising from the conduct of the presidential election on the 25th of February 2023. The court rose a while ago for a 15-minute break, and you heard His Lordship tease one of the attendees at the court that the court needed to give him some breather as well. So, in the interval, we'll come back to our two guests in the studios here who have been following the proceedings, especially since Judge Samani began delivering his judgment on behalf of the Court of Appeal. But of course, it's a 5-man panel, which means that the other 4 justices will also have the opportunity of delivering their own decisions. With what we don't know at the moment, and you heard that question if you've been following the transmission, popped up to the effect that was this a unanimous decision, or was this a split decision? And therefore, if it was a late judgment that His Lordship was reading, and His Lordship's response was that the 4 brother justices who are sitting on this petition will equally deliver theirs. So perhaps that's when we'll have a clearer idea whether it's a split or a unanimous decision. So back to the studios here, Ezenwa Wango and Professor Adoba Amorike, you followed the proceedings so far. It looks like we are in for a long day.
So it appears, now that we have had from one of the justices, and we have 4 more to go. If we go by the length of the first decision, then of course we really have a long way to go. But nevertheless, we now have an idea of what the Islami is thinking, or study is concerning one of the issues canvassed during the trial, and that is the issue of double nomination. And as you had the court's view, or the judge's view, is that amounts to a pre-election issue, which the election court cannot adjudicate pursuant to the provision in the Constitution, specifically Section 285, that says that only the Federal High Court can adjudicate upon such a matter. So that's where we are now. We have heard from him. We're going to wait to hear from the other justices.
All right. Thank you very much, Professor Amorike. I'm just talking about the duration. It's a long haul ahead.
Well, we're here. I think today is dedicated to these judgments. Whether it's long or short, we're here. We'll see through it. And I think what's important is that Nigerians are interested in finding out at least some relative closure around this whole litigation and all of that. And since the ball has been set rolling by Justice Samani, I don't think that the other judges would be this lengthy. I think they would either go straight to, because any rehash, if they are going to do the same rehashing of what Justice Samani has done, then that may be. But I'm sure they are also conscious of time and may not want to take us through this long haul.
Okay, Ezenwa, thank you very much. We are trying to get our correspondent, who is also the head of Judicial Desk, Dele Atumbi, who is at the court premises, and in fact, inside the courtroom, but he just stepped out of the courtroom. Once we're able to establish, all right, he's there. Dele, if you can hear me, give us a sense of what has transpired in the courtroom. At least some of the summaries that you have transmitted to us have also been on our screen. But I want to ask you a question, and then you get back into the details of what has transpired. Who is in attendance? Some of the faces we have seen, but others we haven't quite seen. The Vice President, who was returned as Vice President, Kashim Shettima, we've seen him there. Atiku Abubakar of the PDP and Peter Obi of the Labour Party, are they also in the courtroom, and who else is there?
You say at this point that the Vice President of the Federal Republic of Nigeria, Kashim Shettima, is a court, and some other governors are here. Opuzodima of Imo State, the governor of Ekiti State, and some other governors are equally here. The Bauchi State governor is equally here. And while they were inside the court, there were many things that transpired at that time. The Allied People's Movement matter had been dismissed, and it is unanimous. It is a unanimous judgment that had been given on this matter, and there are certain things that were equally discussed. One, that the process was an abuse, that the petition itself was an abuse of court process. And for that reason, the court has equally said that nomination of a candidate is and sponsorship is a pre-election matter, and for that the court lacked jurisdiction to entertain the matter, and the matter was dismissed on the ground of lack of jurisdiction on this matter. And don't forget that one of the things that Justice, the lead justice said was that the abuse of court process should not be entertained by the court. And that was one of the reasons that the matter lacked merit, the petition lacked merit, and it was dismissed on the basis of the fact that two things: for lacking the merit and for the fact that the court lacks jurisdiction, because those two issues, sponsorship of a candidate and the qualification, is a pre-election matter. They are pre-election matters.
Tell us, just before their lordships rose for the interval, there was a question from one amongst the participants, I didn't quite get a name, asking whether this was a unanimous decision or a split decision, and his lordship Samani did respond that the other four brother justices would also read their judgment. We don't have a sense yet whether this is unanimous, or we have to wait until all five justices have delivered their verdicts.
He said it before we left the courtroom that they all concord. It was a concordance of every one of them participating on that panel. It was a concordance. They agreed on that. It was a unanimous judgment, not a split judgment at this point in time. So the issue of APM matter had been dismissed, and the court is functus. It cannot come to it any longer.
That's useful to understand, but of course there are still other aspects of the decision which the court will return to. In a sense, how much more do we have to still hear? But there's the issue of whether a person or a candidate to be declared winner of a presidential election must score 25% of the lawful votes cast in the Federal Capital Territory. That's a matter of the cards, I imagine.
Let me equally say this. The matter came up in the petition which was filed by Peter Obi and the Labour Party. And it would now take the lordships to take a critical look at this issue. And 25% in Abuja, it was Peter Obi that raised it. And in the prayers of Peter Obi is saying that the President of the Federal Republic of Nigeria, President Bola Ahmed Tinubu, did not call 25% in Federal Capital Territory. Since we cannot dabble into it now, because it is a matter that has not been decided, and I know that immediately they come in, it will be matters to be decided by the justices. 25% in Abuja is a matter that the court will decide now, and we may not be able to dabble into it. Kingsley, you know.
Well, I'm just saying that it's a matter that is pending in the decision of their lordship. What else should our viewers be interested in what is outstanding with regard to this judgment?
Take a look at the prayers of Atiku Abubakar and the PDP. What they are alleging is that the President of the Federal Republic of Nigeria, at the time of his declaration and return, that he was not qualified to stand in for the election. It's a matter which the court will equally decide. And and I don't want us to dabble into it too much. Atiku Abubakar is equally asking the court in one of his prayers to declare him as President of the Federal Republic of Nigeria. One of his prayers. Another prayer of Atiku Abubakar is for a rerun between him and President Bola Ahmed Tinubu. Whether the court will grant it or not, it's a decision of the court, and it's at the discretion of the court.
What we now know from the decision by His Lordship Samani is that the petition of the APM has been dismissed, and that petition related essentially to the allegation of double nomination. So that's one matter that has been sorted out. Others remain to be decided upon by their lordships, and that will happen when they reconvene. Is that correct?
That's correct, because if you take a look at Section 35 of the Electoral Act, it's talking about double nomination or multiple nomination. And the court, it is now a settled law. It has been settled that the APM matter are pre-election matters. Those things that were brought were pre-election matters, and that it denied the court jurisdiction. And for that matter, for that reason, the court will not double it. It is settled matter. Kingsley, you are right.
Okay, Dele, thank you very much. What we will do is to return to the studio so that we get the benefit of the knowledge of Professor Edoba Omorike for our viewers to have a clearer understanding of the core value of jurisdiction. Because jurisdiction in law, as you very well know, you are a lawyer as well, a correspondent. Thank you very much for what you've been doing. We'll get back to you. I'm sure we'll be able to re-establish contact. And if there is anything, of course, that is happening still in the interval before the lordships reconvene, kindly be back to us, and then we'll open up the lines. Dele Atumbi, thank you very much. Back to the studios here, Professor Edoba. We'll see that the court said, look, this is an abuse. One, it's a pre-election matter, and we don't have jurisdiction. Let our viewers know what might have happened if the Presidential Election Petition Court then opted to assume jurisdiction.
No, they were not in a position to assume jurisdiction because, like I said, the Constitution is clear on matters like this, and I think that's what they pronounced. Section 285 is the relevant section, and that section says that if there is any concern about nomination, in fact, it was in 2018 that alteration was made there, defining what constitutes pre-election. Hitherto, it was not very clear. So that if there is any concern about nomination of candidate of a political party, the Constitution requires that such a challenge should be taken up within 14 days upon becoming aware of that situation, and that is before election. I think that's what the court has virtually has pronounced upon, meaning that the issue of whether the vice president was nominated previously for Senate and subsequently tapped for vice president, presidential candidate, constitute matters before election, which ought to have been litigated before the election of February 25. And so I think the court has, virtually just stated what, the courts have decided upon frequently on this issue. So jurisdictional issues are very important because a court without jurisdiction cannot adjudicate upon a matter. So it's a threshold issue. It's only when the court has been conferred jurisdiction that you can assume it and decide on the substance of the matter. So the substance of the issue has not been addressed at all. What was addressed is whether this tribunal has jurisdiction. The proper court in the Constitution and even in the Electoral Act is the Federal High Court. And that's what the court has said.
Okay, Prof, thank you very much. As the question of challenging the eligibility of a candidate in an election, how onerous is this a duty on the part of anyone who seeks to mount such a challenge?
Well, I don't think there's a big challenge from that. The way the processes are structured is that we do know that INEC publishes qualifications of the different candidates who will be running in different political parties, and that's public knowledge. So even if you couldn't avail yourself the opportunity when that publication was made, you can go by way of seeking the CTC, the Certified True Copy, which INEC is obligated to give to those who apply within a stipulated period of time. So I don't, if there is the interest to pursue that in terms of qualification, but what I see often is that many litigants test water because if by simply listening to this judgment, there is some kind of irritation in the voice of the justice in terms of why are you bringing this? This is something you should ordinarily know. But as it is, Prof has told you, you can't assume what you don't have. So, and I think that the lawyers who also test this water want to see whether it is possible to technicalize the conversation and see whether there is a loop. And that is okay. It's also part of what it is. But simply, the task is very simple. Once people apply for a position, they apply with their qualifications. In the Constitution, it's very clear. You have your age, the educational qualification is also a constitutional matter. Your state of origin, your Nigerianness, and those issues. You put it out there. And then, so have you gone to jail before? Have you been convicted? And all of those things. If you answer those questions, you put it out there. And what needs to happen is that as we continue to develop, those things can be put on the website of INEC so that people can simply download it without necessarily going through all this etc. Because as we advance in technology, we should also advance in such a way that makes these things more difficult. We run an adversarial regime of judiciary where people have to be, you have to be the one proving, not the other way around. If the man has been cleared to contest, you who want to unseat him must do the duty. But the electoral management body has to create what we call level playing ground for everyone who wants to be able to access information to do that, and that can be done through their website. And I think that's the way they've been trying to go.
In the public space, for a pretty long time, ahead of the 2023 elections, the structural issues around the elections, of course, have to do, one, with amendments to the Constitution, and secondly, the enactment of the Electoral Act. It took quite a while. The Electoral Act eventually was passed, and then we had the Electoral Act 2022. We know that there have been several petitions handled by tribunals with respect to either governorship or legislative elections. But this again, what we're having today is the big one. Many would say is the big elephant that everyone is focused on. Is there a sense in which, based on the experiences from the previous decisions by the other tribunals and what their lordships are now deciding on today, that this will be like a true test, if not trial, of the relevant amendments to the Constitution and the operationalization of the Electoral Act 2022?
Yes, of course, that's what we are seeing now. Which is that some aspects of the Constitution that seem to be unclear. You know, again, they are being clarified again. You know, although, like I said, some of this, because the aspect that relates to pre-election, it's not new. It's been on now since 2018, and there are many judgments on the point. And perhaps the only one that seems to be unclear is the provision of Section 134 of the Electoral Act, which now try to incorporate qualifying and disqualifying provisions contained in the Constitution, you know, as grounds for election petition. So to that extent, we have not had that before. So with that introduction of qualifying and disqualifying grounds as grounds for election petition, some persons will feel able to raise issues even post-election that would otherwise be classified as pre-election. So what this court has done now is to reaffirm the position that despite that, you know, incorporation of qualifying and disqualifying grounds of the Constitution into the Electoral Act, the position taken previously by the courts as to what constitutes pre-election, as disclosed in Section 285 of the Constitution, remains the case. So that even if you go to court and say, well, you are not qualified, you are as an election petition ground, you would have to contend with the question. These questions of qualifying or disqualifying that you have raised, do they constitute pre-election issues? If they do, you cannot raise them as an election petition question. You would still have to meet with the challenge that you ought to have raised them, not in the election petition court, but in the Federal High Court, as provided in the Electoral Act. So that is the position. So to answer you, the novel position now, which the court has pronounced, as far as the first arm of the challenge, is that the jurisprudence of pre-election remains. Namely, any matter which relates to matters before election remains pre-election matters. So that you can raise them as election petition matters.
The Electoral Act is its first bad day was on the 25th of February, the very day that election took place. That was the first 1 year of using that Electoral Act. So it's a baby in terms of operationalization. But one beautiful thing about elections is that the legal framework for an election, which is the work that, like I keep saying, even though sometimes we don't like to take the credit, even you, Kinsley, the work that you did to get that thing passed, is important, because we've created a legal framework that helps us to have better elections than we used to have in the past. And so when people, and I listened very attentively to Justice Samani when he was talking about nobody can import what does not, you can't bring in something that does not exist. They are not going to give you all of that. So I'm excited that we are seeing some kind of a legal framework that helps us to drive our electoral process. But it has to be tested over a period of time. And part of the test is what the court is doing. The court is helping us to unpack the Electoral Act, make it simpler, because the mysticism of legal terms and all the rest, when this judgment comes, we are then able to see whether what we pushed has helped us to advance our elections in the direction we wanted it to go, and then we can begin to x-ray all of that. But it's still morning in terms of where at least one part of it has been closed. We are eagerly waiting to see other issues, but I think the issue of qualification has been closed in terms of where should you go to if you have issues around qualification or disqualification, and
where should you go to and when
you should go there. Those have been cleared in terms of if we can't do that at this place. What we do is to look at the conduct of these elections and how it followed the Electoral Act. If you have other issues, take it to some other. And I think it should be a learning, because all of this is not just the excitement of winning or losing. It should be a learning for both the political parties, the electoral management body, and other stakeholders in the electoral process to just say, what are we taking? What are the lessons away from all of this? What advocacy issues are all of this throwing up for us in terms of even making our elections better? And that for me is the crux of today's engagement. Is a learning curve for us. We are consolidating our democracy, and the only way to do that is to keep improving, keep getting better. And I think that is what all of this. And then special thanks to putting that out on live television. If you whatever you want to take away from it, that opportunity has been given to us, and it's something we shouldn't take for granted.
Thank you very much. One other very interesting aspect to all of this, Prof, this question is coming to you, because early on, before the court began reading its decision, Ezenwa, in responding to one of the questions, did say that yes, today is a big day because it's leading us to closure. But we know, as he also indicated, that this is the first step. But significantly, the timelines are delimited.
Yes.
What are the uses of this versus what we had in the past?
Well, of course, the whole idea is to ensure that you don't protract litigation over election. So that, everybody is elected for a time certain.
Professor Edaba Amerige, we have to pause. So we'll keep that question in abeyance, or in administration, we'll KIV the question. I will come back to it. Now, we understand that the lordships have resumed sitting, delivering their judgment in the consolidated petitions challenging the election of Bola Ahmed Tinubu as President Commander-in-Chief of the Armed Forces of the Federal Republic. So we now rejoin the Presidential Election Petition Court, which ordinarily is the Court of Appeal.
Well, the same paragraph further provides that, and I quote, the election petition shall be divided into paragraphs, each of which shall be confined to a distinct issue or major facts of the election petition, and every paragraph shall be numbered consecutively, unquote. In addition to the provision of paragraph 4 of the first schedule to the Electoral Act, paragraph 54 of the same schedule to the Act has made applicable to election petitions the rules of procedure in the Federal High Court of 2019, subject to such modifications as would bring same in conformity with the provisions of the Act. By Order 13, Rule 4 of the Federal High Court Civil Procedure Rules 2019, every party to an election petition shall ensure that amendments in their pleadings, and I quote, contain in a summary form the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved, and shall, when necessary, be divided into paragraphs and numbered consecutively, unquote. By subparagraph 4 of that rule, such facts contained in the pleading must, and I quote again, be alleged positively, precisely, and distinctly, and as briefly as is consistent with the clear statement, unquote. The aforementioned provisions contained in the first schedule to the Electoral Act 2022, as well as the Federal High Court Rules 2019, state the mandatory requirements of pleadings in election petitions. The requirements for clarity and precision of facts required by paragraph 4 of the first schedule to the Electoral Act means that amendments must not be vague, ambiguous, or unclear, leaving room for speculation or conjecture, while the requirements of distinctiveness means that each amendment must contain a clearly understandable allegation, and there should be no confusion as to the linkages between facts contained in the amendments in ascertaining the allegations being made in it. In particular, paragraph 4 sub 1 sub D, relating to the fact of petition, the grounds on which it is based, and the relief sought by the petitioner had been severally considered and interpreted by the appellate court. In Belgorian Ahmed Supra, the complaint against the amendments in the petition was that they were unspecific, generic, speculative, vague, unreferable, omnibus, and general in terms. In that case, the Apex Court specifically held as follows, and I quote, pleadings in an action are the written statements of the parties wherein they set forth the summary of the material facts on which each relied in proof of his claim or his defense, as the case may be, and by means of which the real matters in controversy between the parties and to be adjudicated upon are clearly identified. Although only material facts are required to be pleaded and in a summary form, they must nevertheless be sufficiently specific and comprehensive to elicit the necessary answers from the opponent. They must contain such details as to eliminate any element of surprise to the opposing party. In this case, where the dispute involves the election in as many as 895 polling units, the pleading in the petition, which allege electoral malpractices, non-compliance, and/or offences in, quote, some polling units, many polling units, most polling units, or several polling units, cannot be said to have made the requirements of pleadings as stipulated in paragraph 4 sub 1 sub D of the first schedule to the Electoral Act and Order 13 in 4 sub 1, 5, 6 and sub 1 of the Federal High Court Civil Procedure Rules 2009, unquote. Indeed, in PDP and INEC, the Apex Court was categorical when it held those, and I quote, on whether the affected paragraphs were rightly struck out, I have read the affected paragraphs and found that they relate to allegations of non-voting in several polling units, disruption of election, non-conclusion of election, thumbprinting of ballot papers, falsification of election results, widespread disruption, irregularities and malpractices without providing particulars or the polling units where the alleged malpractices took place. The lower court was therefore right when it held as follows. The paragraphs above, in my view, are too generic, vague, lacking in any particulars, and they are not tied specifically to any particular polling unit or any particular number of people who are alleged to be disenfranchised. The fact that a party can file further particulars or deny any reply, the government in the pleading must not be general, it must be specific as to facts. It is settled law that a petitioner's obligation to plead particulars of fraud or falsification without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above, and I adopt it as mine. Unquote. Indeed, on the provision of paragraph 17 sub 1 of the first schedule to the Electoral Act relating to further particulars, the Apex Court held in PDP versus INEC, Supra, that, and I quote, an application for an order for further particulars is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, and devoid of necessary quote. A sober consideration of the decisions of the Supreme Court in relation to the requirements of pleadings in paragraph 4 sub 1 sub T of the first schedule to the Electoral Act 2022 on the one hand, and the decisions of the Supreme Court on the provision of paragraph 17 sub 1 and sub 2 of the first schedule to the Electoral Act 2022 relating to further particulars on the other hand, shows that whilst in cases such as Abubakar versus Eraduan and Ombugadu versus Sule, the Supreme Court had held that a respondent who complains of vagueness of averments in an election petition should avail himself of the provision of paragraph 17 sub 1 of the first schedule to the Electoral Act to seek for further particulars or the direction of the tribunal or court. The decisions of the Apex Court, especially in PDP, INEC, and Belgore and Ahmed, have specifically held that where averments in the petition are grossly imprecise and generic, such averments will be incompetent and liable to be struck out. See also on this Ipiazu versus Oti Supra. It is therefore clear that the state of the law, as could be deduced from the various decisions of the Apex Court, is that the provision for further particulars, as stated in paragraph 17.1 of the first schedule to the Electoral Act 2022, will only come into play where the petition itself contains material or necessary particulars. In other words, paragraph 17 sub 1 of the first schedule to the Electoral Act 2022 does not bar a respondent from applying under paragraph 4 sub 7 of the first schedule to strike out averments in the petition which are grossly inadequate, insufficient, and devoid of material or necessary particulars. This is because the operational words in paragraph 17 sub 1 is further particulars, and this means there must be some material particulars already pleaded in the petition before further particulars can be sought by the respondent. As born from the Apex Court decision in Belgore Ahmed, PDP, INEC, and Ipiazu and Oti, the law is clearly settled that specifying the particulars of polling units or places where irregularities are alleged to have occurred are material particulars in an election petition, and averments in an election petition which allege irregularities or malpractices but fail to specify the polling units or places where the irregularities or malpractices occurred are bereft of material particulars, and such averments are incompetent and liable to be struck out. As specifically stated in PDP and INEC, a petitioner who has failed to state such material particulars cannot invoke the provision relating to further particulars as a sword against the respondent in order to cure the incompetence of such averments. With respect, it is a misconceived argument on the part of the senior counsel for the petitioners to state that the latter decision of the Apex Court in Ombugadu and Sule Supra, which relates to further particulars under paragraph 17.1 of the first schedule, has departed the specific decisions of the Apex Court in Belgore Ahmed, PDP, INEC, and Ipiazu and Oti, and several others, on the mandatory requirements for stating material facts as provided in paragraph 4.1 of the first schedule of the same first schedule to the Electoral Act. Contrary to the contention of the petitioners, the decision of the Supreme Court in Ombugadu and Sule Supra has merely reiterated the legal position relating to further particulars as provided in paragraph 17 sub 1 of the first schedule to the Electoral Act 2022. It has not departed from the above specific decisions of the Apex Court on the materiality of specifying in an election petition the polling units or places where irregularities and malpractices are alleged to have occurred. Now, a look at the arguments in the petitioner's petition shows that the petitioners have only alleged various irregularities and malpractices, but failed to specify the particular polling units or specific places where the alleged irregularities and malpractices have occurred. For instance, in paragraph 9 of the petition, where the petitioners avert that, and I quote, in appropriate cases, these agents raise complaints about anomalies where they occurred and reported such complaints to the designated officers of the second respondent and the first respondent, unquote. The petitioners failed to specify the anomalies, the places where the anomalies occurred, the agents who complained, and the designated officers of the second petitioner and the first respondent to whom the complaints were made. In paragraph 60 and 61 of the petition, where the petitioners allege that the first respondent, and I quote, suppressed the actual scores obtained by the petitioners by deliberately uploading blood from EC8As on the RF in 18,088 polling units. The petitioners did not specify the polling units, but only stated that they will rely on spreadsheets containing the polling units codes and details of the 18,088 polling units, as well as the authentic results in the said polling units. In paragraph 66 and 67, where the petitioners allege that the first respondent embarked on, and I quote, massive misrepresentation and manipulation, there were no elections, unquote. They did not specify the polling units where they allege there were no elections, the incorrect results that were uploaded, and which are the correct results. Again, in paragraph 68 to 71, where the petitioners allege that the scores obtained by them were, and I quote, unlawfully reduced and added by the first respondent to the scores of the second respondent, unquote. They failed to state their scores that were reduced and added to that of the second respondent by the first respondent, and the figures that shows that the first petitioners won the election. In paragraph 72, 73, 76 to 78, where the petitioners allege overvoting, they merely stated that they will, and I quote, rely on the forensic reports of the election materials showing that the votes cast in the polling units in Ekiti State, Oyo State, Ondo State, Taraba State, Osun State, Kano State, Yobe, and Niger States exceeded the number of votes accredited on the beavers on those states. The petitioners failed to specify the polling units in those states where the overvoting occurred, the number of votes affected, the margin of lead, which they claim that the voters who ought to legitimately vote in those polling units. In paragraph 73 of the petition, the petitioners only stated that they will, and I quote, show that in the computation and declaration of the results of the election, based on uploaded results, the votes recorded for the second respondent did not comply with the legitimate process of computation of the result and disfavored the petitioners, unquote. In Rivers, Lagos, Taraba, Benue, Adama, Imo, Bauchi, Borno, Kaduna, and Plateau, and other states of the Federation. Petitioners neither specified the uploaded results nor the votes illegally recorded by the second respondents and how they were disfavored. In paragraph 83 of the petition, where the petitioners claim that the first respondents scored the majority of lawful votes cast at the election, they did not state the majority of lawful votes they claim to have scored, especially as elections and the determination of who won is about figures. In paragraph 99 of the petition, where the petitioners say they will rely on Form EC8As to establish that substantial votes were unlawfully credited to the second respondent, they failed to state the figures of the unlawful votes credited to the second respondent. In the petition, the petitioners merely made generic allegations of various irregularities and malpractices against the respondents without specifying the polling units, collation centers, or specific places where the alleged irregularities and malpractices occurred. Rather, the petitioners only stated that they will rely on spreadsheets, inspection reports, and forensic/expert analysis, which they say they have incorporated in the petition by reference. But none of the spreadsheets, inspection report, and forensic/expert analysis was attached and served along with the petition on the respondents. Rather, they were only listed as items 35 and 36 in the list of documents to be relied upon by the petitioners. It is only in paragraph 62 and 64 of the petition where the petitioners allege that the first respondents suppressed the lawful votes of the petitioners and inflated the votes of the second and fourth respondents in Rivers and Benue states. And the petitioners gave figures of the votes, where the petitioners gave figures of the votes suppressed for the petitioners and those inflated for the second and fourth respondents, and also stated that they claim to be the actual figures scored, what they claim to be the actual figures scored by them and by the second and fourth respondents. But all other paragraphs of the petition where irregularities and malpractices were alleged are bereft of any material details of the polling units or places where they were alleged to have taken place, or the figures of votes alleged to have been suppressed, deflated, or inflated. It is also pertinent to observe that in paragraph 79 of the petition, where the petitioners alleged corrupt practices, they merely stated that they are repeating their pleadings in support of the grounds of non-compliance to be in support of their allegations of corrupt practices. It should be noted, however, that not every ground of non-compliance will amount to corrupt practice. In fact, the standard of proof of non-compliance differs from that of corrupt practice, while standard of proof of non-compliance is on the balance of probabilities, that of corrupt practices is beyond reasonable doubt. See PDP, INEC, Mohamed Wamako, Board of Customs and Excise versus Alaji Ibrahim Barrow, citations on the record. It is instructive that in paragraphs 3.2 3.21 of their submission, in opposition to the first respondent's objection, the petitioners appear to have considered that in the averments of the petition they have not specified the particular polling units where the alleged irregularities and malpractices occurred, or specified the figures of the votes or scores which they are alleged to have been suppressed, deflated, or inflated. Rather, they stated that the details of the polling units are contained in the spreadsheets and forensic analysis reports which they have incorporated and made part of the pleadings by reference. See particularly on this paragraph 67 of the petition. Petitioners further argued that since the respondents have failed to apply for further particulars under paragraph 17.1 and 2 of the first schedule to the Electoral Act, they are deemed to have understood those averments. However, by paragraph 15 of the first schedule to the Electoral Act 2022, when the petitioner claims, and I quote, that he had the highest number of valid votes cast at the election, the party defending the election or the return at the election shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove at the hearing that the petitioner is not entitled to succeed, unquote. This provision presupposes that the petitioner has a first duty to state clearly in his petition the particulars of such votes, in respect of which he claims to have scored the highest number of valid votes, and thus entitled to be returned as the winner. This also presupposes that it is only after the petitioner has supplied the particulars of the votes in support of his claim that he scored the highest number of valid votes that a respondent will then have a duty to object to any part of the particulars of such votes supplied by the petitioner in order to show that the petitioner is not entitled to succeed. With regard to the petitioner's contention that they have incorporated into the petition by reference the spreadsheets and forensic analysis report containing details of the polling units where they allege that the irregularities and malpractices occurred, it is right that for a document to be properly incorporated as part of pleadings by reference, the document must not only be referred to in the pleadings, but it must also be included as part of the pleadings to be served on the adverse party, so as to enable the adverse party to properly respond to same in his defense. Indeed, in all the cases of EFCC reign, a Como Polo was a Dere Moda Marine Management Associates Incorporated versus NMA and Dinjadi and Wamako Supra, which were relied upon by the petitioners. The documents which were incorporated as part of the pleadings by reference were served along with the pleadings of the adverse party. In considering a similar scenario, this court by Ayola, just as it then was, held in Nigeria Merchant Bank PLC was Ayedu Investment Limited as follows, and I quote, before I party this appeal, it is pertinent to advert to one pleading question raised in this pleading regarding the consequence of a party pleading that he will rely on certain unspecified documents at the trial. The plaintiff contended that such averments made the contents of such document part of the pleading. In this case, the plaintiff in paragraph 30 of the statement of claim pleaded thus: the plaintiff at the trial will rely on all letters and documents between the parties pertaining to this. Although the principle is established that if an agreement in writing is referred to in the pleading, it becomes part of the pleading, and it is open to the court to give the agreement its true legal effect, irrespective of the term used in the pleading to indicate such effect. That proposition of law should not be used to cover such armament as shown above, which lacks specificity. Besides, a report such as Exhibit P22 in this case, prepared by a witness for the plaintiff and tendered at the trial by the witness, cannot be described as documents between the parties pertaining to the suit. At the appropriate time, when the occasion arises, the true ambit of the proposition of law in such case, such as Bank Genesis versus Petai Limited, ought to be defined, unquote. In the instant case, the spreadsheet and forensic report, which were documents prepared by the petitioner's witnesses, were not served along with the petition on the respondents, but were only listed as documents to be relied upon at trial. I'm not oblivious of the petitioner's argument in relation to paragraph 4, sub 5, sub C of the first schedule to the Electoral Act 2022, which provides that the election petition shall be accompanied by, quote, copies or list of every document to be relied on at the hearing of petition, unquote. This provision undoubtedly only relates to front-loading of documents to be relied upon by the petitioner as his evidence during trial. Contrary to the petitioner's argument, it does not cover incorporation of documents into pleadings by reference. It is also noteworthy that the spreadsheets and forensic reports which the petitioners claim to be incorporated into the petition by reference are actually documents prepared by the petitioner's witnesses. In other words, the spreadsheets and forensic reports are not documents which are outside the control of petitioners and which they have to obtain by subpoena. Being the petitioner's own documents, they ought to have served those documents along with petition on the respondents, so as to enable the respondent to counter say by engaging their own experts to appropriately respond to say if they so desire. That indeed is the essence of pleadings, so as to avoid taking the other party by surprise. Petitioners have also tried to argue that the respondents having joined issues on the general allegations contained in the petition, they are deemed to have understood safe. With respect, this is also not a tenable argument in view of the grossly generic allegations made in the petition. Faced with a similar scenario, this court, Gungumi Jujesi, as in then was now JSC, held in Utiaga and another was Omegara, as follows, and I quote, the argument of appellant's counsel that the respondents did not adequately traverse the petition is unfounded. The petition itself contained general complaints. There was no effort in point in the pleadings, the various places where corrupt practices, non-voting, use of violence, forgery, rigging in polling units, massive thumbprint and of ballot papers, fictitious entry of election results took place. Therefore, there was a general corresponding reply denying the allegations in general terms from the respondents. If the petitioners did not plead particulars, how could the respondents traverse non-existent particulars? The arguments in the appellant's pleadings should have contained details of the allegations and complaints which the respondents could reply in detail in their own pleadings. The appellants expected the respondents to reply to the various specific allegations contained in the witness statements filed along with the petition. That is not the correct procedure. Those specific allegations should have been in the pleadings. The pleadings must show the facts disputed, while the witnesses will give evidence of these facts. In election petitions, it has been held that there is the need for particulars where required in order to prevent taking adverse party by surprise. It is not the function of particulars to take the place of necessary arguments in pleadings, unquote. Indeed, in a presidential election like the one being challenged in this petition, where it was held in 176,846 polling units, 8,809 wards, 774 local government areas, 36 states and the Federal Capital Territory, it is unimaginable that arguments in the petition which merely allege irregularities and or malpractice without specifying the particular polling units or particular collation centers where the irregularities or malpractices have taken place will be regarded as proper merely because the respondent has not requested for further particulars. Ahmed and PDP. Also, when an election petition is by nature a declaratory action in which the petitioner succeeds only on the strength of his own case and not on the weakness of that of the respondent. Ibusari versus Adepoju, Oyetola versus Adeleke, and Anazong versus Olubogu, citations on. It is in this respect that the petitioner has an obligation to set up a clear, unambiguous, precise, and positive case in his pleadings, since pleadings is the foundation of the party's case, and it is to the pleadings that the parties to litigation, as well as the court, are all bound. See Enang and others was studied. It is in the light of all the foregoing that I find and hold that the motions of the respondents listed above succeed. In consequence, paragraphs 9, 60, 61, 66, 67, 68, 69, 70, 71, 72, 73, 76, 77, 78, 83, and 99 of the petition, which have failed to state the specific polling units, collation centers, or the specific places where the irregularities and malpractices are alleged to have occurred, or the figures of votes which are being claimed are grossly vague, imprecise, nebulous, and bereft of material particulars, and have thus failed to meet the requirements of paragraph 4, sub 1, sub D of the Electoral Act 2020. In accordance with paragraph 4, sub 7 of the said schedule, the said paragraphs are consequently hereby struck. On the first respondent's prayer, strike out paragraphs 57 and 58 of the petition for being inconsistent with paragraphs 65, 67, 70, and 71 of the petition. The essential contention of the first respondent is that while paragraph 57 and 58, whilst in paragraph 57 and 58 of the petitioners have alleged that the first respondent failed to comply with the order of inspection granted by the court. The petitioners have in paragraph 65, 67, 70, and 71 stated that they will rely on the report of the inspection. Additionally, the first respondent also argued that the first petitioners have alleged that the election was marred by corrupt practices and was not conducted in substantial compliance with Electoral Act 2022. They have also alleged that they have scored majority of no-free votes cast and should be declared the winner. Relying on some cases which are produced here, the first respondent urged the court to strike out the paragraphs as well as prayers 1 to 4 on the one hand, and prayers 5, sub 1 and sub 2 on the other hand, for being inconsistent. Firstly, the petitioners contend that the law allows them to plead conflicting facts insofar as they have claimed alternative reliefs. They refer to the alternative reliefs at pages 35 to 37 of the petition and rely on some cases which are reproduced, as well as the ruling on similar objection by the 2019 presidential election court in the previous case. As rightly submitted by the petitioners, the reliefs in this petition, which I have reproduced at the beginning of this ruling, are undoubtedly sought in the alternative. The settled law is that reliefs can be sought in the alternative, and where sought by a party is at liberty to plead conflicting facts in line with the alternative reliefs he has sought. In IDEJ versus Muagu and others, this court, Muagu Women's Justice, as it then was, held that, and I quote, in civil litigation and indeed in election matters, a party can make two seemingly contradictory pleadings, leading to two different heads of claim. That is why a petitioner can claim that the election be annulled for reason of substantial non-compliance and in the same breath claim that he won the election by a majority of votes. Petitioner may plead the same set of facts to ground alternative relief. Those pleadings are not so facto held to be self-contradictory. The court can only grant one relief as the party must decide which relief is best supported by the evidence on it. Unquote. Also, this metal construction West Africa Limited was awarded citation given. In any case, the first respondent, which is the body that conducted the election and to whom the first petitioner's nomination documents were submitted by the second petitioner, admitted in paragraph 4 of the petition, where the petitioners averred that the first petitioner was duly sponsored by the second petitioner, on whose platform the first petitioner contested. I therefore have no hesitation in countenancing this ground of objection. Now, second category of objections or applications. These are the categories that challenge the competence of the petition on some of its grounds. The second category of the respondents' applications that challenge some of the grounds of the petition and all the competence of the petitioner as follows. First, respondents' motion filed on the 19th of April 2023, seeking 1. Order striking out ground 2, paragraphs 333 to 79 and release 5, Roman 1 and 2 of the petition on transmission of election results for being cut off by issue S. 2. Order striking out paragraphs 20, Roman 1, 21, 23, 24, 25, 26, and 27 on nomination of the second and third respondents for lack of jurisdiction. Second and third respondents' motion filed on the 12th of May 2023 seeking for the following. 1. Order striking out or dismissing the petition for being incompetent and defective. 2. Order striking out grounds 1, 2, and 3 of the petition. 3. Order striking out release 1, Roman 1 to 3, 2, 3, 4, Roman 1 to 4, 5, Roman 1 and 2 of the petition. The above two motions are predicated on several grounds which are reproduced here. It is the view of this court that the issue relating to ground 1, challenging the qualification of the second respondent to contest the election, the issue relating to the competence of ground 2 relating to the allegations of corrupt practices and non-compliance of the Electoral Act 2022, and the plea of estoppel in relation thereto, as well as the issue relating to competence of the relief sought in this petition, are matters on which the parties have joined issues in the main petition, evidence laid in the petition. It is the settled position of law that a court should not comment on or decide at preliminary stage matters or issues which are supposed to be decided in the substantive case. See Nwanko and others versus Eraduan. Actually, on Onojo James, SAN versus INEC, citations on the record. Hence, while leaving those issues to be dealt with on the merits of the petition, we shall determine at this stage the objections relating to the petitioner's lawful standi, the non-joinder of necessary parties, and the objection to the competence of the petitioner's replies, the respondent's replies, quotes some paragraphs of the petitioner's replies. Lack of lawful standi of the first petitioner. The second and third respondents and the fourth respondents in this motion filed on the 8th of May 2023 also objected to the first petitioner's lawful standi to bring this petition. The principal contention is that the first petitioner was in contravention of section 77 sub 3 of the Electoral Act 2023. They argued that the first petitioner, who was a member of the People's Democratic Party and who was screened as one of its aspirants for the presidential election, only resigned his membership of that party on the 24th of May 2022, joined the second petitioner on the 27th of May 2022. They contended that as at 30th of April 2022, the first petitioner could not have been in the register of members of the second petitioner, which it submitted to the first respondent 30 days before the presidential primary election, as mandated by section 77 sub 3 of the Electoral Act 2022. And since the first petitioner is not in the membership register submitted by the first respondent to the first respondent by the second petitioner, the first petitioner lacks the local standard to challenge the outcome of the presidential election. Per contra, the petitioners submitted that the issue of membership of a political party is a domestic affair of the political party concerned, and the court lacks the jurisdiction to case. They relied on the cases that are reproduced. The courts have consistently held in a plethora of cases that the issue of membership of a political party is an internal affair of the political party. It is not a justiciable issue, and courts have no jurisdiction to interpret it. CNN versus Asufo and others, Sani and Galadima, and Tubido versus INEC, citations on the record, as well as all the cases cited above by the petition. The provision of section 77 sub 3 of the Electoral Act 2022, which only mandates every political party to submit the register of its members 30 days before its party primaries, cannot be invoked by the respondents for the purpose of challenging the first petitioner's membership of the second petitioner. It is only the second petitioner that has the sole prerogative of determining who are its members. And having sponsored the first petitioner as its candidate for the presidential election, the first petitioner has satisfied the requirement of being a member of the second petitioner as provided for in section 131 sub C of the 1999 Constitution. It is not within the rights of the second and third respondents and the fourth respondent to question the first petitioner's membership of the second petitioner. This ground of objection is hereby overruled. No enjoinder of necessary parties. The first respondent in his motion of 19th of April 2023 and the second and third respondents as well as the fourth respondent raised the issue of non-joinder of Abubakar Atiku or the People's Democratic Party, who came second in the presidential election as respondents to the election. The contention of the respondent then is that since by relief 1 Roman 3, 4 Roman 4, the petitioners who came third in the presidential election are seeking to be declared the winners of the election the petition cannot be effectually and completely determined without the joint of Abubakar Atiku or the People's Democratic Party, who came second in the election, as respondents to the petition. For that reason, the respondents have contended that this court lacks jurisdiction to maintain the petition as constituted. Buhari and Obasanjo citations on the record. In opposition, however, the petitioners relied on the cases of Obasanjo and Yar'Adua, Buhari and Yusuf, Akoti and INEC, and contended that only statutory respondents provided in Section 133 of the Electoral Act 2022 are necessary parties to the petition, and the petitioners are not under any obligation to join Abubakar Atiku and the People's Democratic Party. By Section 133 of the Electoral Act 2022, the statutory respondents in an election petition are 1. The person whose election is being complained of, and 2. The Independent National Electoral Commission, which will also be deemed to be defending the petition on behalf of its officers whose conduct is complained of. In the cases of Obasanjo and Yar'Adua, Buhari and Yusuf Supra, cited by the petitioners, the Supreme Court categorically held that only the statutory respondents stated in Section 133 of the Electoral Act are necessary parties, and that losers at an election who are not statutory respondents are not necessary parties to an election petition. By the import of Section 133 of the Electoral Act 2022, the contest in an election petition is strictly between the petitioner who challenges the outcome of the election, the person who was declared the winner of the election, and the commission that conducted and declared the outcome of the election. This means that every candidate who lost the election and who is desirous of challenging the outcome of the election is expected to file his own petition against the winner of the election, and in so doing is not required to join any other candidate who lost the election like himself. It is in furtherance of this that paragraph 50 of the first schedule to the Electoral Act 2022 requires an election tribunal or court to consolidate 2 or more petitions which are presented in relation to the same election or return. As rightly submitted by the petitioners, the case of JJ and INEC cited by the first respondent is clearly not applicable to this case, since the decision in that case is that Maimala Buni was a necessary party caused by the provisions of Section 183 of the 1999 Constitution would have ceased being a governor of Yobe State if the case made out in the petition that he could not combine the offices of governor of Yobe State and acting chairman of the All Progressive Congress is sustained. In this case, Abubakar Atiku and the People's Democratic Party, who were only runners-up in the presidential elections, are not necessary parties, as they are not statutory respondents to this petition, and the petitioners here have no obligation to join them in this petition. Again, in Buhari and Obasanjo Supra, relied upon by the respondents, the Supreme Court reconfirmed its decision in Buhari and Yusuf Supra that there is no obligation on the petitioner to make a candidate who lost an election like himself a respondent to his petition. Also, as in this case, Abubakar Atiku and the People's Democratic Party have filed a separate petition number CAPEPC 05-2023, which, as mentioned in the earlier part of the ruling, this court has consolidated with the petition in line with paragraph 50 of the first schedule to the Electoral Act 2022. This ground of objection to the competence of the petition is unmeritorious. It is accordingly overruled. On the arguments over the competence of the relief sought in this petition, it is my view that the relief which the court can grant in an election petition as statutory, as provided in Section 136 of 1 sub 2 sub 3 of the Electoral Act 2022. Therefore, the determination of whether the relief sought by a petitioner are grantable can only be made after trial. Challenge to competence of the petitioners applies. The third category of the applications of the respondents seek to strike out the petitioner's replies or some paragraphs of the replies. These are first respondent's motion filed on the 9th of May 2023 seeking 1. Order striking out the petitioner's reply to the first respondent's reply for being incompetent. 2. In the alternative, order striking out paragraphs 15, 16 Roman 1 to 7, 17 to 20, 22, 24, 25, 27 to 32, 34, 36, 37, 38, 40, and 41 of the petitioner's reply for offending the provisions of the first schedule to the Electoral Act. Second and third respondents' motion filed on the 13th of May 2023 seeking for order striking out petitioner's reply of 21st April 2023 for being incompetent. 2. In the alternative, order striking out paragraphs 8 to 17, 19 to 32, 34 to 42 of the petitioner's reply for introducing new facts. first respondent's motion filed on the 8th of May 2023 prays for 1. Order striking out paragraphs 15 to 32 of the petitioner's reply, the fourth respondent's reply, as well as the witness statement on oath, the failure to deny the fourth respondent's allegation. 2. Order striking out paragraphs 5 Roman 1 to 9, 15 Roman 1 to 7, 16 Roman 1 to 7, 17 Roman 1 to 7, 18 Roman 1 A to H, 18 Roman 2 A to E, 18 Roman 3, 5 and 7, A to B, A and B, Roman 8 A and B, Roman 9, Roman 11, 20 to 25, A to D, 26 Roman 1 and 2, 27 to 31 of the petitioner's reply to the fourth respondent's reply for raising new issues. All the respondents challenge the competence of the petitioner's reply to their respective replies or in the alternative the paragraph thereof, which they have variously listed above. Their essential contention is that the replies or in the alternative the paragraph thereof have either raised or introduced new facts aimed at substantially altering the grounds and reliefs in the petition, or a mere repetition or rehash of the facts contained in the petition, contrary to the provisions of section 16, paragraph 16, sub 1A and B of the first schedule to the Electoral Act 2020. The respondents replied on several judicial authorities, which are reproduced. In response, the petitioners have argued that they have merely reacted to the fresh/new issues raised in the replies of the respondents, which attempted to justify the grounds of non-qualification of the second and third respondents, as well as the non-compliance by the first respondent with the Electoral Act 2022. They relied on Silva and INEC, PDP versus Ezeomuka, citations on the record, and urged the court to discountenance the objections of the respondents and uphold the petitioner's replies. Now, paragraph 16, sub 1A of the first schedule to the Electoral Act 2022 provides as follows, and I quote, if a person in his reply to the election petition raises new issues or facts in defense of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, the petitioner's reply in answer to the new issues of fact. So, however, that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds or prayers to amend or add to the contents of the petition filed by him, unquote. By the import of paragraph 16 sub 1A of the first schedule, the petitioner may in filing a reply respond to allegations of new facts raised in a respondent's reply to the petition, provided he does not in so doing amend or add to the petition. It is instructive to observe that the words used in paragraph 16 1A are, quote, new facts, grounds or prayers tending to amend or add to the contents of the petition, unquote. The word new suggests something which is not there, while the word amend signifies modification. Add, on the other hand, means to increase. What the provision envisages, therefore, is that the reply of a petitioner must strictly be confined to the new facts raised in the respondent's reply and must not go over that to attempt to amend or add to the petition. See All Progressive Congress versus People's Democratic Party, Njadi and Wamako, Adepoju versus Awoduyilemi, and Ikoro versus Izunaso, citations on the record. Indeed, in succinctly explaining the new issue which should attract the reply, the Supreme Court had held in Ejesimba versus Onuzuriki as follows, and I quote, a new issue to attract a reply must in law be really new in the sense of being brand and fresh. The issue must be really new to the statement of claim, in that it was not existing therein and was therefore brought into existence or introduced for the first time in the statement of defense by the defendant. The new issue, in both its contents and materiality, must be further and additional to the statement of claim. Thus, the mere fact that a defendant states his own side of the case does not necessarily make it new, particularly when the plaintiff has told a contrary story in his statement of claim. In such a situation, the case stated by the defendant amounts to joining issues with the plaintiff, and that does not bear the name of a new issue in law. A new issue arises where the plaintiff did not avert to or touch the contents of the defendant's averments in anticipation, and the defendant's averment was introduced to the pleadings for the first time and therefore unique and novel to his pleadings, unquote. A careful examination of the petitioner's petition, the first, the second and third, and the fourth respondents' respective replies and the replies which the petitioners filed in response thereof reveals that apart from rehashing what they have already averred in their petition and denying what the respondents have stated in their respective replies, the petitioners also introduced new facts in their replies to the respondents' replies which were not contained in their petition. This is in clear contravention of paragraph 16 sub 1A of the first schedule to the Electoral Act 2020. Paragraph 16, 1 to the law as encapsulated in paragraph 16(1)(a) of the first schedule to the Electoral Act quoted above forbids new additions or amendments by a petitioner which are not contained in their petition, because such new additions or amendments will prejudice the respondents and breach the respondents' fundamental right to fair hearing, guaranteed by section 36(5) of the Constitution of the Federal Republic of Nigeria 1999, since the respondents will have no opportunity to respond to those new issues, additions or amendments. See PDP and another versus INEC and others, Maku and another versus Al-Makura and other citations on the record. An examination of the paragraph 4, Roman 3, Roman 4, and Roman 5 of the first respondent's reply shows that the paragraphs has not raised any new issue contrary to the assertion of the petitioners. In paragraph 15 of their reply, the first respondent's reply to the petition, it is only a response to paragraph 7 and 8 of the petition. But the petitioner's argument in the same paragraph 15 that the first respondents' officials at the polling units failed to give clear copies of the results of the election from ECHA to the petitioner's agents, as the pink copies given by the petitioner's agents were very faint and unreliable, is a new fact which tends to amend the petition. Paragraph 16, Roman 1 to 7, 17, second part of 18, 22, 24 of the first respondent's reply are traverse of paragraphs 21 to 27 of the petition. Hence, paragraph 16 of the petitioner's reply, which purport to respond to new issues in paragraph 17, 18, 19, 20, 21, 22, and 24 of the first respondent's reply, actually contain new facts, which will amount to amendment of the petition. Also, paragraphs 17, 18, 19, 24, 25, 27, 28, 29, 30, 31, 32, 34, 35, 36, and 37 of the petitioner's reply to the first respondent's reply are either a rehash of the facts already averred in the petition or contain new facts which amount to amendment of the petition. In respect of the petitioner's reply to the second and third respondent's reply to the petition, the latter are seeking for an order striking out paragraphs 8 to 42 of the petitioner's reply. However, a careful examination of those paragraphs shows that only paragraph 21 of that reply has raised a new allegation against the first respondent of attempts to manipulate the data uploaded on the back-end server of the AWS. The said paragraph 21 of the petitioner's reply to the second and third respondent's reply is hereby struck out. Similarly, petitioners have introduced new facts in paragraphs 16, 17, 18, 20, 22, 23, 24, 25, and 27 of their reply, some of which contain serious allegations to the fourth respondents, which the fourth respondents have no opportunity to respond. Being in contravention of paragraph 16 sub 1 of the first schedule to the Electoral Act, those paragraphs are also hereby struck out. And that indeed is the rulings on the respondents' objections, various objections.
Well, as I was trying to explain earlier before we went for the break, we will take all the judgments. After that, my learned brothers will now give their own decisions on the petitions in order to save time. Because the petitions are consolidated. So now we will go to the main petition, and petition number 3. In bringing this petition, the petitioners who were contestants in the presidential elections held on 26 February 2023 have challenged the declaration return of second respondent as the winner of the election and sought for the declaration and consequential reliefs, which I have reproduced in the beginning of this judgment. The petitioners have predicated their petition on the 3 statutory grounds earlier stated. Although in the ruling of this court on the objections of the respondents, some paragraphs of petition replies have been struck out for stated reasons, this court will take into consideration the entire variance in the petition in determining the merit or otherwise of the petition in the interest of justice. At trial, the petitioners opened their case with tendering from the bar several certified true copies of electoral and other documents which were objected to by all the respondents, who reserved the reasons for their objections to the stage of final address. The said objections were therefore admitted, the said documents were therefore admitted and marked as exhibits without prejudice to the objections of the respondents. The court ordered the respondents to file separate addresses on their objections along with their final addresses. In proof of their petition, the petitioners called 13 witnesses who gave evidence as PW1 to PW13. Of those witnesses, only 3 had their witness statements on oath filed along with the petition, while the other 10 were subpoenaed witnesses whose statements were filed separately after hearing in the petition had commenced. The respondents objected to the competence of the subpoenaed witnesses to give evidence and adopt their addresses, witness statements on oath, and reserve the rulings for their objection to the stage of final address. Without prejudice to the objection, the said witnesses adopted their respective witnesses' statement on oath, after which they were duly cross-examined by all the senior counsel for the respondents. Upon closure of the petitioner's case, the first respondent as well as the second and third respondents called one witness each in their defense. The fourth respondent did not call any witness, but opted to rely on the evidence already adduced by the other respondents that elicited under cross-examination on behalf of the fourth respondent. At the close of evidence, parties filed and exchanged their respective final addresses, including separate addresses in support of their various objections which they raised during trial. So we shall now consider respondents' objections to the competence of some of the petition witnesses and to the documents tendered by them during trial. To save time, we'll skip the addresses of counsel and we'll go to the resolution of those issues. Of the respondent's objection to witnesses and documents contained in page 84 of the judgment. On the first segment of the respondent's objection, all the respondents challenged the competence of PW3, PW4, PW5, PW6, 7, 8, 9, 10, 11, and 13. And the respondent's essential contention is that the witness statements on oath whose witnesses on both of those witnesses of the petitioners were not loaded along with the petition, but were only filed during trial, contrary to paragraph 4, sub 5b of the first schedule to the Electoral Act 2022. Section 285, sub 5 of the 1999 Constitution as amended, which limits the time for presidential election petition, provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. In the same vein, Section 132, sub 7 of the Electoral Act 2022 provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. Paragraph 4 of the first schedule to the Electoral Act 2022 stipulates the contents of an election petition which shall be filed. In particular, paragraph 4.5 of the said schedule mandates as follows. The election petition shall be accompanied by A list of the witnesses that the petitioner intends to call in proof of the petition, B, B. Written statements on oath of the witnesses. And C. Copies or list of every document to be relied on at the hearing of the petition. But subparagraph 6 of that paragraph, a petition which fails to comply with the above requirements shall not be accepted for filing by the Secretary. Paragraph 14 sub 2 of the same first schedule to the Electoral Act then provides as follows. After the expiration of the time limited by A. Section 132 sub 7 of this Act for presentation of the election petition, no amendment shall be made. 1. Introducing any of the requirements of paragraph 44(1) contained in the original election petition file, or 2. Effecting a substantial alteration of the ground for or the prayer in the election petition, or 3. Except anything which may be done under subparagraph 2A to Roman 2 affecting a substantial alteration of or addition to the statements of fact relied on to support the ground for or sustain the prayer in the election petition. And sub B, paragraph 12, for filing the reply, no amendment shall be made. 1. Alleging that the claim of the seat or office by the petitioner is correct or false. 2. Except anything which may be done under the provisions of paragraph 2A, Roman 2, effecting any substantial alteration to, in or addition to the admissions or the denials contained in the original reply file or to the facts set out in the reply. The above provisions of the Constitution, Electoral Act 2022, and the first schedule thereto have been thoroughly considered by the Supreme Court in several cases, including Okian, another versus Mimiko and others, by Ogumbi JC, Oba, and Vincent Ararume and others, and Anne, Okuru, Ogi and others, PDP and Oku and several others listed here. In Oke and Mimiko, the upper Apex Court by Ogumbi JC held as follows in court. By paragraph 4, 1 and 5 of the first schedule to the Electoral Act, the composite analysis of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive, mandatory, conclusive. In other words, the provisions do not allow for additions, and hence, the procedure adopted by the appellants in seeking for an extension of time is nothing other than surreptitious attempt to amend the petition. This is obvious from the nature and substance of the application, especially where one of the grounds seeks to put in facts which are allegedly not available at the time of filing the petition, but only came into their possession after the statutory time limits allowed for the presentation of election petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, video paragraph 14(2) of the first schedule to the Electoral Act, the appellant by section 134 sub 1 of the Electoral Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. The saying is true that even the devil does not know a man's intention. It can only be inferred from the act exhibiting that which is conceived in the heart and mind. The use of the word shall in paragraph 14 sub 2A of the first schedule to the Electoral Act is mandatory and places a complete bar on any form of amendment to a petition file and does not allow for an exercise of discretion whatsoever. Further still, on a critical result of the application, relief 2, 6 court seek to call additional witness to which AEO. It is pertinent to state that at the close of pleadings, parties have submitted the list of witnesses who were to testify together with their depositions. The idea, purpose, and intention of the application is suggestive of nothing more but a clear confirmation seeking for an order of an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions section 285(5) of the Constitution and section 134 of the Electoral Act, close of court. In his concurring judgment in the same case, Nguta JSC specifically stated as follows, I quote, the additional or further witness depositions sought to be allowed for a just and fair determination of the petition are fresh facts as found by the tribunal, and which finding was endorsed by the lower court. This court will not interfere with the concurrent finding of fact of the two lower courts when the appellants have failed to show a special circumstance for this court to do so. Election petitions are time-bound, and the court will not allow a party to resort to any sort of subterfuge or to frustrate the intention of the Electoral Act that petitions be disposed of expeditiously. The petitioners in this case have relied on the earlier decisions of this court in Omidiran versus Ete and Lasun versus Awoyemi Supra to argue that the subpoena witnesses whose witness statements on oath were filed outside the time limited for the presentation of the petition are competent to testify because that they are subpoena witnesses who do not work for the petitioners. However, it is pertinent to observe that unlike in the present case, the subpoenas issued at the instance of petitioner in the case of Omidiran and Ete and Lasun versus Awoyomi were decided under the Electoral Act of 2006, which did not have provisions similar to paragraph 4 sub 5 of the first schedule to the External Electoral Act 2022. Secondly, the subpoenas in the above two cases were issued and served on adversaries, namely the resident electoral commissioners. Again, those two cases were decided before the introduction of section 285 subsection 6 of the Constitution of Federal Republic of Nigeria 1999, which mandates that an election petition shall be decided within 180 days from the date of filing of the petition. Thus, whilst this court in Omidiran and Ete and Lasun versus Awoyomi appeared to have adopted a flexible approach, the Apex Court had taken a strict approach in its later decision in Oke and Mimiko. Indeed, in subsequent following the Apex Court's decision in Oke and Mimiko, this court, per Agim JCA, as he then was, now JSC, highlighted this strict position of the law in Ogba versus Vincent at paragraph 46 to 48, paragraph A to B, wherein he held as follows, I quote, I think that this court in Omidiran and Ete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether a tribunal or court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election petition proceeding. Omidiran's case did not strictly enforce the time limits prescribed in section 141 of the Electoral Act 2006. The provision in the first schedule thereto on prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings, and paragraph 1 sub 1 of the Election Tribunal and Court Practice Directions of 2006 on the content and form of the petition. It held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rule where applicable. This elastic application of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the Electoral Tribunal and Court Practice Directions as overriding the rules of court in election court cases. In Oke and Mimiko, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The Supreme Court has consistently, in a long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. The law has laid out testima juris in Oke and Mimiko is that a witness deposition that is not filed along with the petition within the 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus, if there was an evidence which was fundamental to determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time limit specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition. Even if it has been withheld by any person, there are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this. The petitioners ought to have restored to that procedure, laws of court. The firm position of the Supreme Court, as stated in Ocha Mimiko and followed by this court in Oba and Vincent Supra, is that by the combined provisions of Section 2855 of the 1999 Constitution, Section 137, Subsection 7 of the Electoral 2022, and paragraph 4, 5, and 6 of and 14.2 of the first schedule to the Act, every written statement on oath of the witness which a party intends to call must be filed along with the petition within the time limited by Section 2855 of the Constitution of the Federal Republic of Nigeria as amended, and Section 132, Subsection 7 of the Electoral Act 2022. Once the time limited for filing of a petition has elapsed, the contents of the petition cannot be added to or amended in any manner or under any guise. Any written statement on oath of the witness filed outside that 21 days limitation will amount to a surreptitious amendment of the petition and a breach of paragraph 14 of the first schedule to the Electoral Act 2022. This is irrespective of whether the witnesses to be called are ordinary or expert witnesses and whether they are willing or supine witnesses. Since then, this has been the consistent position of the law followed by this court. Indeed, in Okuru versus Obe, this court stressed this position by our learned brother Bolaji Yusuf Jesse stated as a quote. From the records, PW3 and PW4 was summoned by subpoena issued by the tribunal and presented as expert witnesses. The question is whether this without more entitles the appellant to file their statements on oath outside the time set for filing a petition. Or a reply to the respondent's reply in answer to the petition. Of the humble view that whether an expert witness or not, a witness remains a witness. Though the proviso to Order 3, Rule 3, Sub 1 of the Federal High Court Civil Procedure Rules 2009 made applicable to an election petition by paragraph 54 the first schedule to the Electoral Act provides that the statements on oath of witnesses requiring subpoena from the court need not be filed at the commencement of the suit. 2. The witnesses who require subpoena or summons shall, at the instance of the party calling them, deserve receivable from 1A before the filing of the statements of such witness. The application of that rule is with regard to and or subject to the provisions of the Electoral Act, not independent of the Act. Paragraph 54 reads, subject to the express provisions of this Act, the practice and procedure of the tribunal or the court in relation to an election petition shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modifications as may be necessary to render them applicable having regard to the provisions of this Act, as if the petitioner and the respondent were respectively the plaintiff and the defendant in an ordinary civil action. The provisions of the Electoral Act being a substantive law shall override any rule of court which is contrary to its provision. The subsidiary legislation must conform with the principal law, CNNPC and Afamfa Oil Limited. The proviso to Order 3, Rule 3.1 of the Federal High Court Rules 2009 cannot override or affect or whittle down the absolute and mandated provisions of Section 285, Sub 5 of the Constitution of the Federal Republic of Nigeria as 1999 as amended, which stipulates that an election petition shall be filed within 21 days after the date of the declaration of the result of the elections, and paragraphs 4, Sub 1, 5, and 14.1 and 2 of the first schedule to the Electoral Act, which stipulate the content of a petition. It is therefore clear that in law, the provisions of Order 3, Rules 3.1 of the Federal High Court Civil Procedure Rules 2009 cannot provide a platform for filing and using witness statements on oath not filed within the time set for presentation of petition, and which time cannot be extended for any reason under any guise. The focus of our decision in Ogba and Vincent Supra was the injustice in allowing a piece of evidence not covered by the pleadings to be presented to the court when the opposing party would have no opportunity to react to it. It is my humble view that the position of the law, as can be gleaned from the section 2855 of the Constitution, paragraph 4, 14.2 and 16.1 of the First Schedule to the Electoral Act, is that a petitioner cannot be allowed to file and use documents or witness statements on oath filed outside the time set for filing petition, and to which the respondents would have no opportunity to react. To do so will amount to creating an avenue which a petitioner can use or exploit to overreach the respondents. That is the stand of the Supreme Court in Oke and Mimiko, number 1 Supra, followed by this court in Oba and Vincent Supra, close of court. Again, in Ararume and another, but Anik and others, in which I wrote the lead judgment, therein are stated as follows. The law, therefore, is that the deposition of a witness must accompany the petition at the time of filing the petition. In other words, the written statement on oath of an intended witness must be filed along with the petition. Thus, any written deposition of a witness not filed along with the petition will not be countenanced by the court or tribunal. It therefore means that a written deposition filed by a witness not listed in the petition nor his deposition front-loaded cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. I think that is what the tribunal decided in this case, in line with the decision in Oba and Vincent. The combined effect of paragraph 4.5, Roman 1 and 2, 14.1 and 3 of the First Schedule to the Electoral Act is that no witness can testify in chief before a tribunal if he has not deposed a written statement on oath, which must necessarily have been filed along with the petition, close of court. From the foregoing judicial decisions, it is clear that in election petition litigation, whether the witnesses which a party intends to call are ordinary or aspire witnesses, and whether they are willing or supine witnesses, their witness deposition must be filed along with petition before such witnesses will be competent to testify before the tribunal or court. It is instructive to observe that one of the leading senior counsel for the petitioners in this petition, Dr. Onyechi Ipiazu, SAN, was the lead counsel to the second respondent in Ararume and another versus Anik and others, wherein he successfully challenged the competence of a subpoena witness, Ama Ibom Abu, PW2, on the same ground that the witness statement on oath of the same witness was filed on 8/7/2019, long after the time limited for the filing of the petition. Therefore, the petitioners in this case were well aware of the settled legal position on subpoena witnesses in election petitions, stated by the Supreme Court and by this court. Yet they embarked on subpoenaing PW3, PW4, PW5, PW6, PW7, 8, 9, 10, 11, and 13. 10 out of their 13 witnesses, whose witness statements on oath were not front-loaded along with the petition. The petitioners have tried to argue that the said witnesses are witnesses of this court. With respect, this argument is misconceived because the subpoena in respect of those witnesses were issued upon the request of the petitioners. The application for the issuance of the subpoenas were duly signed filed at the registry of this court by the petitioner counsel, and the requisite fees paid, including filing fees and service fees as assessed, were duly paid by them before this court approved and issued the subpoenas. Therefore, those witnesses are the petitioner witnesses and not witnesses of this court. Indeed, the procedure for calling of witnesses by the court is by short summons as stipulated in paragraph 42, sub 1 of the First Schedule to the Electoral Act 2022. By the provisions of that paragraph, the tribunal or court may summon a witness as a witness who appears to the tribunal or court to have been concerned in the election. It is clear from the provisions of that paragraph that it is a person summoned by the court suo motu in exercise of his powers under paragraph 42(1), that is a witness of the court and not a person subpoenaed at the request of a party to the case. In the instant case, PW3, who was subpoenaed at the request of the petitioners, is a staff of Channels Television who tendered exhibits PBH3 and PBH4, 2 flash drives containing third annex consultative meeting with leaders of political parties held on 26 October 2022, an interview with Mr. Festus Okoye, National Annual Commissioner, held on 12 March 2023, respectively. PW4, a professor of mathematics who was engaged before the election by the petitioners and whom the petitioners presented as a subpoenaed expert witness, stated under cross-examination by the first respondent that he concluded his report on the 19th of March 2023 before the petition was filed. PW5 is the staff of Arise Television who also tendered exhibit PCG2, a flash drive showing the INEC chairman delivering an address at the Chatham House, London, UK, on the preparations for the 2023 election in Nigeria. PW6 is the staff of African Independent Television, AIT, who tendered exhibit PCH1, a flash drive of the program Democracy Today, anchored on 22nd November 2022, wherein the INEC chairman was shown giving a brief on the preparations for the 2023 general elections. PW7, who claimed to be a cloud engineer and architect working with Amazon Web Services Incorporated, tendered exhibits PCJ3A to F, which are 6 reports of Amazon Web Services AWS Health Dashboard, which she said she downloaded from the Amazon website. Under cross-examination, however, she not only admitted that she is a member of the second petitioner. Let us be serious, please. This is a serious matter, not a laughing matter. She not only admitted that she is a member of the second petitioner, the Labour Party, but she had contested elections as a candidate for the second petitioner for House of Representatives elections, conducted along with the present elections on 25th February 2023. PW8, who claimed to be a cybersecurity expert engaged by the Labour Party on 10th March 2023, stated that he produced his preliminary report on 17th or 18th March 2023 before the petition was filed. He tendered exhibit PCK1, a metadata. PW9, a staff of Women and Child Rescue Initiative, a non-governmental organization, claimed to be an observer in the 25th February 2023 elections, but stated that the subpoena was addressed to him personally and served at his village address. PW10 claimed to be an annual ad hoc staff who acted as a supervisor. He stated under cross-examination that the subpoena was addressed to him personally and not through INEC. PW11, who is a staff in the Legal Services Department of National Information Technology Department Agency, NIDDA, stated that the subpoena was addressed to him personally instead of his organization. As for PW13, who claimed to have acted as a presiding officer in the 25th February 2023 elections, he stated that he was on a subpoena. The subpoena, which was admitted as exhibit PCR, was however addressed to him personally and not through INEC. It is pertinent to observe that the above 10 witnesses subpoenaed by the petitioners were all witnesses who were available to the petitioners at the time of filing the petition. They were neither subpoenaed as adversaries nor subpoenaed as official witnesses. It is therefore beyond controversy that the witness statements on oath of those witnesses filed after the time limited for presentation of the petition had lapsed are incompetent, and the same witnesses had no virus to testify in this petition. Their testimonies are embodied in their respective witness statements on oath. Being incompetent are accordingly struck out. With regard to the respondents' objections to the admissibility of documents tendered by the petitioners, the first objection raised by the respondents is to exhibits tendered through PW4, as to exhibits tendered through PW4, 5, 6, 7, 8, and 8. These are exhibits PCD1, PCD2, PCD3, PCE1, PCE2, PCE3, PCE4, and PEF2, Tender 3 PW4. Exhibits PCG1 and PCG2, Tender 3 through PW5. Exhibit PCH1, Tender through PW6. Exhibits PCJ1, PCJ2, PCJ3, A to F, and PCJ4, Tender through PW7. And exhibits PCK1 and PCK2, Tender through PW8. The said exhibits I have estimated them in this judgment. The respondents' essential argument is that since the subpoenaed witnesses and their witness statements on oath are incompetent, the documents tendered through those witnesses cannot be countenanced by the court. By paragraph 41(3) of the first schedule to the Electoral Act 2020, oral examination of witnesses is not allowed. Witnesses are only to adopt their respective written depositions and tender in evidence all disputed documents or other exhibits referred to in their depositions. By paragraph 4(5)(b) of the schedule, such written depositions of the witnesses must be filed along with the petition. Since the above exhibits are documents including expert reports which were tendered through the subpoenaed witnesses whom we have already declared incompetent because their witness statements on oath were filed in violation of the mandatory provisions of paragraph 4(5)(d) of the first schedule of the Electoral Act 2022, the documents admitted through them which form part of their evidence are inadmissible and liable to be exchanged from the record. See the case of Buhari and INEC. The petitioners have also argued that since the parties have agreed during pre-hearing session that documents properly certified by INEC will not be objected to, and the said documents were tendered from the bar pursuant to pre-hearing order of this court of 23rd May 2023. The parties are bound by the order of the court, since same has not been appealed against by the second and third respondents. However, this contention of the petitioners does not represent the position of the law. It is stated that a court is not permitted in any event to admit an act on it is stated that a court permitted to act in any event to admit an act on legally inadmissible evidence, even if such evidence had been admitted by agreement of the parties or under order of court in the course of hearing. Once such evidence is legally inadmissible, the court must reject it when giving its final judgment, even if that will amount to overruling itself by so doing. Ishanu and Afribank by OY4 JSC. Indeed, even in the case of Sani and Akwe, relied upon by the petitioners, this court at paragraph 20, paragraph BPA, restated the position of the law that even when pieces of evidence had been improperly receiving evidence, the trial court as well as appellate court have the power to expunge it from the record and decide the case only on legally admissible evidence. On the objection of the respondents to the admissibility of the documents tendered as expert reports by the petitioners, which were admitted as exhibits PCD1 to PCD3, PCE1 to PCE4, PCJ2, PCJ3A to F, and PCK1, the respondent's contention is that they are caught up by the provisions of Section 83, subsection 3 of the Evidence Act 2011, having been contrived for the purpose of this petition. It is settled law that as provided in Section 83, subsection 3 of the Evidence Act 2011 and pronounced upon in several decisions of the appellate court that a document which is made by a party interested in a pending or anticipated proceeding involving a dispute as to any fact which the document tends to establish is inadmissible in evidence. Thus, in Latoja and Ajimobi, where the Supreme Court, by Peter Odili, JSC held as follows, I quote, in respect of what is referred to as a person interested, I shall refer to the cases of Nigeria Social Insurance Trust versus Clifco, Nigeria Limited. As regards to the phrase, a person interested, I agree with the respondent that the phrase has been examined in the case of Ivan versus Noble, where a person not interested in the outcome of an action has been described as a person who has no temptation to depart from the truth, one side or the other. A person not swayed by personal interest, but completely detached, judicial, impartial, independent. In other words, it contemplates that the person must be detached, independent, and non-participant, and really not interested which way in the context the case goes. Normally, a person who is performing an act in official capacity cannot be a person interested under Section 91, subsection 3, which is now the Section 83.3. I think the phrase, a person interested, ever more so has been quite definitely put in the case of Halton and Halton to mean a person who has pecuniary or other material interest in the result of the proceeding, a person whose interest is affected by the result of the proceedings and therefore would have no temptation to pervert the truth to serve his personal or private ends. It does not mean an interest in the sense of intellectual observation or an interest purely due to sympathy. It means an interest in the legal sense, which imposes something to be gained or lost. CPC and Ombugadu, when considering and determine who is a person interested under Section 91.3 of the Evidence and Truth and Health does. By the provision of Section 91.3 Evidence Act, a person interested is a person who has a pecuniary or other material interest and is affected by the result of the proceeding and therefore will have have a temptation to pervert the truth to serve his personal or private ends. In fact, it is in its most recent decision in Oyetola and another versus Anek, the Supreme Court, by Ajim JSC, restated this position in the following words. The other evidence adduced by the appellant to prove their case is the expert analysis report prepared by PW1, who by his own admission is a member of the second appellant and had been a special assistant to the first appellant and was engaged by the appellants to establish the invalidity of the disputed results in Form EC8A for the 744 polling units. It is filed further that I made the report as directed by the petitioners and that I am part of those who wrote the petition. By his own testimony, he established that he was not an independent expert, as he had an interest in the subject of his analysis and carried out the analysis from the conclusion that the results were invalid to justify to support the contemplated election petition. It was an analysis from an answer and not from a question. Such a report is not the product of an independent, impartial, detached, and professional analysis. He is clearly a person with the disposition or temptation to depart from the truth. The listing of the expert analysis report in the petition among the documents to be relied on to prove the petition it was made in anticipation of contemplation to be filed. The report having been made by PW1 as a person interested in the subject matter of the petition, when the petition was anticipated to establish that the election result was invalid, is not admissible evidence by virtue of Section 83.3 of the Evidence Act 2011 as amended. Close of court. In the instant case, PW4, who claimed to be an expert, was contracted by the petitioners before the election to carry out data analysis on the results of the presidential elections held on 25th February 2023. He even tendered his letter of engagement by a second petitioner dated 20th February 2023, which was admitted as Exhibit PCF2. According to him, he produced his initial report on 19th March 2023. His report was made a day before this petition was filed, on 20th March 2023. Obviously, the report Exhibit PCD1 to PCD3 was prepared in anticipation of this petition. As for PW7, who also claimed to be an expert witness. She admitted that she was not only a member of the second petitioner, but had contested the House of Representatives election under the platform of the second petitioner, which election was conducted the same day with the presidential election on the 25th of February 2023. She also admitted that the report she presented in exhibits PCJ A to F are public information hosted by Amazon, which she downloaded from the Amazon website, and that the open access information she downloaded in her report cannot be amended by her. This shows that PW7 was clearly not the maker of the said documents. As for PW8, who claimed to be a cybersecurity expert, he stated under cross-examination by the first respondent that he was engaged by the second petitioner as an expert on 10th March 2023, and that he produced a preliminary report on 17th and 18th of March 2023, and final report, Exhibit PCK1, at the end of May 2023, while this proceeding was pending. It is therefore evident from the above that PW4, PW7, and PW8 are personally interested in the outcome of these proceedings. The reports produced by PW4 and PW8 qualify as statements made by persons interested in anticipation or during the pendency of this petition. As for PW7, she is admittedly an interested party, having been a member of and even contested election under the umbrella of the second petitioner. Her interest is further underscored by the fact that she admitted under cross-examination that she was attending court throughout the proceedings prior to her evidence. By virtue of Section 83, Sub 3 of the Evidence Act 2011, the reports tendered by those witnesses which form part of their evidence are inadmissible. In view of the foregoing, exhibits PCD 1 to PCD 3, PCE 1 to PCE 4, PCF to PCG 2, PCH 1, PCJ 1, PCJ 2, PCJ 3 A to F, PCJ 4, PCK 1, and PCK 4 tendered through the incompetent PW 4, 5, 6, 7, and 8 are hereby extant from the record of this court. The second aspect of the respondent's objection is on the ground of improper certification or authentication. On the second respondent's objection to exhibit PBP1 to PBP21, the IRF report for Adamawa State on the ground that no certificate of authentication of those computer-generated documents was filed in compliance with Section 84 of the Evidence Act 2011. Exhibit PCB1 to PCB6 referred to by the petitioners in response to the objection are IRF certificates of compliance for Bayelsa, Benue, Ekiti, Niger, Ogun, and Rivers states. Adamawa State is not included in those exhibits. Exhibit PCC1 to PCC28, which include Adamawa State, are actually Beavers reports and their certificates of compliance. That of Adamawa is PCC21. In short, no certificate of compliance was produced by the first respondent in respect of exhibits PBP1 to PBP21. The blank IRF reports exhibits ECA series in respect of Adamawa State. However, since the documents were stated to have been downloaded from ANEC's IRF portal and were certified by ANEC as true copies of what they have in their IRF portal, the documents qualify as public documents within the meaning of Section 102 of the Evidence Act 2011, and the certification by ANEC authenticates those documents. Therefore, the provision of Section 84 of the Evidence Act is not applicable in this case. This is the position of the law as espoused by the Supreme Court in the case of Kubo and Dixie, where the Apex Court held that the computers from Internet institution is a public document, and only a copy of such document which is duly certified in compliance with Section 104 of the Evidence Act 2011 is admissible. With that, I've cited the victim of the Supreme Court by Akas JSC in support. exhibits PBP1 to PBP21 having been downloaded from ANIC report and duly certified by ANIC are clearly admissible. As for the fourth respondent's objection to exhibit PCG2, the flash drive tendered by PW5, staff of Arise TV, it is clear that the said witness had in paragraph 6 to 12 of his witness statement on oath not only stated that he participated in all stages of the recording, production and packaging of the flash drive, but he had certified the process of his production as required by Section 84 of the Evidence Act. On the fourth respondent's objection to the admissibility of Exhibit X2, on the ground that the Exhibit X2 was obtained by the petitioner from the registrar of this court and not from the custodian of the original copy, we have examined Exhibit X2, which is the European Union Election Observation Mission Nigeria 2020 final report, as rightly observed by the fourth respondent. The photocopy of the document is certified by the Secretary of the Presidential Election Petition Court and not any officer of the European Union Election Observation Mission, which is the custodian of the original copy of the document. By Section 104(1) of the Evidence Act 2011, the secondary evidence of any public document is only admissible in evidence if it has been certified by a public officer having custody of the original copy of the document, who by that section may give a copy of same to any person who has a right to inspect, together with a certificate written at the foot of such copy that it is a true copy of such document or part of it as the case may be. Under subsection 2 of that section, the public officer is enjoined to certify the same by subscribing his name, official title and date, and why he is authorized to use a seal with his seal. Clearly, the registrar of this court, who is not the custodian of the original copy of Exhibit X2, cannot validly certify that document under Section 104(1) of the Evidence Act 2011. See Omiseri and Arebeshola, Emmanuel vs. Umana, where JSC stated that the whole essence of the court's insistence on the scrupulous adherence to the certification requirements of public documents is to vouchsafe their authenticity vis-a-vis the original copies. Since Exhibit X2 has not been validly certified, it is inadmissible in evidence. Accordingly, Exhibit X2 stands for expunged from the record. The third aspect of the petitioner's objection to the petitioner's document is on the ground that the petitioners failed to plead specific facts to cover the documents objected to. The said documents objected to by the respondents are exhibits. There are so many, they have been listed in this judgment. Get the judgment, you will see them. I have carefully examined the petitioner's pleadings and the documents objected to by the respondents. The petitioners have specifically averred in paragraph 101 of the petition that they will be relying on all the first respondents' electoral and all other necessary documents used for the conduct of the presidential election, including the documents which they listed as items A to CCC of that paragraph. However, election petitions are sui generis, and it is certain that for an averment in an election petition to be competent, material facts relating to complaints made therein must be pleaded. The Belgore and Ahmed, the Piazzu and Oti. In the latter case of PDP and ANIC, the Supreme Court was categorical on this mandatory requirement or specificity in averments of election petitions when the court held as follows. On whether the affected paragraphs were rightly struck out, I have read the affected paragraphs and found that they relate to allegations of non-voting in several polling points, disruption of election, non-conclusion of election, some printing of ballot papers, falsification of election results, widespread disruption, irregularities and malpractice without providing particulars or the polling units where the alleged malpractice took place. The lower court was therefore right when it held as follows. The paragraphs above, in my view, are too generic, vague, and lacking in any particulars, as they are not tied specifically to any particular polling unit or any particular number of people who were alleged to be disenfranchised. The fact that a party can file further particulars or deny in a reply the averment in the pleading must not be general, it must be specific as to fact. It is certain law that a petitioner's obligation to plead particulars of fraud or falsification, without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above. I adopt it as mine. Close of court. That's where allegations of non-compliance and corrupt practices are made, such as in the instant petition, the polling units, wards, or other places where those irregularities and malpractices are alleged to have occurred must be specifically pleaded. The petitioners have argued that the issue of non-compliance by the first responder to his laws, guidelines, and relevant statutes is a universal complaint because it is an infraction against the Nigerian people and the Nigerian state. However, this contention of the petitioners is not in consonance with the requirement of the law as espoused in Belgore and Ahmed, PDP and INEC. This is more so as the petitioner's allegations of non-compliance is interwoven with allegations of corrupt practice, and the same set of facts are pleaded for both. In the instant case, the petitioner tendered the following documents, which have been listed in this judgment. However, a look at the entire petition shows that no single petition complaint was made by the petitioners in respect of any of those states as to make those exhibits relevant to the petitioner's case. For instance, in paragraph 72, to which the petitioners referred in response to the objection, the petitioners have alleged that there was overvoting in the states of Ekiti, Oyo, Ondo, Taraba, Osun, Kano, Rivers, Borno, Katsina, Kwara, Gombe, Yobe, and Niger states. However, the petitioners failed to specify the polling units where the overvoting took place, the total number of accredited voters, the total number of votes cast, and the number of votes to be deducted from the scores of the parties. Similarly, in paragraph 73, which was also referred to by the petitioners in their response to the objection, the petitioners have averred that based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process for computation of the result and disfavored the petitioners, and listed the states of Rivers, Lagos, Taraba, Benue, Adama, Imo, Bauchi, Borno, Kaduna, Plateau, and other states of federation. But the petitioners failed to state the scores improperly computed and how they were disfavored. As regards the objection to exhibits PCE1 to PCE4, said to be 18,084 and 88 blood results downloaded from RF and contained in 4 boxes, the petitioners have contended that the petitioners' request for the petitioners to specify the 18,088 polling units to which those blood reports relate is an impossibility because the results are unreadable and the details of most of the polling units are stated in exhibit PCD1 to PCD3, the expert report tendered by PW4. This contention of the petitioners is, however, misconceived. This is because the petitioners who claim that they could not specify the polling units in the 18,088 blood results because those results are unreadable are the same persons who have stated that the said polling units have been specified in the expert report or PW4, through whom the blood results were tendered. However, PW4 stated under cross-examination that the primary source of the data he used in producing his report was the IRF portal. Did not state how he was able to determine the particular polling units and the impacted votes, accredited voters, and the number of PVCs collected. As I earlier noted, PW4's report was concluded on 19th March 2023 before the petitioners filed this petition on 20th March 2023, which means the petitioners were aware of the polling units to which their complaints relate even before they filed the petition. So their theory of impossibility, which they invented around the 18,088 blood results, is misconceived and an obvious misadventure. Again, in paragraphs 7 and 8 of the petition, the petitioners admitted that they have agents in the polling units, and those agents signed and collected duplicate copies of the result sheets. Those paragraphs read as follows. Paragraph 7. The petitioner is a body corporate with perpetual succession and in sponsorship of the first petitioner, and the conduct of the election thereby acted through its members duly appointed as agents at all stages of the election, namely at the polling units, the ward collation centers, the local government collation centers, the state collation centers, and the ultimate collation center at the federal level in Abuja. Paragraph 8. In the conduct of the election, the agents duly appointed by the petitioners performed their assigned and statutorily designated roles at the election. These roles included observing and monitoring the process of arrival of election materials where they were supplied by the first respondent, and leading to and including the process of accreditation, voting, counting of votes, and announcement of the results of the election. These agents were the election proceeded in due form upon the first respondent agent duly entering the results in the result sheets at the polling units, signed and collected duplicate copies of the result sheets. Having clearly admitted that their agents signed and collected duplicate copies of the result sheets, their contention that they are unable to determine the polling units from which the blood results emanated is untrue. In fact, this admission reinforces the need for the petitioners to specify all the polling units in respect of which they made complaints, since their agents were availed with copies of the results of the polling units. As regards the petitioners' contention that they have complied with paragraphs 4, 5C, and 41A of the first schedule to the Electoral Act 2022, I had earlier considered this argument of the petitioner while resolving the corresponding objection to petitioner pleadings, wherein we held that the provision of paragraph 4, 5C of the first schedule to the Electoral Act 2022 only relates to the front-loading of documents to be relied upon by the petitioners as their evidence during trial. It does not obviate the mandatory requirement for pleading materials as stated in paragraph 41(1)(d) and 2 and 41(8) of the same schedule, so as to enable the adverse party to know the exact case he is to meet and to respond to same accordingly. As I stated in my earlier ruling, the reports which the petitioner stated they had detailed the polling units was not filed along with the petition, so as to afford the respondent the opportunity to respond to same, but was merely tendered at trial, by which time the respondents had no opportunity to respond. Since the petitioners have failed to specify in the petition the polling units to which exhibits PCA1 to PCA4, the 18,088 ballot results relate, the said documents are clearly inadmissible. The said exhibits are hereby discountenanced and expunged from the record. We now go to petitioner objections to the respondents' documents. In the course of trial, the petitioner also objected to the documents tendered by the first and second and third respondents at the hearing of the 4th of July 2023. The first respondent had tendered exhibits RA1, RA2, RA3, RA4, F5, 6, and 7 through his sole witness, Dr. Lawrence Bayode, a deputy director in the ICT department of the first respondent, who gave evidence as RW1. Of those documents, the petitioners had objected to the admissibility of exhibits RA1, RA2, RA6, and RA7. Similarly, at the hearing of the 5th of July 2023, the petitioners had objected to all the documents tendered by the second and third respondents from the bar and through their sole witness, Senator Michael Opeyemi Bamidele, who testified as RW2. The petitioners had reserved their reason for the objection to be adduced at the stage of final address. Pursuant to the order of this court, that parties should file separate addresses on their objections. The petitioners have filed separate addresses in support of their objections to to the documents of the first respondent and those of the second and third respondents. The written address in support of the objection of the first respondent documents was filed on 23rd July 2023, while that in support of the objection to the second and third respondent documents was filed on 20th July 2023. In the written address in support of the petitioner's objection to the first respondent documents, Dr. Livy Uzoku, the Land Senior Counsel for the petitioners, essentially raised the sole issue of whether, having regard to the pre-hearing report of 23rd May 2023, paragraph 41, sub 3 of the first schedule to Electoral Act 2022 and other relevant provisions of the Act and decided cases, exhibits RA 1, 2, 6, and 7 are inadmissible and liable to be exchanged from the evidence. Similarly, in the address in support of the objection to the second and third respondent documents, the petitioners raised the sole issue of whether, having regards to the said pre-hearing session report and paragraph 41(3) of the first schedule and decided cases, the documents tendered by the second and third respondents are inadmissible and liable to be expunged from evidence. Lanis pointed out that Exhibit RA1 is a private document emanating from the third respondent and argued that in the absence of the narrow exceptions to the maker of the document, being the person to tender the document, they would not tender same in evidence. He relied on Main Street Bank Limited and General Steel Mills Others Limited. The National Council also submitted that Exhibit RA2 is inadmissible because the first respondent cannot appropriate or appropriate at the same time, since Exhibit RA2, the first respondent is trying to deny another letter received by it from the fourth respondent on 15 July 2022, which he had also certified. Here we just go direct to the resolutions. So by virtue of the provisions of Section 102B of the Evidence Act 2011, public documents include public records kept in Nigeria of private documents. In the case of Onwuzurike and Idozium and others, where the Supreme Court, Onogen JSC, held, as he then was, held that a private document sent to the police form part of the record and of the police and is consequently a public document within the provisions of Section 109 of the All Evidence Act, now Section 102 of the External Evidence Act 2011. It is also tried that a public document duly so satisfied is admissible in evidence, notwithstanding that it is not tendered by the maker. Indeed, a certified true copy of a public document can be tendered by a person who is not a party to the case. See the case of Maranro and Adebisi, Dagash and Bulama, Mustafa Chetima and others versus Al-Haji Bukar Customs. Exhibits RA1 and RA2, being in the public record of the first respondent, are public documents and are therefore admissible in evidence, having been certified by the first respondent under Section 104 of the Evidence Act 2011. On the petitioner objection to Exhibits RA6 and RA7, the record of proceedings of this court of 4th July 2023 shows that contrary to the assertion of the petitioners, the said Exhibits RA6 and RA7, which are the cloud trail log and certificate of compliance with Section 84 of the Evidence Act respectively, were not tendered from the bar but through RW1. Indeed, the record shows that the petitioners consented to the said documents being taken as read and demonstrated. We therefore have no hesitation in discountenancing the petitioner's objection to those documents. On the whole, the petitioner's objection to Exhibits RA1, RA2, RA6, and RA7 tendered to respondents is unmeritorious. It is hereby overruled. We now go to objection to the petition objection to the second and third respondents' documents. We consider the The resolution without objection on the petitioner objection to exhibits RA8 and RA9 and examination to it. They have challenged the second respondent qualification to contest the election on the ground that he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division. As rightly submitted by the second and third respondents, they have countered this allegation of the petitioners in paragraph 46 to 53, and particularly pleaded in paragraph 50 that the United States of America, through its embassy in Nigeria, had by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that upon their record checks of the Federal Bureau of Investigation, National Crime Investigation Center, NCIC, a centralized information center that maintains records of every criminal arrest and conviction within the United States of America. There were no record of any form of criminal arrest, warrants against the second respondent. The respondents shall found and rely upon copy of the said letter of February 4, 2023, signed by Michael, I think 2003. Done by Michael M. Bonner. Yes, the date is wrongly stated. It will be corrected. From the foregoing, it is obvious that issues were joined by the parties on the indictment alleged by the petitioners, and Exhibit RA8 and RA9 are clearly relevant. As for the argument of the petitioner over the custody of the documents, Exhibit RA8 is a letter of inquiry written by the Inspector General of Police to the Consulate General of the United States Embassy in Nigeria, inquiring as to whether the second respondent had any criminal record in the United States of America, while Exhibit RA9 is the reply to Exhibit RA8 by the United States Embassy in Nigeria. Both letters form part of the record of the Nigerian police and are therefore public documents under Section 102B of the Evidence Act. Certification by the Nigerian Police Force is a confirmation that Exhibits RA8 and RA9 are true copies of those documents which are in their custody. See, on Wuzuriki and Idozem, Abaji and Koka. With regard to the petitioner objection to the relevance of Exhibit R10, the record shows that the petitioner's challenge to the qualification of the second respondent was confined to allegations of double nomination of his running mate, the third respondent, and the alleged fine of the second respondent of the sum of $460,000 by a United States court. The educational qualifications of the second respondent were never challenged by the petitioners in the petition. It was the second and third respondents who introduced the educational qualifications of the second respondent in their reply, and the petitioner have not joined issues with the second and third respondents in their reply to the second and third respondent reply. It is right that the court of law adjudicates only on matters over which parties are in dispute. See Adedeji and Olosho and another Trade Bank PLC versus Benelux Nigeria Limited. Since there is no controversy or dispute between the parties as it relates to the second respondent educational qualifications, Exhibit RA10 is not relevant to determination of this petition. It is hereby discountenanced. Our examination of Exhibits RA11 to RA16, which are data pages and visa pages in the second respondent Nigerian passport, show that contrary to the assertion of the petitioners that the documents are not relevant, the petitioner have alleged in paragraph 28 to 32 of the petition that the second respondent was fined $460,000 for an offense involving dishonesty, namely narcotics trafficking, and in response to this allegation, the second and third respondents have denied same in paragraph 46 to 53 of their reply, and specifically pleaded those documents in paragraph 52 of their reply to the petition to show that the second respondent enjoyed an unrestricted right of ingress and egress to the United States of America. And up till now, he still enjoys an unimpeded right of access to the United States of America. It is therefore a considered view that Exhibits RA11 and RA16 are relevant to these proceedings, and the petitioner objection to same is hereby discountenanced. As for Exhibits RA17 and RA18, the petitioner's reason for objection to same has nothing to do with the admissibility of the documents. The second and third respondents, having raised objection to the first petition's local standard to present the petition in paragraphs 1. However, we have already considered and determined the issue of the petitioner's local standing whilst resolving the respondents' preliminary objections. We have already resolved same in favor of the petitioners on the preliminary objection. On the petitioner contention that Exhibit RA19, the report of the committee on the location of the Federal Capital Nigeria, is not relevant, we have examined the pleadings and the said exhibit. It is apparent to us that while the petitioners have averred in paragraph 81 of the petition that a presidential candidate must score 25% of the votes in FCT before he can be declared and return elected, the second and third respondents have averred in paragraph 86 of their reply that the FCT does not enjoy a special status over the other states of the Federation, and that Abuja is still inhabited by Nigerians who are deemed equal to Nigerians in any other part of Nigeria, and residents of Abuja are not conferred with any privilege and advantage that is not accorded to citizens of other communities or states in Nigeria. We are therefore of the view that facts have been pleaded which renders Exhibit RA19 relevant and admissible. On the petitioner's objection to the admissibility of Exhibit RA22, we observe that the document is the same as Exhibit RA2, which we have already found to be admissible, having been certified by ANIC as a copy of document in their possession. The tender of Exhibit RA22, which is not even certified, is therefore a surplusage and is hereby discountenanced. With regard to the objection to admissibility of Exhibits RA24 and RA25, which are citizens of pages 20 and 29 and 27 of Nigerian Tribune newspapers, respectively. The reasons advanced for the objection of the petitioners are not legal grounds for challenging admissibility of a document. We have no hesitation in discounting the objection, contrary to the arguments of the second and third respondents' counsel that Exhibit RA27, the ECOWAS preliminary declaration, is a private document. The said document forms part of the official record of the Economic Community of West African States, ECOWAS, an official body established under the ECOWAS Treaty. An agreement made by member states of the ECOWAS community, and the treaty was signed by heads of states and government of the 16 member states. It is undoubtedly a public document within the meaning of Section 102 of the Evidence Act 2011. However, we observe that Exhibit RA27 is not certified as required by Section 104 of the Evidence Act to render same admissible. Not being so certified, Exhibit RA27 is hereby extended from the record. As for the objection to Exhibit RA28 being the American Bar Association membership card of RW2, which was tendered by RW2 under cross-examination by the fourth respondent, it is clear to us that the document was neither pleaded nor listed or referred to in the statement of RW2, as rightly argued by the petitioners. Exhibit RA28 is expunged from the record. Now we go to the merit of the petition. Having disposed of the various objections to witnesses and to some of the documents tendered in this petition, we now proceed to consider the merit of the petition. The parties filed, exchanged, and adopted their written respective final written addresses starting with the respondents. The respective final addresses of the first, second, and third, and fourth respondent were filed on the 14th July 2023, respectively. On the 23rd of July 2023, 20th July 2023, and 23rd July 2023, the petitioners filed 3 separate final addresses in response to the final addresses of the first, second, and third, and fourth respondents, respectively. In reaction to the petitioners' final addresses, the first, second, and third and fourth respondents filed their reply addresses on 28th July 2023, 21st July 2023, and 28th July 2023, respectively. The first respondent and the second and third respondent also filed lists of additional authorities on the 28th and 31st of July 2023, respectively. On the 1st of August 2023, the parties adopted their respective final addresses. In his adopted final written address, Land Senior Counsel for the first respondent, A.B. Mahmoud SL, distilled the following 5 issues for determination. A. Whether having regard to the provisions of Section 131 and 137 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 25th February 2023. B. Having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraph 38 and 92 of the regulations and guidelines for the conduct of the election 2022, the inability of the first respondent to transfer or transmit the results of the presidential election to the IRF portal real time amounted to non-compliance to Electoral Act, and whether such non-compliance substantially affected the outcome of the election. C. Whether by the totality of evidence adduced, the petitioners have proven that the election of the second respondent was invalid by reason of corrupt practices and non-compliance with the provisions of the Electoral Act 2022. D. Whether in the absence of any proof of lawful and unlawful votes to be added to the cause of the petitioners and or unlawful votes to be deducted from the second respondent's cause at the election, the petitioners have proven that the second respondent was not elected by majority of lawful votes cast. E. Whether having regard to the declared results of the election and the provision of Section 134, subsection 2B of the Constitution of the Federal Republic of Nigeria 1999 as amended, the second respondent ought to have been returned as duly elected after having scored the highest number of votes cast with 25% of the votes cast in over 2/3 of the states in the Federation. The Land Senior Advocate for the second and third respondents, Chief Wale Olanipekun, formulated the following 4 issues for determination. 1. Having regard to the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, the salient provisions of the Electoral Act 2022, the judgment of the Federal High Court in FAC ABJCS 1454/2022 between Labour Party and INEC delivered on 23rd January 2023, which is X1, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 25th February 2023 was not in substantial compliance with the principles and the provisions of the Electoral Act 2022. 2. In view of the clear provisions of the Constitution of the Federal Republic of Nigeria 1999, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President in SC/CV/501/2023, People's Democratic Party vs. Independent National Electoral Commission INEC, delivered on 26 May 2023, Exhibit RA23, whether the second and third respondents were or are not eminently qualified to contest the presidential election of 26 February 2023. 3. Upon a combined reading of sections 134 and 299, as well as other relevant sections of the Constitution of the Federal Republic of Nigeria 1999 as amended, Section 66 of the Electoral Act 2022, and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. And 4, considering the constitutional petition and the task evidence adduced, whether this honorable court can accede to the reliefs being claimed by the petitioners. Prince L.O. Fabemi SN, the Senior Counsel for the further respondent, also nominated 4 issues for termination as follows. 1. Whether having regard to the issues joined and the evidence laid on the nomination of the third respondent as vice presidential candidate of the second respondent and the annulled civil forfeiture of the alleged civil forfeiture of the sum of $460,000 to the United States by order of the district court in case number 93C 4483. The petitioners have established that the second respondent was not qualified to contest the presidential election held on 26 February 2023 as provided for in the Constitution of the Federal Republic of Nigeria 1999 as altered. 2. Whether having regard to the relevant and admissible evidence laid by the parties, the conduct of the presidential election held on 26 February 2023 election was vitiated by non-compliance that was substantial enough to have affected its outcome and justified nullification of the election as envisaged by the applicable provisions of the Electoral Act 2022. 3. Whether the burden of proving that first petitioner and not second petitioner scored majority of lawful votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 26 February 2023 has been discharged by the petitioners. 4. Whether having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the relief sought in the petition at all, or that the petition ought to be dismissed in favor of the respondents. On the part of the petitioners, their lead senior counsel, Dr. Livy Uzoku SN, distilled the following 3 issues in the petitioner final address in response to the final address of the first and fourth respondents. 1. Whether the second and third respondents are qualified to contest the presidential election by reason of the unchallenged facts and circumstances arising under Section 137, Subsection 1D, 142, Subsection 1 and 2 of the Constitution, 1999 Constitution, Section 35 of the Electoral Act 2023 in this petition. 2. Whether from the documentary evidence before the Honorable Court read and examined together with the unchallenged expert and technical evidence of the petition witnesses, the petitioners proved that the non-compliance by the first respondent with the relevant provisions of the Electoral Act 2022 and the subsidiary legislation made thereunder substantially affected the outcome of the questioned presidential election held on 25th February 2023. In response to the second and third respondent final address, the petitioners adopted issues 1 to 3 of the issues for determination with the earlier filed on 18th May 2023 during the hearing session. These are 1. Whether the second respondent at the time of the presidential election held on 25th day of February 23 was not disqualified to contest the said election by virtue of the provisions of Section 1371D of the Constitution of the Federal Republic of Nigeria as amended. 2. Whether the third respondent at the time of the presidential election held on 26th February 2023 was qualified to contest the said election as the vice president answered in the negative, whether this did not invalidate the qualification of the second respondent to contest the said election. 3. Whether the presidential election held on 26th February 2023, wherein the second respondent was declared and returned by the first respondent as the winner, was not invalid by reason of non-compliance with the provisions of the Electoral Act 2022 and earlier guidelines and regulations for the conduct of the elections 2022 made pursuant to the Act. From the pleadings, the evidence adduced and the submissions of counsel of the parties, it is a considered view that the following are the issues which will effectively determine this petition. 1. whether having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria 99 as amended, Section 35 of the Electoral Act 2022, and the Evidence Act, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 26 February 2023. 2. Whether having regard to the evidence adduced by the parties, the petitioners have established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. 3. Whether from the totality of the evidence adduced, the petitioners have proven that the presidential election held on 26 February 2023 was invalid by reason of corrupt practices. 4. Whether from the evidence adduced by the petitioners have established that the second respondent was not duly elected by majority of lawful votes cast at the election. Well, we stated earlier, we have summarized the submissions of counsel. We see no need of reading them out. The first issue is Constitution of the Federal Republic of Nigeria as amended, Section 35 of the Electoral Act and the evidence before the court. The second and third respondents were qualified to contest the presidential election of 26 February 2023. Well, I think this issue of qualification on this issue has been resolved in petition number 4. It's the same issue that has been raised here. So we stand by our resolution on this issue. The only exception is the allegation on the issue of the second allegation made by the petitioners in ground 1, which is contained in paragraphs 28 to 32 of the petition, is that the second respondent is disqualified from contesting the presidential election because they stated in paragraph 28 of the petition as follows. The petitioner further pleaded that the second respondent was also at the time of the election not qualified to contest for election to the office of president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C4483 between United States of America plaintiff versus firms in the account of 2633226,700 held by First Heritage Bank in the name of Bola Tinubu. Funds in the accounts 394833134, 394833396, 4650279566 held by Citibank NA in the name of Bola Tinubu or Compass Finance and Investment Company. Funds in the accounts number that are held by Citibank International in the name of Bola Tinubu defendants. The petitioners have pleaded and relied on the order of the U.S. Court in Exhibit P5, which they tendered from the bar and which was subsequently identified by PW2 and PW12 in their evidence earlier summarized. The petitioners have centered their contention on the provisions of Section 137, subsection 1D of the 1999 Constitution, which reads as follows. A person shall not be qualified for election to the office of president if G. He he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed by him by any court, tribunal, or substituted by a competent court, by a competent authority for any other sentence imposed on him by such court or tribunal. A careful examination of the above provision shows that the operative words of that paragraph of the section are sentence, imprisonment, or fine, and for any offense. Black's Law Dictionary 6th edition at page 1081 defines offense as, quote, a felony or a misdemeanor, a breach of the criminal laws, violation of law for which penalty is prescribed. The word offense, while sometimes used in various senses, generally implies a felony or a misdemeanor, infringing public as distinguished from mere private rights. And punishable under the criminal laws, though it may also include the violation of a criminal statute, which the remedy is merely a civil suit to recover the penalty. An act clearly prohibited by the lawful authority of the state, providing notice through public laws, close of court. Also, the Supreme Court, in the case of Abdullahi Umar and the state, held that an offense is an act which is clearly prohibited by law and which may be a crime or a civil offense. Sentence, on the other hand, has been defined by the same Black's Law Dictionary at page 1362 as follows. The judgment formally pronounced by the court or judge upon the defendant after his conviction in a criminal prosecution, imposing the punishment to be inflicted, usually in the form of a fine, incarceration, or probation. Again, this court also defined sentencing in Yakubu and the state as follows. The judicial determination of a legal sanction to be imposed on a person found guilty of an offense. It means the prescription of a particular punishment by a court to someone convicted of a crime. It is discernible from the above that the fine referred to in paragraph D of section 137(1) quoted above is one which emanates from a sentence for a criminal offense involving dishonesty or fraud. The words for imprisonment or fine also presupposes that the fine envisaged under the section is one which is imposed as an alternative to the imprisonment. In other words, the provision of section 137, subsection 1D relates to sentence of death or sentence of imprisonment or fine imposed as a result of a criminal trial and conviction. Indeed, in considering the offense that can amount to disqualification under section 1371 of the Constitution, the Supreme Court held in Action Congress versus Anil as follows. The disqualification in section 137 subsection 1 clearly involves a deprivation of right and a presumption of guilt for embezzlement or fraud in derogation of the safeguards in section 36 subsection 1 and 5 of the Constitution. The trial and conviction by a court is the only constitutionally permitted way to prove guilt, and therefore the only ground for the imposition of criminal punishment or penalty for the criminal offenses of embezzlement or fraud. Clearly, imposition of the penalty of disqualification for embezzlement or fraud solely on the basis of an indictment for those offenses by an administrative panel of inquiry implies a presumption of guilt, contrary to section 36 9, whereas conviction for offenses and imposition of penalties and punishment are matters appertaining exclusively to judicial power. See also the cases of Amici and Anis Womuwaye versus Attorney General of Ekiti State, Abdul Karim and others versus Shinkafi. A careful perusal of P5 relied upon by the petitioners show that the case number 193 CV 04483 was in the civil docket of the U.S. District Court, Northern District of Illinois, and it was a civil forfeiture proceeding against funds in specified accounts with First Heritage Bank and Citibank N.A. Exhibit N5 is actually an action in rem against the funds with First Heritage Bank and Citibank. It is not an action in personam against the second respondent. In Jonathan versus Federal Republic of Nigeria, citation supplied, the Supreme Court held inter alia that Section 17 of the Advanced Fee Fraud and Other Related Offences Act 2006 provides for the power to make an order of forfeiture without conviction or for an offense, and that an order of forfeiture under the section shall not be based on conviction for an offense under the Act or any other law. The Apex Court further held that there was no need to prove any crime in forfeiture of property under Section 17 of the Advanced Fee Other Related Offences Act. A civil forfeiture is a unique remedy which rests on the legal fiction that the property, not the owner, is the target. Therefore, it does not require conviction or even a criminal charge against the owner, as it is not a punishment, nor is it for criminal purposes. See also the cases of Lawari Furnitures and Bags Limited versus Republic of Nigeria, Alison Madoke versus ESCC. From the legal definitions and judicial authorities cited above, it is clear that the sentence of imprisonment or fine for any offense involving dishonesty or fraud envisaged in Section 137, subsection 1D of the Constitution is one imposed upon a criminal trial and conviction. In the instant case, the petitioners have failed to show evidence that the second respondent was indicted or charged or arraigned, tried and convicted, and was sentenced to any term of imprisonment or fine for any particular offense. On the part of the second tier respondent, they have contended that the second respondent was never fined for any offense and has no criminal record in the United States. In proof of their assertion, they have tendered exhibits RA8 and RA9 from the bar and called RW2 to give evidence and identify the said exhibits as documents he referred to in his adopted statement of oath on oath of 12 April 2023. In paragraph 45 to 52 of his statement on oath, RW2 has stated that the second respondent was never convicted or fined for any criminal offense in the United States as alleged by the petitioners. In particular, RW2 stated as follows in paragraph 46, 47, and 49. This 46 says, in case number 93C4483 at the United States District Court, Northern State District of Illinois, Eastern Division, which was pleaded by the petitioners. 1. No criminal charge was filed against the second respondent. 2. The second respondent was not arraigned and did not take or make a plea to any count in the charge of allegations of crime. 3. The second respondent did not go through a criminal trial. 4. The second respondent was not convicted of any crime or any criminal activity. 5. No sentence of imprisonment was imposed on the second respondent. 6. No sentence of fine was imposed on the second respondent. 7. No form of sentence was imposed on the second respondent. 8. Case number 93C4483 was a civil suit in respect of which the court exercised civil jurisdiction under 18 U.S.C. 981 and 28 U.S.C. 1345 and 1355. In paragraph 47, he said, I also note that in case number 93C4483 at the United States District Court, Northern District of Illinois, Eastern Division, no impersonal criminal sentence was imposed on the second respondent. 49. The second respondent was not convicted in case number 93C4483, United States District Court, Northern District of Illinois. The United States of America, through its embassy in Nigeria, had, by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that upon the record checks of the Federal Bureau of Investigations, National Crime Investigation Center, NCIC, the Centralized Information Center that maintains the record of every criminal arrest and conviction within the United States of America, there were no records of any form of criminal arrest, warrants against the second respondent. I shall rely upon a copy of the said letter of February 4, 2023, signed by Michael M. Bonner. Under cross-examination by the fourth respondent, RW2 has stated that as a practicing attorney in the United States, he knows that there cannot be a conviction unless there is an indictment. He also stated that exhibits RA8 and RA9 gave the second respondent a clean bill of health as far as criminal conviction is concerned. When cross-examined by the petitioner's counsel, RW2 has stated that the American court relied on Section 981 of the American Money Laundering Law, which is a civil and not Section 982, which is criminal, and which the petitioner stated in their petition. He further stated that in the US, even a minor traffic infraction will be reported, so that if someone has a criminal record, the general record will show it. He added that a general search was conducted in respect of the second respondent. A look at exhibits RA8 and RA9 tendered by the second and third respondents showed that upon receipt of exhibits RA8 written by Nigeria's Inspector General of Police to the Consular General of the United States Embassy in Nigeria, inquiring of the criminal record of any of the second respondents, the U.S. Embassy had replied via exhibit RA9 and stated as follows, quote, in relation to a letter dated February 3, 2003, reference number SR 3000, IGP SEC/ABJ volume 24 289/87, regarding Governor Bola Ahmed Tinubu, a record check of the Federal Bureau of Investigation, National Crime Information Center NCIC was conducted. The results of the checks were negative for any criminal arrest records, warrants, or warrants for Bola Ahmed Tinubu, DOB 29, date of birth, March 1952. For information of your department, NCIC is a centralized information center that maintains the record of every criminal arrest and conviction within the United States and its territories. Apart from the above, Section 249 of the Evidence Act 2011 has stipulated how previous criminal convictions outside Nigeria can be established. Section 249, subsection 1 and 2 provides a previous conviction in a place outside Nigeria may be proved by the production of a certificate purporting to be given under the hand of a police officer in the country where the conviction was had, containing a copy of the sentence or order and the fingerprints of the person or photographs of the fingerprints of the person so convicted, together with evidence that the fingerprints of the person so convicted are those of the defendant. 2. A certificate given under subsection 1 of this section shall be prima facie evidence of all facts set out in it, without proof that the officer purporting to sign it did in fact sign it and was empowered to do so. It is instructed to observe that when cross-examined by the fourth respondent, PW1 had admitted that there was no certificate under the hand of a police officer in the United States of America where a crime was alleged to have been committed by the second respondent. It is significant to state that this petition is a declaratory action in which the petitioners are seeking inter alia that this court declare the second and third respondents as unqualified to contest the election. The petitioners who have made the allegation have the burden to prove the allegation on the strength of their own case and not on the weakness of the respondents. See Okereke vs. Umahi, Minike vs. PDP, Omushore vs. Erebushola, Ucha and Elechi. The petitioners have evidently failed to establish the allegation that the second respondent is disqualified from contesting the presidential election under Section 137, subsection 1D of the 1991 Constitution, because he was fined a sum of $460,000 by District Court, Northern District of Illinois. As shown above, the order of forfeiture in Exhibit PA5, on which the petitioners have relied, does not qualify as a sentence of fine for an offense involving dishonesty or fraud within the contemplation of Section 137 sub D of the 1999 Constitution. As regards whether paragraph E of Section 1 As regards whether paragraph E of section 137(1) should be read together with paragraph D of that subsection, the settled rule of interpretation of the Constitution or statute is that where the court is faced with two or more differing provisions over the same subject matter, the judicial attitude is to treat the special provision as overriding the general provision, on the principle that by enacting a separate provision for a part of the general class intends that the said part shall not be treated the same with the general class. See Atiku and another versus Attorney General Anambra State, Martin Croyder and others versus Major and Co. Nigeria Limited, but FMBN versus Olo. Since in both paragraph D and E of section 137, subsection 1, a sentence for the offense of involving dishonesty is mentioned, but in paragraph E, a limitation of 10 years has been introduced, then it means in respect of the sentence for offense of dishonesty, the two paragraphs must be read together, such that for conviction and sentence for an offense involving dishonesty, it must be within a period of less than 10 years before the date of the election, in order for such a conviction and sentence to be used for disqualifying a president candidate from contesting the election. It is also a cardinal principle of interpretation of the Constitution that relevant provisions must be read together and not disjointedly. See, Abegunde and the Ondo State House of Assembly. From all the foregoing, it is clear that having regard to the provisions of section 137 of the Constitution of Federal Republic of Nigeria 1999 as amended and the evidence laid before this court, the second respondent was not disqualified from contesting the presidential election held on 26 February 2023. Consequently, issue 1 is hereby resolved against the petitioners and in favor of the respondent. Issue 2 is whether, having regard to the evidence adduced by the parties, the petitioners has established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. Again, we shall skip the submissions of counsel. But the appropriate starting point for the resolution of this issue is to first consider the objection of the first respondent to ground 2 of the petition, which they raised at prelim stage, but which we deferred to this stage because it touches on the substance of the petition. The first respondent objection is that the petitioners are stopped from litigating the issue contained in paragraph 2, paragraphs 33 to 79, as well as reliefs 5.1 and 2 of the petition, as is released to electronic transmission and collation of the election results in view of the subsisting judgment of the Federal High Court in suit number FHC ABS CS 1454-2022, Labour Party Independent Electoral Commission, delivered 23rd January 2023. A certified true copy of which they attached to their petition as Exhibit A, and which was later tendered in evidence at trial as Exhibit X1. The first respondent particularly referred this court to paragraph 55 and 74 of the petition and submitted that the facts alleging non-compliance with the Electoral Act, which are set out in paragraph 33 to 79 of the petition, are hinged on the same issue of electronic transmission of results, which was resolved against the second petitioner in the said suit number FHC ABJSC 1454-2022, to the effect that there is no mandatory requirement for the first respondent to electronically transmit results of the election. Reliance was placed on Bambegin and others was Oriari, Oyeroba and another was Ulaupa. An examination of petition and Exhibit X1 shows that in their petition, specifically paragraph 37, 45 and 45, the petitioners have averred as follows. The petitioners aver that at the conclusion of the election and at each polling unit, the presiding officer was mandatorily required to electronically transmit or transfer rather, the result of the polling unit directly to the collation system of the first respondent. In addition, the presiding officer was also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent's result viewing portal, RF, in real time. 45. The petitioners aver that apart from the importance of the beavers in the capture of accreditation at polling unit in an election, the beavers is also mandatorily to be used in the process of uploading the information or data imputed into it by the first respondent's presiding officer at each polling unit, who shall, upon completion of voting and due recording and announcement of result, 1. Electronically transmit the result of the polling unit directly to the collation system as prescribed by the first respondent. 2. Use the beavers to upload a scanned copy of the Form EC8A to the annual result viewing portal, RF, as prescribed by the first respondent. And 3. Take the beavers and the original copy of each of the forms in tamper-evident envelope to the registration area for ward collation officer in the company of security agents. The polling agents may accompany the presiding officer to the registration area for ward collation center. In Exhibit X1, the certified true copy of the judgment of the Federal High Court in suit number FHC ABJ CS 1454-2022 Supra, which the first respondent is contending should constitute estoppel to ground 2 of this petition. The sole question presented for determination in the ordinary summons is as follows. Whether, having regard to combined effect of sections 47(2), 52, 64, 65, and 62(1) and 2, and other relevant provisions of the Electoral Act 2022, the respondent can still insist on manual collation of results in the forthcoming general election. Upon determination of the above questions, the plaintiff, which is the second petitioner herein, sought for the following reliefs. 1. A declaration that the respondent has no power to opt for manual method other than electronic method provided for by the relevant provisions of the Electoral Act. 2. An order of this honorable court directing or compelling the respondent to comply with the Electoral Act 22 on electronic transmission of results in the forthcoming general election. In its judgment in Exhibit X1, the Federal High Court held as follows. In view of the foregoing, can the act of the defendant in collecting and transferring election results manually in the forthcoming 2023 general election be said to be contrary to the relevant provisions of the Electoral Act 2022? The answer can only be in the negative, as there is nowhere in the above cited section where the Commission or any of its agents is mandated to only use an electronic means in collecting or transferring of election results. If any, the Commission is only mandated to collect and transfer election results and number of accredited voters in a way or manner deemed by it. In view of the above, I am finding that by the provision of sections 52 and 65 of the Electoral Act 2022, the correct interpretation of the said statute is that the defendant, Independent National Electoral Commission, is at liberty to prescribe the manner in which election results could be transmitted and are so whole. Consequently, this matter is hereby dismissed. Close of court. It is strict law that for a judgment of a court to constitute estoppel in a subsequent action, it must have finally decided the same issue in contention between the same parties or their previous. See Anchorage Leisures Limited and others versus Eco Bank Nigeria Limited. And Adebayo versus Babalola and others. From the averments contained in the petitioner's petition, which I have earlier reproduced above, it is clear that the petitioner allegation of non-compliance averred in paragraph 2 of the petition is hinged on the contention that ANIC was mandatorily required to electronically transmit or transfer the results of the polling units directly to the collation system of the first respondent, and also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent result viewing portal, RF, in real time. First, it is evident that in both this petition and in Exhibit X1, the parties are the same. In that second petitioner herein was the sole petitioner plaintiff in Exhibit X1, while the first respondent herein was the sole defendant in Exhibit X1. Secondly, from the above referred to averments in this petition and the relief sought by the petitioner in Exhibit X1, it is clear that the issue in both cases is whether the first respondent herein is mandatorily required to electronically transmit or transfer election results from the polling unit direct to the collation system. With the judgment of the Federal High Court in Exhibit X, the excerpt of which has been reproduced above, it is evident that the Federal High Court had decided the issue against the petitioners herein by holding that the first respondent cannot be compelled to electronically transmit election results. There is no evidence before this court that the second petitioner against whom the judgment in X1 was given has appealed against that decision. It is settled law that an appeal decision of the court remains subsisting and binding on the parties. See Abba versus Abba Aji, Jegede and INEC, Alexander and others versus Lone Star Drilling Company Limited. It is also tried that the doctrine of issue established is that where an issue has been decided by a competent court, the court will not allow it to be relegated by the same or different parties. It is also pertinent for us to state that in the final address of the first respondent, our attention was drawn to the recent decision of the legal division of this court in appeal number CA/LAG/332/2023, APC and Labour Party and 42 others, wherein this court set aside the decision in suit number FLC/L/CS/370/23, Labour Party and others versus ANEC. Another case forum shopped by the second petitioner at the Lagos Division of the Federal High Court after losing at the Abuja Division of the same court in Exhibit X1. In the judgment in appeal number CALGCV332/2023, this court had upheld the decision of the Federal High Court in Exhibit X1 and construed same against the petitioners as issue estoppel in relation to the petitioner's contention which they are making in this petition that ANEC is mandatorily required to electronically transmit election results. By virtue of Section 122, subsection 2 of the Evidence Act, this court is entitled to take judicial notice of the decision in appeal number CALGCV332/2023, APC versus Labour Party and 42 others. Not only that, this court is by the doctrine of precedent bound by that decision. Since the above judicial pronouncements have decided that under the Electoral Act and ordinary regulation guidelines for the conduct of the election, the first respondent cannot be compelled to electronically transmit election results. The petitioners are clearly stopped by those decisions from contending in ground 2 of this petition that the first respondent is mandatorily required to electronically transmit the election results to the election system. As a court of first instance, in this petition, we shall, notwithstanding our above finding, proceed to determine the merit of ground 2 of the petition relating to non-compliance. It is observed that in their petition, the petitioners have alleged the same set of facts in paragraph 33 to 79 as constituting both non-compliance and corrupt practice. On a careful perusal of the petition, however, it seems to us that the allegations of non-compliance are contained in paragraph 33 to 56 and 59 of the petition, while specific allegations of corrupt practice were made in paragraph 60 to 78, even though same were also founded on the same facts of non-compliance alleged by the petitioners. Compliance are as encapsulated in paragraphs 37, 45, 50, 51, and 55 of the petition, which are reproduced below. The respondents, particularly the first respondent, denied the allegations of non-compliance made by the petitioners in their respective replies to the petition. In particular, the first respondent denied that there was any collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer, and stated that the prescribed mode of collation of results is as stipulated in paragraph 50 to 55 of the regulations and guidelines for the conduct of elections. They further stated that the prescribed mode of collation was manual collation of the various forms EC8A, EC8B, EC8C, EC8D, and EC8E of the presidential election. See paragraph 31 of the first respondent's reply. They also stated that the BVAS is designed to upload the accreditation data at the end of the accreditation process, scan and transmit the result of the election at a polling unit through the e-transmission system, which is uploaded to the first respondent result viewing portal, IREF. The first respondent further averred that the upload of data or images captured and automatically restored on the BVAS device requires data service, and where there is no such data service, where the service is poor, the BVAS service is designed to work offline, and the upload of data will occur when data service is available. They also stated that polling unit results were duly uploaded on the first respondent e-transmission system by the respective presiding officers at the end of the election, but some of the results were not visible on the IREF portal due to the technical glitch experienced on the election day. In specific response to the petitioner's allegation of failure, refusal, and neglect to instantly transmit and upload the results electronically from the BVAS to the IREF, the first respondent stated in paragraph 55, Romans 7 and 10 as follows. Immediately after the election of 25th February 2023, polling unit results were uploaded and received by the e-transmission system whilst using the BVAS. There was a temporary failure of communication between the e-transmission system and the IREF portal for the presidential election. In this regard, the e-transmission system returned an HTTP 500 error, which is an application error such that transmitted results, though received on the in-transmission application hosted on the AWS, the in-transmission could not organize and push the results instantly to the presidential module on the IREF portal because it could not map the result uploaded for the presidential election to any state. The first respondent pleads and shall rely on the AWS CrowdTrail logs indicating patches deployed to fix the error from technical glitch on the election day. Upon resolution of the HTTP 500 error, the results which were delayed in the e-transmission system were eventually organized and pushed to the IREF portal. The results are available as generated in their original form from the polling unit using the BVAS. The first respondent stated that the technical glitch did not in any way affect the result of the presidential election. However, in paragraph 37 of their reply to the first respondent reply, the petitioners denied that there was a technical glitch experienced on election day as contended by the first respondent, and stated that the failure of the first respondent to upload the presidential election results using the BVAS to the IREF was a ploy to manipulate the actual results of the election. As indicated in their pleadings and submissions of counsel, the petitioner's allegation of non-compliance with the Electoral Act 2022 and the regulations and guidelines for the conduct of elections 22 is anchored on the provisions of sections 47.2, 61, 2 and 5, 64.4a and b, 64.5 and 73.2 of the Electoral Act, and paragraph 38.1 and 2, 48a, b, c, 55, Roman 5, 7 and 20, 51.2, 54.12 and 55.12 and 93 of the regulations and guidelines. I have carefully considered the submissions of the parties on this issue of non-compliance with the Provisional Electoral Act and the paragraphs of the regulations and guidelines for the conduct of the election 2022. The Independent National Electoral Commission, the first respondent hearing, is established by Section 53, subsection 1F of the Constitution of the Federal Republic of Nigeria 99, and part of its functions are stated on paragraph 15 in the Item F, part 1 of the third schedule to the said Constitution, is to organize, undertake, and supervise elections, including election to the office of the President and Vice President, among other political officers listed. Being a creation of the Constitution, INEC is empowered by Section 160, subsection 1 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing, it shall not be under the control of the President. Indeed, INEC shall not be subject to direction or control of any authority or person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47, subsection 2 of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62 sub 1 of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64(4) states that a collation officer or returning officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A, number of accredited voters stated on the collected results are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and B, the votes stated on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 60, subsection 4 of the Act. At this stage, it should be noted that Section 47, sub 2, referred to in Section 64(4)(a), relates to the procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 64(4)(b) of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, subsection 5 of Section 60 goes ahead to mandate the presiding officer to transfer the result, including total number of accredited voters and the results of the ballot in a manner prescribed by the Commission. The Act also provides in Section 64(5) that the collation officer or returning officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collection is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collation or returning officer will use to verify and collect the results, subsection 5 also provides for what the collation or returning officer will use to collect the results. Subsection 6 of the same section provides for what the collation or returning officer will use to determine the correctness of disputed results where there is a dispute. These are A, the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, subsection 2 of the Act. And D, the votes and result of the election recorded and transmitted directly from each polling unit where the election is disputed and as prescribed under Section 64 sub 4 of the Act, which requires only the counting and announcement of results at the polling unit. A careful examination of the above sections relied upon by the petitioners show that the Electoral Act had used the words deliver in section 62, subsection 1, transfer in section 60, subsection 5, and transmitted directly in section 50, sub 2, 64, 4, 5, and 6 of the is defined by the same law dictionary to mean to send or transfer from one person or place to another or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly, interchangeably, to describe how the results of the election shall be moved from one state to another until the results are finally collated and declared. In all these, the Electoral Act 2022 has not specifically provided that the result of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1991 Constitution and Section 148 of the Electoral Act 2022 that the first respondent does annex here for the of elections 2022 as well as annex annual election officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal voter accreditation system (BVAS) as the technological device for the purpose of accreditation and verification of voters in the 2023 general elections. The petitioners have also hinged their allegation of non-compliance on paragraph 38(1) and 2, 48A, B, C, 55 and 7 and 20, 51, 2, 54, 7, 55, 7, and 93 of regulations and guidelines. Paragraph 38 of the regulation provides as follows. It's expensive to get a copy of the guidelines to see there we have produced it in this judgment. Yes, quickly. From the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 62, subsection 1, for the delivery by the presiding officer of the result along with other election materials under security and accompanied by candidates or their polling agents were available to such a person as may be prescribed by the first respondent. This first respondent has, by of the regulations and guidelines quoted above, introduced electronic transmission to a collation system in addition to the physical transfer of the election results to the registration area for one collation officer. As said earlier, the technology as prescribed in the conduct of the 2022 election is the bimodal voter accreditation system (BVAS). The function of the BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or her fingerprints or facial recognition, thus accrediting the voter to vote at the election and storing the data and number of such accredited voters. By paragraph 38(2) and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the annex result viewing portal (IREF), after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area from ward collation officer. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit result and upload same to the IREF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the result of the polling unit direct to collation system. It should be noted that the annex results viewing portal (IREF) is not a collation system. The Supreme Court in Oyetola and Annex 2023, Annex 23 LPELR, has explained the difference between the collation system and the IREF. In that case, IGIM JSC held as follows court. As their names depict, the collation system and the annex result viewing portal are part of the collation process, election process, and play particular roles in that process. The collation system is made of centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides the relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. A community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of elections 2022, and the Annex Manual for Election Officials 2023 show that the Electoral Act provides in section 62 subsection 1 that after recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines as well as the Annex Manual also state that hard copies of election results shall be used for the collation, and it is only where no such hard copies of the election results exist that electronically transmitted results or results from the IRF will be used to collect results. The petitioners who contend that ANIC was mandatorily required to the collection system have called PW2 as an expert witness who stated that he is a software engineer. He stated that he was aware that ANIC was mandated to electronically transmit or transfer the result from the polling unit direct to the collation system as prescribed by ANIC. He stated that the IRF portal is part of the technological architecture developed or deployed by ANIC for the storage, management, display, and uploading of polling unit results to be accessed by the public. However, under cross-examination, he admitted that he was not familiar with the operations of the Beavers machine and that his investigations and findings were on the IRF portal. He also agreed that it was only INEC that could prescribe the method of transmission of election results. PW4 was also called as an expert witness by the petitioners, even though he stated that part of his brief by Labour Party was to determine INEC compliance with the Electoral Act 2022 and the INEC regulations and guidelines for conduct of the elections 2022. He prevaricated under cross-examination by the first respondent when he first stated that INEC and the IRF portal is an electronic collation system, but later recanted and said the IRF portal is not capable of collating and or tabulating the results of an election. The witness also stated under cross-examination by the second and third respondents that it is the image of Form EC8A that will be transmitted to IRF, while the hard copy of the Form EC8A will be taken to the Ward Collation Center. As for PW7, also called as expert witness petitioners, her evidence was basically in respect of the health status of Amazon Web Services, which hosted the INEC IRF portal. The testimony of PW8, a cybersecurity expert, also called by the petitioners, also related to the INEC IRF portal. On the part of the first respondent, RW1, Dr. Lawrence Bayode, the Deputy Director in the ICT Department of the first respondent, has testified that contrary to the assertion of the petitioners in paragraph 37 of the petition, there was no collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer. He stated that the prescribed mode of collation was manual collation of the various forms EC8As, EC8Bs, EC8Cs, EC8Ds, and EC8Es for the presidential election. He explained that the Beavers machine was designed to upload accreditation data at the end of the accreditation process and scan and transmit the results of the polling unit results through the e-transmission system to the IRF portal. Even as this witness was cross-examined by the petitioner's counsel, he was not cross-examined on his evidence that INEC has not established any collation system to which results will be electronically transmitted from the polling unit. Thus, his testimony on that fact remained unchallenged and uncontroverted, and it is settled law that the court has a duty to act on unchallenged and uncontroverted evidence. See Bromwen Energy Trading Company Limited, OAN Overseas Agency, Ogunyade versus Oshunke, and others. In addition, RW2, called by the second and third, had testified that defense respondent through its chairman made clarifications on 23rd of February 2023 that raw figures of election results will not be transmitted electronically by defense respondent, as such transmission was susceptible to hacking. He identified exhibits R24 and RA24 and RA25 as documents he referred to in his statement. These are the certified true copies of pages 28 and 27 of Tribune newspapers of 23rd February 2023, wherein the chairman made the said clarification. As indicated in our ruling on objections to documents, the petitioners did not object to the contents of exhibits RA24 and RA25, but only stated that they were objecting to the heading, but not the contents. We overruled that objection in our ruling because the reason advanced by the petitioners' counsel did not amount to a proper objection to those documents. It is also noteworthy that the petitioners never cross-examined RW2 on his oral evidence and the said exhibits in support of his oral evidence. In exhibit RA24, the ANEC chairman was reported to have said that raw figures will not be transmitted because the law does not allow for electronic transmission of results and because it is susceptible to hacking. He stated that only scanned copies of polling unit results will be uploaded to the RF for public view. From the evidence led by the parties on this issue, it is clear that apart from testifying that the first respondent failed to transmit scanned copies of polling unit results to the ANEC RF portal, non-witnesses called by the petitioners had given evidence of the existence of any collation system to which the results shall be electronically transmitted by the presiding officers of the first respondent. Contrary to the contention of the petitioners that under the regulations it will not be possible to collect the presidential election results without verifying them with the electronically transmitted results, paragraph 92 of the same regulations categorically provides that at every level of collation where the ANEC copy of collected results from the immediate lower level of collation exists, it shall be adopted for collation. In addition, paragraph 48C of the regulation provides that if no result has been directly transmitted electronically for a polling unit or any level of collation, the provision of clause 93 of this regulation shall apply. The said clause 93 of the regulations, which I had earlier quoted, provides that where the ANEC hard copy of collected results from the immediately lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the RF portal to continue collation. And where none of this exists, the collation officer shall ask for the duplicate copies issued by the Commission to the Nigerian police or to the agents of political parties. The foregoing provisions of the Electoral Act and the other regulations clearly show that it is not correct, as contended by the petitioners, that results of the election cannot be validly collected without the electronically transmitted results. Indeed, the regulations primarily provide for manual transmission or transfer and collation of results. There is nothing in the Electoral Act or the other regulations and guidelines to show that an electronic collation system was prescribed by the Commission to which results will be electronically transmitted. Thus, the petitioners were unable to establish their assertion that the first respondent is mandatorily required to electronically transmit the polling unit results to a collation system. The first respondent, on the other hand, has adduced unchallenged evidence that apart from the ANEC RF portal, no collation system was established by the first respondent to which the result of the presidential election must be electronically transmitted for collation. It is therefore my finding that both the Electoral Act and the regulations and guidelines provide for manual collation of election results and the electronic transmission to a collation system apparently introduced in the regulations and guidelines are not mandatory as contended by the petitioners in herein. It is also my finding, based on the evidence adduced, that the only collation system put in place by the first respondent in the conduct of the presidential election is comprised of the fiscal collation centers in the registration areas or ward collation centers, local government area collation centers, state collation centers, and the national collation center elaborately stated in paragraphs 47, 50, 53, 54, and 55 of the regulations and guidelines for the conduct of elections 2022. With regard to the petitioner's contention that the first respondent the presidential election results to the INEC results viewing portal, RF, the petitioners avert in paragraphs 53, 97, and 98 of the petition. The petitioner also 53. The petitioner also contend that in manifest violation of the first respondent regulations and the Electoral Act 2022, the results of the presidential election held in the polling units were not fully uploaded on the RF as at the time of the purported declaration of the second respondent as the winner of the presidential election, which gave room for manipulation of the said results by officials of the respondent. 97. The first respondent via a written communication sought to excuse the manifest non-compliance with the requirements of the Electoral Act 22 and the regulations by claiming that there were glitches in the electoral system which prevented it, that first respondent, from uploading the results of the presidential election from the polling units to the RF portal on the day of the election. The said written communication is hereby pleaded. 98. The petitioner shall contend that the alleged glitches in the electronic system installed and managed by the first respondent were a ploy invented by the first respondent to credit unlawful votes to the second respondent and thereby wipe out the clear advantage which inured to the petitioners following the lawful exercise of voting rights by the electorate. In response to the above allegation, the first respondent adverted in paragraphs 59, 55, 7, 8, 9, and 10 of their reply to the petition. That's, I've reproduced them here. In paragraph 37 of their reply to the respondent's reply, the petitioners have again denied that there was any technical glitch and maintained their assertion that the failure to upload the results on the RF was a ploy by the first respondent to manipulate the results. They stated that they will rely on the server logs and server's content of the RF posted on the AWS cloud platform to show that the results of the election were uploaded on the RF portal, but the first respondent attempted to delete or remove the uploaded results. Have the legal burden to establish certain non-compliance and show how the non-compliance substantially affected the result of the election. See Ladoja and Ajimobi, Shinkafi and Yari. In proof of their assertion, the petitioners subpoenaed PW7 and PW8 as expert witnesses, but the respondents challenged their competence to testify because their witness statements on oath were not front-loaded along with the petition, as mandatorily required by paragraph 45 of the first schedule to the Electoral Act. In my ruling at the earlier part of this judgment, I had upheld the respondents' objection and served out the evidence, which include their witness statements on oath and the documents and or reports tendered through them. These are exhibits PCJ A to F, PCJ 4, 6 reports of EWS health dashboard status and certificate of compliance tendered through PW7, and exhibit PCK 1, metadata admitted through PW8. However, notwithstanding that position, I shall proceed to consider the evidence of PW7 and PW8 and the other witnesses called by the petitioners. PW7 claimed to be a cloud engineer, stroke architect, an employee of Amazon Web Services. She stated that she is not only a member of the Labour Party, the petitioner is sharing, but she contested election as a candidate for member House of Representatives for Ogoja, Strogyala, Federal Constituency of Cross River State. She stated that for an IT application, the SDLC includes requirement gathering, analysis, and design. Collation centers and design, yes. the development from implementation, testing the code, staging the software and development and deployment. She stated that she was aware that at the process of testing and staging of software code and problems or challenges, any problems or challenges with the software will usually show and or be flagged. She stated that each function is supposed to be tested and any issues flagged ought to be remedied before deploying the software. She stated that if a software from application has any glitch, such a glitch will pop up, that is, be flagged at the testing stage. She stated that from her preliminary review of the public viewing facing the RF website, she is aware that the polling unit results images are stored in Amazon S3 and AWS storage service. She stated that as an employee of AWS, the AWS has a service level agreement, SLA, with its customers, which is accessible to the public on docs.aws.amazon.com, and that by the SLA for S3 service, it is designed to provide 99.999% durability and 99.99% availability of objects stored over a year. She said this is accessible to the public on http://docs.aws.amazon.com, Amazon S3 latest user guides of data durability.html. She stated that the AWS code servers are hosted in 33 regions, and the health status of AWS cloud service for all regions for the past 12 months from date is accessible to the public on http://health.amazon.com/health/status. She stated that the health status of each service in each region on February 25, 2023 indicated that there were no glitches on any of the AWS cloud servers. She stated that from the post-event summary is by AWS, the last time a significant outage occurred on the AWS cloud servers was on December 10, 2021, which was an internal connectivity issue that affected EC2, API, and Container API, among other services access issues impacting only one region. She said this is available to the public. AWS 7 stated that she was aware that a glitch in the software means a malfunctioning, as a result of which the application is not able to perform properly, and that fixing a glitch in a software application by the creation of patches refers to a series of changes made into the system by writing small code, which is imputed into the software to change its current state and thereby function properly. On cross-examination by the first respondent, PW7 admitted that she missed production maintenance, which is an important element of software development lifecycle. She denied that glitches occur at post-production maintenance stage and stated that it appears at the testing stage. She stated that she was aware of personal health dashboard, but stated that the first respondent's personal health dashboard is not before the court. She admitted that the AWS adopts a shared responsibility model in which AWS plays its part while the customer plays its own part when it comes to security. She admitted that the report she tendered only shows the of all AWS services in all regions in terms of the infrastructure and not security. She admitted that in order to know what happened on applications deployed on AWS infrastructure by a customer, it is not necessary to get a technical report. PW7 also stated that she is familiar with AWS CloudTrail, and there is a CloudTrail for every AWS account and for every API action made on that account. She admitted that she did not produce the CloudTrail for any deployed application before the court. She denied that the CloudTrail is the best account of what transpired on any deployed application, but did not state the best way to know what transpired. She stated that it is highly unusual for glitches to occur for primary functions of applications in production. She stated that she was not aware that glitches happened with the Central Bank of Nigeria e-money project, BSG. She admitted that she was a candidate for the Labour Party at the last election. She also admitted that the subpoena under which she came to court was served on her personally and not on Amazon Web Services. Also on cross-examination by the second and third respondents, PW7 admitted that exhibit PCJ2, which she presented as her employment verification letter, was not signed by anyone, but insisted that there is the name of Employment Resource Center written on it. She also admitted that she had been attending the court and watching the proceedings before the day of her testimony. She admitted that the report she presented before the court is public information hosted by Amazon and that it is available and accessible to the public. She, however, insisted that the report is hers because she was the one who downloaded it and brought them to the court. PW7 also admitted under cross-examination that she won primary election for her constituency under Labour Party, the second petitioner, and that she even filed an action against ANIL, was not placed on the final list of candidates published by ANIL. She admitted that her complaint was because she tried several times to upload her information on ANIL's site, but all her efforts failed because of network failure. She admitted that network failure can happen to either end of an application. Even as she disagreed that there was a glitch on ANIL's site, she admitted that in her affidavit. She stated that ANIL's site crashed. PW7 also stated that she was aware that AWS experienced outage of several hours on Tuesday, 28th February 2017, and that as of 2021, AWS also was reported to have suffered more than 27 outages. She also admitted that what was sent to RF was the image of the form EC8A. On cross-examination by the fourth respondent, PW7 stated that she did not know about password protocols and cannot speak about password protocol to modify the applications of ANIL. She admitted that the open cross-access information she downloaded in her report cannot be amended by her. In fact, she admitted that she was not representing Amazon Web Services in this case. She, however, insisted that she is an expert. She stated that she was aware of glitch which affected Japan brokers in September 2021, but stated that the last one she was aware of was in December 2021. As to whether glitches can happen again, she stated that anything is possible. In his evidence, PW1, Dr. Chibike Ugoike, another expert witness called by the petitioners, stated that he is a cybersecurity and risk advisory consultant and that he was approached by the Labour Party to provide expert evidence in this petition. He said he had read the Electoral Act 2022 and the ANIC regulations and guidelines for the conduct of Elections 22 and the ANIC Manual for Election Officials 2023 with particular attention to the relevant provisions dealing with uploading and transmission of election results from the polling units using the beavers to RF portal. He stated that he has also read the petition as well as the reply to the petition filed by the first respondent. He stated that from his reading of those documents and processes, when a software application undergoes the required minimum testing before deployment, any functionality error or bug will be flagged. He stated that the purpose of testing is to remedy or resolve such errors before the application is deployed for production. On cross-examination by the first respondent, PW8 stated that he was approached on 10th March 2023 and he finished his work sometime in May 2023. He said that he did his preliminary report and on 17th and 18th March, on 17th and 18th March 2023, and concluded the final report at the end of May 2023. PW8 stated in paragraph 14 of this adopted written witness statement that he read the petition and the first respondent replied to the petition and in doing this, his work, stated that he could not recall whether he read the petition. But when his attention was drawn to paragraph 14 of his statement, he agreed that he had read those pleadings. He admitted that it is not impossible for errors to occur after deployment of technology or application. When referred to paragraphs 22 and 23 of his statement, he stated that he referred to the metadata on the IRF in 3 polling units to establish that it is possible to show metadata. He stated that there were errors in those polling units and he did not have to examine the physical copies of the forms EC8A of those polling units. He stated that from the tabulation of the metadata, he could not tell that whether the results stated in those polling units were collected. He stated that all the work he did was on his computer. He confirmed that the AWS security model is a shared responsibility model between AWS and the client. He stated that he was aware of the cloud trail and confirmed that the cloud trail will explain the availability of the application of INEC on the AWS infrastructure. PWA, who insisted that there was an electronic collation system, only pointed to an upload at the last paragraph of Exhibit PCK2 and stated that it means an electronic collation system. When cross-examined by second and third respondents, PWA denied that it was part of his brief to assist the Labour Party to respond to the respondents' reply. He admitted that he did not inspect any of the BVAC machines and did not interrogate Festus Okoye, whose statements he referred to. He confirmed that Exhibit A, which he attached to his report, is the metadata of 23 pages showing multiple uploads. He denied that it contains information which are coded and not explained, and insisted that the information he provided are decrypted and readable. He admitted that he supplied some links in some paragraphs of his report, but stated he did not expect the court to go and browse, access, and download the information contained from those links. When cross-examined by fourth respondent, PW admitted that he downloaded the 12 polling unit results he attached to his report from the IRF, and he did not interact with the presiding officers of those polling units and did not see the hard copies of those results. He could not also tell whether those results have been collected. Starting with the evidence of PW7, it is evidence that she is a person who has an interest to serve in this petition, being a member of the second petitioner, under whose platform she contested election for House of Representatives. Her interest in this petition is further underscored by her admission that she had been attending court and watching the proceedings prior to making her statement on oath and testifying as a witness. Her testimony, therefore, was essentially a demonstration of her support and loyalty to the second petitioner. Her claim to being an employee of Amazon Web Services is also suspect, as she produced no credible evidence to that effect. Exhibit PCJ2, which is the paper she presented as evidence of her employment by AWS, is obviously a worthless paper. It has no author, although she insisted that the author is Employee Resource Center. The paper was also not signed. Her evidence adds no value to the petitioner case because she stated that her evidence relates to the health status of AWS in terms of infrastructure and not in terms of security. She had admitted that the expert report in Exhibit PCJ 3A to F, which she brought to court, are actually documents publicly available on Amazon website, which she downloaded, and her only claim to its ownership is that she was the one who downloaded it and brought it to court. She even admitted that she could not add or subtract anything from the reports. Those reports are obviously not her own. She also admitted that the health status of the first responders application hosted on the AWS is not before the court. My conclusion on the totality of this witness is that it is devoid of any probative value. As for PWA, he has demonstrated that he worked to an answer. Not only did he admit that he read the petition and reply of the first respondent in the course of his commission work, he also stated that he read the Electoral Act and annual regulations and manual for election officials. On the authority of Ladoja and Ajimobi, the evidence of this witness is also not of any probative value. Apart from the above, the other witnesses or petitioners, especially PW4, PW9, 10, 12, and 13, all stated that they voted and everything went well in their respective polling units. In particular, PW4, PW10, and 13 all stated that their polling unit results were taken to collection centers. Therefore, even the evidence of the petitioner witnesses showed that the polling unit results were physically taken to the registration areas for work collection centers. The petitioners have led no evidence to establish the existence of any collection center to which the potential election results were to be electronically transmitted for collection. On the part of the first respondent, RW1 testified that the failure to upload some of the results of the presidential election to the RF portal real time on 25th February 2023 was due to a technical glitch experienced on their e-transmission system. RW1, through whom the first respondent tendered exhibits RA6 and RA7, stated that at the end of the polls, in some polling units, on 26 February 2023, it was observed that the first respondent that polling unit results being uploaded to the annex e-transmit system by the presiding officers were pushed to the Senate and House of Representatives modules on the IREF, but the results of the presidential election were not being pushed to the presidential module on the IREF. That based on threat levels and reports by security agencies that the first responder servers may be subjected to attacks on election day, the first responder first course of action was to investigate whether the servers were being attacked. The preliminary investigation showed that there was no attack, but the issue was a HTTP 500 error from which within the application, which are mostly errors due to problems of configuration, permissions, or failure to create application resources correctly. That a thorough investigation revealed that the e-transmission was unable to map the uploaded results for the presidential election to any specific state, and that the presidential folder structure, which was meant to organize the uploaded result sheets in order of election, state, local government, area, ward, polling unit, was causing the application to crash and return as server error whenever it tried to create the folder structure for the presidential election. RW1 explained that creating a folder structure to organize the uploaded results in the hierarchy of election, state, local government, ward, and polling unit was a new feature introduced as an improvement in the transmission system. And that the old system randomly saved uploaded results by timestamps, making it difficult to upload results sheets by election or by state. He stated that the deficiency was observed after Washington state governorship election in 2022. RW stated that during the election of 25th February 2023, the application was able to query and detect the base states for the senatorial districts and federal constituencies based on the mapping of all central districts and federal constituencies to their respective states. And that this mapping still exists in the database. And the upload was successful because it was able to identify the state and build the folder hierarchy.
day, this nation will rise up and live out the true meaning of its creed. We hold these truths to be self-evident, that all men are created equal.
I am not presenting a fashion show here, but I simply would like to say that we must accept to live the African way. It's been the only way to live in freedom and in dignity. Visionary, selflessness, love for our people and fatherland. These attributes of a true leader are difficult to find at this time. Africa and indeed Nigeria have been at thresholds of history. The quality of leadership at these times has often determined the narratives of such historical moments. The big question, therefore, has always been, who is a true leader?
A proper leader should be a Nigerian that is truly Nigerian. A Nigerian that will not only lead Nigeria, somebody who can also lead Africa. Because Nigeria and the Community of Nations is not an ordinary country. Most of the African countries look towards Nigeria for leadership.
The noble efforts of patriots in pre-independent Nigeria have been well documented. They represented the finest of Nigeria's history and reference point for character development.
We must ensure that in an independent Nigeria, individual citizens throughout the land enjoy liberty, human dignity, and equality under the law. There must be one Nigeria with one constitution and one law for all. Let us therefore, Mr. Chairman, sir, close our ears to the counsel of despair, which says that we cannot here at this conference agree on a constitution.
Nigerians always see their leader as if just Nigerian leader. They don't know how we are seen outside. And if we are able to get the right person who understands the situation, understands Nigerians, who is not greedy, somebody who is ready to sacrifice. Because for a country that have so much resources like Nigeria, so that Nigeria is not a poor country, but we have so many poor people.
Prime Minister Balewa is making an official visit to America at the invitation of the President of the United States.
Provided for in the deliberations and guidelines of Health 2023, prior to electronic transmit election results cannot be made a ground for challenging an election under Section 134, subsection 1B of the Electoral Act 2022. The petitioners also allege in paragraph 59 of the petition that the first respondent failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials on the prescribed forms EC 25A, 25A1, EC 8B, and EC 8B1. That is to say, electoral materials received for local government areas, electoral material distribution for registration areas, electoral materials received for local government areas, electoral material distribution for RS, electoral materials received, reverse logistics, and polling unit materials in respect of states where the respondent is purported, where the second respondent purported to won. The petitioners further allege that following the order of court for inspection, they applied through their campaign organization and lawyers for the forms, but the first respondent refused to give or issue those forms and refused to allow the inspection of the forms despite the order. In response to the petitioner's allegation, the first respondent countered that its officials duly recorded in the prescribed forms the quantity, serial numbers, and other forms, other particulars of the result sheets, ballot papers, and other sensitive electoral materials in the prescribed forms EC 25A, EC 25A1, EC 8B, EC8B1, in respect of the states where the second respondent duly won the election, as done in the states where the petitioner won the election, as the procedure adopted in the election across all the states of the Federation are uniform and the same. The first respondent further stated it duly complied with the order of inspection granted by the Honorable Court, and the petitioners were not denied access to the forms EC25A, EC25A1, EC8B, EC8B1 as alleged by the petitioners. It was the submission of Land Senior Council for the petitioners that, having regard to the state of the pleadings and the issues of fact in contention, the onus is on the first respondent to prove that there was indeed due compliance with provisions of Section 73, Subsection 2 of the Electoral Act, since petitioners are asserting the negative, while the respondents are asserting the positive. They relied on the decision of this court in First Bank Nigeria PLC, Adjudication Business Investments, and Royal United Nigeria Sterling Bank PLC. It submitted that the first respondent did not leave any evidence in proof of their positive assertion that there was compliance with the said provision of Section 73, Subsection 2 of the Electoral Act. Land Council submitted that on the part of the petitioners, they have led evidence through PW12 that the petitioners obtained order of this court for inspection of documents, but the first respondent had refused to produce the form, despite several letters demanding the forms from the petitioners, which were tendered as exhibits PCQ1 to PCQ6. He added that the petitioners have also served subpoena duces tecum on the first respondent to produce the said forms, but the officer of the first respondent, a deputy director, certification, complaints, and legal drafting, who came to court in answer of the subpoena on 20th June 2023, failed to bring the form. Counsel urged the court to invoke the provision Section 167D of the Evidence Act against the first respondent and hold that the forms, if produced, would have been unfavorable to the first respondent. He further submitted that the non-compliance with Section 73(2) of the Electoral Act has been established, which has invalidated the election in those states which the second respondent was declared to have won, namely Benue, Borno, Ekiti, Jigawa, Kogi, Kwara, Niger, Ogun, Ondo, Oyo, Rivers of Zamfara states, which are shown in the form EC8GA, admitted in evidence as Exhibit PBF. He pointed out that Section 135, Section 1 of the Act 2022 only deals with non-compliance generally, but Section 73, Subsection 2 of the Act has provided a specific effect of non-compliance with its provisions. Relying on Crown's Townsend Organization for the National Institute of Policy and Strategic Studies, he urged the court to hold that substantial non-compliance has been established by the petitioners. Arguing per contra, Land Senior Counsel for the first respondent referred the court to Section 135(1) of the Electoral Act 2022 and submitted that the petitioner complained of non-utilization of prescribed forms, even though not proved, cannot without showing the effect on the election be a basis to avoid an election. He submitted that the attempt by the petitioners to exclude Section 73, Subsection 2 of the Act from the ambit of Section 135, Section 1 is a non-starter, because the non-compliance referred to in Section 135(1) is for the provisions of the Act, and no part of the Act was excluded by the section. He posited that for non-compliance with Section 73 of the Act to avoid an election, it must have substantial effect on the election, and the petitioners have neither proved such non-compliance nor shown that it has substantially affected the result of the presidential election. He urged the court to so hold. Petitioners had contended that since they are alleging that the first respondent failed to record in the prescribed form the quantity and particulars of the materials used in the election, they are alleging the negative, and as such, the burden is on the first respondent to establish that they have duly complied with the provisions of Section 73 sub 2 of the Electoral Act. They have relied on the decision of First Bank of Nigeria versus Adjudication Business Investment Limited and Royal United Nigeria for Sterling Bank. While it is true that the burden of proof is generally on the party that asserts the affirmative for an issue, and not on the party who asserts the negative. There is an exception to that general principle. Where a negative assertion forms an essential part of the party's case, the burden is on him to establish that fact. This position was clearly stated by the Supreme Court in the case of Buhari and Anil, where Toby JSC stated held thus, quote, a negative allegation must not be confounded with the mere traverse of an affirmative one. The true meaning of the rule is that where a given allegation, whether affirmative or negative, forms an essential part of a party's case, the proof of such allegation raised on him, close of court. Again, this court in Dashi and others versus Druven and others espoused this legal position when Ugo JCA held as follows. Quote, I am in no doubt that this argument of appellants about negative and positive assertion is misconceived. For while it is true that the burden of proof is generally on the person who